జడ్జ్ విశాఖపట్నం వారు సక్సెషన్ యాక్ట్, హిందూ సక్సెషన్ యాక్ట్ మీద లెక్చర్ ఇస్తారు. ఈ లోపల మనకి ఇటీవల కాలంలో సుప్రీంకోర్టు వెబ్సైట్లో దేశంలో ఉన్నటువంటి అన్ని భాషల్లో జడ్జిమెంట్స్ని వ్యూ చేసుకునేటువంటి, ఫ్రీ ఆఫ్ కాస్ట్ వ్యూ చేసుకునేటువంటి అవకాశం వచ్చింది. బహుశా ఇది కొత్తది కాబట్టి కొంతమందికి తెలిసి ఉంటుంది, కొంతమందికి తెలియకపోవచ్చు. సుప్రీంకోర్టు వెబ్సైట్ నోట్ చేసుకోండి మీరు మీ పేపర్స్లో. మిత్రులారా, ఇది సుప్రీంకోర్టు వెబ్సైట్. దీంట్లో ఈఎస్ఈఆర్ కాజు లిస్ట్ కింద ఈఎస్ఈఆర్ ఉంటుంది. ఇక్కడ కింద ఈఎస్ఈఆర్, దిస్ మీన్స్ ఎలక్ట్రానిక్ సుప్రీం కోర్ట్స్ రిపోర్ట్. సుప్రీంకోర్టు ఎస్టాబ్లిష్ అయిన 1952 నుంచి ఈ రోజు వరకు ఉన్నటువంటి జడ్జిమెంట్స్ దేశంలో ఉన్నటువంటి ప్రధాన భాషలు 13 భాషలు, జాతీయ భాషల్లో తర్జుమా చేసి పెట్టడం జరిగింది ఈ వెబ్సైట్లో. ఫ్రీ ఆఫ్ కాస్ట్, మీరు ఎటువంటి ఈ లా జర్నల్స్ ని సబ్స్క్రైబ్ చేయకుండానే ఫ్రీ ఆఫ్ కాస్ట్ తోటి చేయబడింది. జస్ట్ 1 minute. కరెంట్లీ అండర్ మెయింటెనెన్స్ అన్నారు. ఈ వెబ్సైట్లోకి వెళ్తే మనకు ఆప్షన్స్ వస్తాయి. మీరు జడ్జిమెంట్ డేట్ వైజ్గా సెట్ చేసుకోవచ్చు. అదేవిధంగా జడ్జిమెంట్ని జడ్జి నేమ్ పేరుతో సెట్ చేసుకోవచ్చు. అది సెట్ చేసుకున్న తర్వాత మనకి ఆప్షన్ వస్తుంది ఏ భాషలో మీకు జడ్జిమెంట్ కావాలి అనేది. కాబట్టి ఏ భాషలో, తెలుగు భాషలో కావాలన్నా జడ్జిమెంట్ చదువుకోవచ్చు. చాలా మంది ఇప్పుడు తెలుగు భాష మనకి జడ్జిమెంట్స్ రావట్లేదు, అన్ని లీగల్ జర్నల్స్ అన్ని ఇంగ్లీష్లోనే అనుకున్నారు. కానీ సుప్రీంకోర్టు ప్రయోగాత్మకంగా ఇచ్చినటువంటి వెసులుబాటు ఫలితంగా ఈరోజు దేశ భాషల్లో ప్రధానమైనటువంటి జాతీయ భాషలు అన్నీ కూడా తర్జుమా చేసి జడ్జిమెంట్స్ని ఈఎస్ఈఆర్లో కడతా ఉన్నారు. అట్లాగనే లేటెస్ట్ జడ్జిమెంట్స్ అక్కడే కింద ఎస్, లేటెస్ట్ జడ్జిమెంట్స్ పైన ఎస్. ఇది చూడండి, 15th May 2023 అంటే ఎప్పుడు? నిన్న. ఒకసారి అది ఓపెన్ చేయండి. 15th May 2023. దిస్ ఈస్ ద జడ్జిమెంట్ రెండెడ్ బై హానరబుల్ సుప్రీం కోర్ట్ ఆన్ విచ్ డేట్? 15th means yesterday. So day to day they are uploading the judgments simultaneously in the Supreme Court website. We can view the entire judgment and we can download it or we can print it directly. Now Supreme Court and all high courts న్యూట్రల్ సైటేషన్ అని ఒక వేదిక వచ్చింది. అన్ని వెబ్సైట్స్ లో, బహుశా హైకోర్టు, సుప్రీంకోర్టు అన్ని రాష్ట్రాల వెబ్సైట్ లో ఇది పెట్టడం జరిగింది. న్యూట్రల్ సైటేషన్ అంటే సుప్రీంకోర్టు రిపోర్ట్ అయితే ఎస్ఈఆర్, ఆంధ్రప్రదేశ్ హైకోర్టు రిపోర్ట్ అయితే ఏపీ హైకోర్టు రిపోర్ట్ ఏపీహెచ్సిఆర్, అట్లాగా ఉంటుంది. ఏపీ హైకోర్టు వెబ్సైట్ ఒకసారి ఓపెన్ చేయండి. ఏపీ హైకోర్టు వెబ్సైట్ apHC.gov.in, apHC. అది కాదు. ఎస్, దీంట్లో న్యూట్రల్ సైటేషన్ 1, 2, 3, 4th కాలం కింద. ఎస్, న్యూట్రల్ సైటేషన్. అట్లాగనే సైటేషన్ ఆర్డర్ డేట్ క్లిక్ చేయండి. ఆర్డర్ డేట్, ఈ ఆర్డర్ డేట్లో ఒక 20 days బ్యాక్, ఎనీ డేట్. అలాగే ఈ రోజు డేట్, నిన్న తెలియదు. ఎంటర్ క్యాప్చా 94918. సెర్చ్. యూ ప్లీజ్ సీ దిస్ జడ్జిమెంట్ డేట్స్ తో సహా ఓపెన్ చేయండి. So this is the judgment. So friends, on date wise, judge wise, if you know the citation wise, you can view the judgment clearly, and citation mode is also there. ఇది ఏపీ హైకోర్టు, అదేవిధంగా అన్ని సుప్రీంకోర్టు, ఆల్రెడీ హైకోర్టు, సుప్రీంకోర్టు జడ్జిమెంట్స్ అన్ని కూడా ఈ విధంగా న్యూట్రల్ సైటేషన్ అవటం జరిగింది. కోర్టు పేరు మీదనే ఉంటుంది. ఏఎల్టీ క్రిమినల్ లా జర్నల్, యూ నీడ్ నాట్ కోర్ట్. సుప్రీంకోర్టు వెబ్సైట్ నుంచి, హైకోర్టు వెబ్సైట్ నుంచి తీసుకున్నటువంటి న్యూట్రల్ సైటేషన్ ఈ విధంగా క్లియర్గా డేట్ వైజ్ అండ్ జడ్జి వైజ్ అండ్ ఆల్సో ఆర్డర్ డేట్ అన్నీ కూడా ఈ విధంగా వెబ్సైట్లో ఫ్రీగా లాంచ్ చేశారు. వీటితో పాటుగా భారతీయ భాషలు అన్నిట్లో తెలుగు, ఇంగ్లీషు, హిందీ ఇలా అన్ని భారతీయ భాషల్లో కూడా ఈరోజు సుప్రీంకోర్టు వెబ్సైట్స్ ఫ్రీగా యాక్సెసిబిలిటీ వస్తూ ఉంది. వీటితో పాటుగా అనేకమైనటువంటి ఆర్టికల్స్, అలాగనే ఫ్రీ లీగల్ జర్నల్స్ కొన్ని సైటేషన్ కూడా ఫ్రీగా యాక్సెసిబిలిటీ చేసుకునే విధంగా వస్తూ ఉంది. మీకు ఇప్పుడు సపోజ్ లైవ్ లా సార్ స్టార్ట్ చేయండి. సో ఈ విధంగా మనం మళ్ళా నెక్స్ట్ గ్యాప్ పీరియడ్లో చూద్దాం. ఈ సైటేషన్ మోడ్ ఎలా సెట్ చేసుకోవాలి, సుప్రీంకోర్టు వెబ్సైట్లో న్యూట్రల్ సైటేషన్ నుంచి భారతీయ భాషల్లో 13 భాషలు, జాతీయ భాషలు అన్నింటిలో కూడా జడ్జిమెంట్ని ఫ్రీగా యాక్సెస్ చేసుకొని డౌన్లోడ్ చేసుకోవచ్చు. మనకి అవకాశం తెలుగులో కూడా జడ్జిమెంట్ని డౌన్లోడ్ చేసుకునే అవకాశం సుప్రీంకోర్టు వెబ్సైట్లో ఉంది. ఈఎస్సిఆర్ ఎలక్ట్రానిక్ సుప్రీంకోర్టు రిపోర్ట్. మరలా మన స్పీకర్ గారు వచ్చి ఉన్నారు కాబట్టి నెక్స్ట్ సెషన్కి మళ్ళా బ్రేక్ పీరియడ్లో మీతో ఇంటరాక్ట్ అవుతాం. థ్యాంక్ యూ.
Good morning, all of you. The last day, final day of our program begins. Satya Rao Garu, the retired district judge, now he is the chairman tribunal for the land acquisition under the Land Acquisition Act. In fact, it is very, I should apologize to Satya Rao Garu because due to communication gap, we troubled him. Initially, we thought of, I postponed even printing of this program sheet for some time, but we could not contact him. Ultimately, we could contact him. The subject is succession, Hindu succession, partition law. In fact, I also proposed, I have been telling you from the beginning that we will have a open session where you will be able to clear all your doubts about the profession, not only the subjects, which is not the subject matter of the discussion in this program. In fact, I wanted to prepone Satya Rao Gari program to yesterday, but we don't have communication. And he has taken a lot of pains to travel and stayed at Vijayawada. And first we shall be thankful to him for the keen interest he has taken. Because of his love and affection towards the profession, he could do that. Mr. Shivasubbara also, he was the ex-bar council member and a senior advocate at Rajamandri. I have been troubling him since long time that he shall come for this program. And keeping in mind them, one Mr. Posan Venkateswarlu, Das from one Giri from Bemwaram, all these people I coordinate, but ultimately they said today is convenient and I could trace only 2 people. I am postponing that for time being, and next sessions after, by saving some time, I will try to accommodate you as promised to have interaction with all the senior advocates. Now I request Satya Rao Garu, retired district judge and now the heading the tribunal under the land acquisition, to come on to the dais. I request Sudha Madam, HOD of the Law Department, to offer a plant. I also request Chandrasekhar Reddy Garu to come on to the dais. Honorable Member, Bar Council of AP. I request Mr. Thakur, Deputy HO, Law Department, to offer a. Oh, sir, Mama. I also request Sri Sivasubbarao Garu to come on to the dais. Mr. Siddiq, Associate Professor of Law, will offer a plant to Sri Sivasubbarao Garu. Sri Sivasubbarao Garu can hold us for hours together, but we are having a short of time. Sivasubbarao Garu will address us for 2 minutes.
Good morning to all, and another hot day. Before I attend to the assignment given to me by our respectful chairman of the Bar Council for 1 minute, I should first of all profusely thank Mr. Ramararu, my good friend, to still remember me as member of former Bar Council and inviting me to such a wonderful program. In fact, for the last 15 years, I have been requesting all Bar Council members to organize these kind of meetings, at least at every district headquarters. So much so, advocate fraternity can interact with each other, discuss about not only archaic law principles, but more relevant and contemporaneous social problems and repeatedly being reenacted enactments and judgments. Well, anyway, I thank you, Ramararu, for giving me a great opportunity and conferring a privilege on me. I owe Ramararu another thanks also for one good reason. Because he didn't assign any particular topic to me to talk about. Has left an open field for me, but at the same time, he has restricted my movements to 1 minute. As you know, as advocates, particularly as we grow in this field for a long period, like me, we enjoy hearing ourselves, our own voice, hoping ultimately to convince a judge to have faith in you and believe in what you say to be correct. Well, my friends, I don't like to say anything more. As I understand, this meeting is meant for not only refreshing the knowledge of senior advocates, basically I should take it like that, but I is expected to tell the youngsters who have entered the profession, not only, it should not only be about subjects. I have seen just now the different subjects that would be spoken to by honorable judges who are naturally well versed in law, changes and amendments in the law. I tell you only one thing. As students, as lawyers, we are all students. That's what everybody, everything, every meeting here. Every case is an examination for us, irrespective of standing before the bar. and you write the examination not for yourself, but as a proxy for your client. But everything depends upon the result. Pass or fail of your own client depends on your performance when you write an examination paper. The judges are the persons who value your examination papers. They either pass you or fail you. But one peculiarity in this particular examination is sometimes you gain some good marks on one or two topics, either finding on fact or law, and sometimes you fail ultimately because one fact or one particular question of law is against you. When I say that this is an examination you take in every case, I meant that you have necessarily to put in hard work day in and day out, just as you have prepared yourself to pass your graduation, your intermediate, graduation, and then post-graduations or whatever it is. When every case is taken in an examination very seriously, you will keep yourself continuously reading and then applying your knowledge to attend to a particular practical problem. So my friends, I tell you, please always bear in mind that every day you are facing an examination. And also bear in mind, you come across different kinds of valuers, whom we call judges. The valuation depends, the judges here, X are present, Honorable Justice Shivashankar Garu and others are there. They have, every judge has his own peculiar notions about law or the societal changes and all. Sometimes we call them idiosyncrasies. They have also developed notions about the particular manner in which a matter is being presented by an individual concerned. So there, the other day I heard Justice Mahandas Sitaramurthy Garu telling you, while talking about Evidence Act or CPC, how to conduct yourself, how to dress, how to button your coat, and all these things were taught to you by Justice Sitaramurthy Garu. There is no reason to repeat them. But mind you, you also judge your judge before you open your mouth or any case. Don't mistake me, judges. It is highly essential. Knowing about it, you have to conduct your case. Ultimately, but both the judge and the advocate have to necessarily work in tandem, because our ultimate goal in this system, we work as a team to ultimately do justice to a litigant. We are surviving because of the litigant public. Either you are paid fee or the judges are paid salaries. It is only expecting that both of you put together jointly would do justice to a litigant. How you work it out depends on the individual mental makeup of all concerned. But suffice it to say, friends, particularly youngsters, I tell you, you have three commitments. Your first commitment to the court. You have to be very fair and honest to the court. You must place before the court all legal propositions, whether it supports your case or not, fairly, and then show your prowess to how to overcome a difficult legal proposition in a given set of facts. So always remember, you have a commitment to court. The next commitment is to client. You should be very, very honest to your client. You must tell him the moment he comes if he has a case or no case, or if there is a possibility for mediation and settlement. Be very frank and honest to him. Don't think of making and milking him, making money and milking him simply because he has approached you. You must guide him properly, just as you latter point of time guide the honorable judge. The third commitment is to community, not to yourself. You are living because you are able to survive, you are able to attend to the needs of your family members, all because of the community at large looks at you. It seeks your help, aid and guidance. The manner of application of law, conducting oneself properly in society. That is the third commitment you have, one after the other. Lastly, only the commitment is to, not again to yourself, all said and done, it is to your family. You have to provide them residence, comforts, and education for your children and all that. There again, to attend to that commitment, to discharge that commitment, you have to put in very hard work. And all these commitments, everything depends upon your fairness and honesty and integrity. Unless you maintain that honesty, ethical values, follow that in your daily life, routine life, and maintain that integrity. Don't ever think that somebody, sometimes my associate friends younger to me, or somebody was expecting me to talk about tricks of the trade. Let me tell you, there are no tricks. Absolutely no tricks in this. There's only one commitment to court, nothing more than that. If you can bear that in your mind and make it a principle in your social life, your professional life, your daily life, you will be recognized as an advocate. The question before you is whether you wanted to be known as a notorious advocate or a famous advocate or a popular advocate. Everything depends upon you. Left to me, I would say I should strive to become a popular advocate because of my ethical values, my integrity, my fairness to the court and all that. I don't like to be noted as a notorious advocate. A notorious is one who makes money by taking advantage of his situational placement in society. So my friends, with this short recommendation to you and appeal to you, I thank you very much for being very patient to hear me. I thank Ramararu. Sorry, I have exceeded because after COVID and during COVID, we didn't have much opportunity to open our mouth. He has given me a chance. Thank you very much, kind of.
Thank you, sir. I did not put 1 minute. He himself put 1 minute restriction, and that minute is renewed from time to time. I call upon Sacharao Garu to deliver on the subject that Hindu succession and partition law.
I'm more comfortable as a backbencher and student than sitting on the dais, all of you staring at questions on the desk. I seek permission of the chairman to go down and sit down.
Esteemed dignitaries on the dais, respected chairman, Bar Council of the State of Andhra Pradesh, respected member Chandrasekhar Reddy Garu, Bar Council of the State of Andhra Pradesh, renowned advocate and veritable advocate Sri Sivasubbara Garu, Honorable Justice Shivashankar Garu, respected advocates. Good morning, everybody. I know it is a difficult task to interact with the advocates who have been practicing in mafsal courts and trial courts. For the advocates in trial courts are the coal face of the Indian judiciary. The coal face, why I used the word coal face means, it is those advocates who draft, who teach, who try to appreciate, analyze the things to the judges. You have seen for the last 70 years, there are several clashing decisions by equal benches of High Court, by equal benches of Apex Court regarding interpretation of Section 6 of Hindu Succession Act and deciding the partition suits. Why this conundrum? Where the fault line lies? These are the topics for our consideration. First of all, I want to confess that I am completely dry inside. It is neither a lecture nor a discourse. It is an interaction, just sharing information and trying to receive some information from you. Before entering into the discussion, I would like to say I don't want to tell something which amounts to mono action unless you participate in this interaction. Before going into the subject, I want to know what is meant by Mitakshara and what is meant by ancestral property. May I request some of you to say what is meant by ancestral property? Then what is meant by Mitakshara? What is the exact definition of Mitakshara? Okay, well. You know, we are governed by two laws. One is personal law and the other is territorial law. Personal law is applicable to people of a particular religion, and thus people of different religion in our country are being governed by their respective personal laws. Take for example, in the case of interstate succession, suppose a person dies, it is being governed by Hindu Succession Act. The long cause title of Hindu Succession Act is interstate succession, not testate succession. Again, the section is classified into testate section and interstate section. The only section in Hindu Succession Act that deals with testate section is section 30 of Hindu Succession Act. So also, in case of Muslims, they are being governed by Muslim law of inheritance, and in case of Christians, Indian Succession Act. After the adventing of section 4, 5 and section 6 of Hindu Succession Act in 1956, the law of succession has undergone a tremendous change. I would like to shed a light on the Hindu law in the teeth of sections 4, 5 and 6 of Hindu Succession Act. Section 4 has the overriding effect that the Hindu law in force prior to the Amendment Act 1956 came into force shall cease to have in existence with regard to any of the matters for which a provision is made in the Hindu Succession Act 1956 or amended Succession Act 2005. The codified law rightly omitted the antediluvian theories of uncodified law, but there are some aspects which are being considered as fulcrum and pivotal to decide the crucial aspects while dealing with the suits for partition. Unless you have a perception in right perspective about those crucial aspects, it is not easy to interpret section 6 of Hindu Succession Act or to decide the partition suits or to draft the plaints or to take defense in the partition suits. The concepts are what is meant by Mitakshara, what is meant by ancestral property, what is meant by co-partitionary, what is meant by joint family property, and who is the Hindu, what is meant by Hindu religion, whether Hindu as defined in section 2 of Hindu Section Act and Hindu Marriage Act is a comprehensive definition of Hindu, and whether that definition is in terms of Hindu religion. These are the crucial aspects we must know. India is not the exclusive term for Hindus. Some are Hindus, other are Muslims, Christians, and Persians, and so on. The word Hindu is elastic and a plastic term. For the first time, the Honorable Supreme Court had the occasion in 1966 to deal with what is meant by Hindu religion, because Hindu religion is not defined anywhere, though the word Hindu is defined in section 2 of Hindu Section Act. In that case, Yajna Purushadji and others versus Moldas, Brududas, Vaishya and another reported in AR 1966 Supreme Court, page 1119. The case is that one Swaminarayana sect filed a suit in the Municipal Court at Mumbai on the ground that Bombay Arjan Temple Entry Act 1947 is not applicable, and scheduled caste people are not supposed to enter into that Swaminarayana sect shrine because it is not a temple and they are not Hindus. They do not belong to Hindu religion. They pray and they worship their Guru as God, and they do not believe in the God. So that's why, since it is not a temple, the Hindu Temple Act 1947 facilitating for entry of scheduled caste people into temples is not applicable. The trial court decreed the suit. Then the High Court said, no, as per section 2, they have been practicing all the rites of Hindu religion, and thus the Swaminarayana sect cannot be considered as something else than Hindu religion. Then it went to Supreme Court. There the Supreme Court had the occasion to make a threadbare discussion what is meant by Hindu and Hindu religion. The word Hindu is derived from the word Sindhu, a river which is known as Indus flowing from Punjab. The people, the great Aryan people, migrated from Central Asia through the mountains, entered into India and settled first on the drained parts of the river Indus, that is Sindhu river. The Persians called them as Hindus because they called the word Sindhu as Hindu, and thereafter the Westerns called them as Hindus. Even according to our former president Radhakrishna Garu, the word Hindu has a territorial significance, rather a cradle significance, and it is a residence in a well-defined geographical area. Tupiki Himalayalu, Dashiniki Kashi Rameswaram, Ila. This is not a religion, because aboriginal tribes of civilized people, savages, cultured Dravidians and Vedic Aryans, all are Hindus because they are the sons of the same soil. Then the Supreme Court again said, it is difficult, though not impossible, to define the Hindu religion. For that matter, even to adequately define it, Hindu religion doesn't claim any prophet. It doesn't worship any one god. It doesn't support any one dogma. It doesn't believe in any one philosophical concept. And it doesn't follow any one set of writers. It is a way of life. Ultimately, the Supreme Court decided it as a way of life. That is the origin of the genesis of the word Hindu and Hindu religion. Then there is again a problem, whether the scheduled tribes come under the definition of Hindu. Again, section 2 says that the scheduled tribes, unless the central government gives a notification under clause 25 of article 366, if I remember correct, they are not Hindus. Then why the family courts have been interpreting and entertaining the diverse petitions filed by Naiks, Banjaras, scheduled tribes, denotified tribes, knowingly or unknowingly? There is a case law in that regard also. I will come to it later. Next, what are the main sources of Hindu law to interpret Hindu Succession Act? Vedas, Smritis, and customs. Vedas do not deal with legal jurisprudence. Vedas consist of two parts, Shruti and Smriti. Shruti doesn't contain anything which is a positive lawyer's law, whereas Smriti, considered as Dharmasastras, is the foundation of Hindu jurisprudence. The persons who throw light on Smritis are known as Smritikars. Manusmriti, Yajnavalkya Smriti, Jimutavahana Smriti, Narada Smriti, so on and so forth. The result is that the two schools sprang from that concept. One is Mitakshara school of law and the other is Dayabhaga school of law. Now I will tell you what do you mean by Mitakshara. You click Google. Mitakshara means a brief digest or compendium on the code of Smriti interpreted by Yajnavalkya. Dayabhaga means a brief compendium or a digest on the code of Smriti interpreted by Jimutavahana. The main difference between these two schools is the spiritual efficacy. In Mitakshara, the community of blood is preferred to community in offering religious oblations. Whereas in Dayabhaga, it is the spiritual efficacy that plays the pivotal role and not the kinship or consanguineness or blood relationship. In Mitakshara, the son gets a share by birth, whereas in Dayabhaga, the son gets a share after the death of father. So Dayabhaga is applicable to West Bengal, whereas Mitakshara has the sovereign sway over the entire India except the West Bengal. This is in brief what do you mean by Mitakshara and what do you mean by Dayabhaga. Next, what do you mean by ancestral property, co-portionary and joint family? Ancestral property is a species of co-portionary. If a son inherits a property from a father, the property in the hands of a son is known as ancestral property in terms of his children, great-grandchildren and great-grandchildren. And I am, assume for a moment, I got some property in the joint family from my father. I am the last male holder. And I am known as prepositus because I am holding the co-portionary property. And this property in terms of me is co-portionary, in terms of my son is ancestral property, in terms of my grandson it is ancestral property, in terms of my great-grandson it is ancestral property. That's why ancestral property is known as species of co-portionary. If you go through Mains, if you go through Milla, it will be there. It is very much there. Next, the joint family property. Joint family property consists of all the descendants from a common ancestor, lineal descendants from a common ancestor. including their wives and unmarried daughters. It is known as a corporate body having both male and female persons as members in it. It need not contain any property as a condition precedent, and a joint family without having any property nevertheless is a joint family. Co-portionary is a narrower concept and a narrower body when compared to joint family, and it is a branch of corporate body, that is a branch of joint family. In this case, only the lineal descendants by birth will have share in the property, and their right is restricted up to 3 generations from the last holder, that is from the prepositus. That means, take for example, I am the prepositus, I got some share from my ancestors. My son, my grandson, and my great-grandson, 3 generations excluding me, 4 generations including me, are known as co-portioners. We have right by birth in the property. Now, after the adventing of the Act 2005, the daughters were also being called as co-portioners. Now, the incidence of co-portionary, there is a debate whether we have to redefine the incidence of co-portionary, since the daughter is also elevated to the status of a co-portioner, because the co-portionary, the first incident is that he has the right by birth, and this right is limited to 3 generations from the last holder. Whereas in case of a daughter, when we see subsection 2 of the amended Act section 6, the daughter can dispose of this property by a testamentary disposition, whereas a son cannot do it, because I inherited the property, ancestral property, from my forefathers. I can dispose of my share, but I can't dispose of my son's share. Whereas a daughter, she can dispose of the entire share. She need not leave it to her son or daughter. She need not leave it to her grandson or granddaughter. She need not leave it to her great-grandson and great-granddaughter. For that matter, the son or daughter, the grandson or daughter, the great-grandson or great-granddaughter of a daughter cannot have any say in the property inherited by her as a co-portioner, whereas it is not the case with the son. That is the reason why we have to redefine the incidence of co-portionary. And there are 4 schools which stem from Mithakshara School of Law. Benares School, which is applicable to North India. Midla School, which is applicable to Patna. Madras School, which is applicable to Dravidian School, which is applicable to the Telugu states and Madras and southern states, with an exception to section 7 of Hindu Section Act. And yes, Maharashtra, one is Bombay, what we call Maharashtra School, Mithila School, Patna, and Dravid School, what we call Madras School, it is applicable to South India, and Benares School, it is applicable to entire North India. But Vineet Sharma and Rakesh Sharma, all these were discussed. You go through it. The fundamental concept is unobstructed heritage. I will come to it later, right, subject to restriction of time. Later, these schools were done away because after the adventing of Hindu Section Act 1956 came into existence, they have become vesties and they do not hold the field anymore. But in the State Reorganization Act 1956, Madhya Pradesh was formed. There was a trouble. Some parts of Madhya Pradesh belong to North India. Some parts of Madhya Pradesh, Madhya Bharat, belong to Mumbai, Maharashtra. which school is applicable? Whether Maharashtra school or Bombay school or Banaras school. There was a conundrum for some time, and later, due to the decisions pronounced by Madhya Pradesh High Court, that was cleared. This is in precise how the concept of Mitakshara came into existence now. The Pulavati case, Prakash and others versus Pulavati and others. Pulavati filed a suit for partition, claiming a share in the properties of her father. The defendant, Prakash, resisted the claim of Pulavati on the ground. It was filed on the file of Subcourt, Senior Civil Judge Court, Belgaum. Resisted the claim of sister on the ground that you are entitled for a share in the self-acquired property of father, but you are not entitled for a share in the ancestral property or co-portionary property of the father. The trial court accepted the contention of the defendant and allotted shares in the self-acquired property of the father and declined to give any share in the ancestral property of the father to Pulavati. Pulavati got it amended after the Act 2005 came into force and her father died in the year 1988. The High Court allowed the petition, suit, and now it has gone to the Supreme Court. Prakash filed appeal, and there it was decided that she must be a living daughter of living co-partner. I am telling in brief. So, to claim a share, the daughter must prove one thing, that her father was alive on 9/9/2005 when the Act came into effect. Since she failed to establish that her father was alive on that day, she is not entitled for any share. That is the another question is, they interpreted the question of notional partition, and since it is created by law, it need not be registered, and there was a severance of joint status, disruption of joint family by virtue of notional partition. The concept of notional partition, though fictitious, it is a creature of law, and there is a partition, and since it is a partition created by law, it need not be compulsorily registered. These concepts were thrown for discussion in the judgment. Then Danamma case came. This happened in 2015. It was in the year 2018. Danamma case was decided in the year 2018 in the month of February. There they interpreted the law and they relied on two citations. Anar Devi versus Parmeswari Devi and Gandur Kotiswaramma, which was decided in 2011. When you see the judgment, when you read the full text of the judgment, they didn't differ with Pulavati case anywhere. They extracted all the paragraphs right from 16 to 23 in the judgment in Danamma case, but they surprisingly they gave asymmetrical judgment, stating that she did not be a living daughter of a living co-partner. Later, the registry put the clashing decisions of the equal bench of the apex court before the three judges bench. Then it went to the notice of the Supreme Court. A three-judge bench headed by Honorable Justice Misra decided the conundrum. There the points came into discussion whether the act is retrospective or retroactive or prospective as stated in Pulavati case, or retrospective as stated in Danamma case, or both not, and whether it is retroactive. You know, prospective, retrospective. But retroactive means it creates new obligations by taking the law to backwards, that is to 1956, and creating a new right. Previously, daughter has no right in the property, co-portionary. Now, a new right was created. Thereafter, she can enforce her right by creating new obligation on the other co-portioners. That's why they stated that the act is retroactive rather retrospective. The second one is there cannot be any notional partition. The concept of national partition is introduced to ascertain the share of or interest of the deceased co-portioner. It doesn't mean that it has the effect of disturbing the joint status or disrupting the joint family. What was laid down in Palwati case is bad, and they stated that the joint family continues irrespective of the death of a co-portioner, and even after interpreting that by virtue of national partition, his share can be reckoned or ascertained. And another one is, you cannot take the plea of oral partition. It can be taken only in exceptional cases. Oral partition supported by a contemporaneous document or a public document, and only in exceptional cases the oral partition must be accepted, provided the public document is as good as a decree passed by a court for partition. That is the essence of Vinit Sharma case. There they stated that the co-portionary means by virtue of unobstructed heritage, the right accrues by birth. A person can claim right by birth. That is the gist of the suggestion. Next, in Gonduri Kotiswarama, what happened is, two daughters of Chakri Venkataswamy from Ongole filed a suit for partition. Chakri Yanadri's son filed a suit for partition. Chakri Venkataswamy father died in the year 2001, and the suit was decreed, preliminarily decreed. In the meanwhile, a commissioner was appointed after filing a final decree petition, and at that time the Act 2005 came into force. The daughters Gonduri Kotiswarama and another sister filed a petition for amendment of preliminary decree. The trial court rightly allowed the preliminary decree because the notion is that preliminary decree cannot be amended unless appeal is preferred under section 97 of CPC. A preliminary decree which passed by a court cannot be varied, amended, changed or modified unless it is challenged by way of appeal under section 97. But the trial court allowed it, and it matter went to High Court. The High Court said no, you cannot amend the preliminary decree because there is a bar under section 97 of CPC. Then the matter went to Supreme Court. The Supreme Court, it was discussed in the Supreme Court, there is no such bar. The trial court, due to intervening circumstances, has power. It will never become funcus officio. It can vary, change or amend the preliminary decree, and what the trial court did in Ongole is right. So, till then we are under the impression that once there may be any final decrees, but there must be only one preliminary decree. Even prior to Gandoor Koteswaramma, way back in the 2006 Sai Reddy case also, the Supreme Court held that preliminary decree can be amended even by the court which passed it, irrespective of the fact that appeal is preferred or not. Next, Tulsamma's case. In Tulsamma case, Tulsamma versus Shasha Reddy, Tulsamma is the wife of brother of Shasha Reddy, which has joint family, who is a joint family member, and the joint family has joint property. Tulsamma's husband died before 1937 Act came into force. Tulsamma filed a suit for maintenance in trial court. While the suit was pending trial, Shasha Reddy, the brother-in-law, and Tulsamma entered into compromise. By virtue of the said compromise, Shasha Reddy executed a document conferring life interest on Tulsamma to enjoy the said property during her lifetime. Thereafter, Tulsamma alienated some of the properties. Then Shasha Reddy filed a suit for declaration that such alienation is null and void and for cancellation of those documents. There, the matter went up to apex court. The trial court rightly dismissed the suit. The High Court reversed the judgment. The matter went to Supreme Court. In the Supreme Court, it was argued, since the husband of Tulsamma died before 1937, she has no right, even for limited interest, she has no right. Because her husband died, even the Act 1937 came into force. Then the Supreme Court said, even in Shastric law, there is a responsibility on the manager of the joint family to maintain widows and daughters, unmarried daughters and widowed daughters. So she has a right of maintenance. That right is, though not a right in property, it is a right against property. By that right against property, she can ask for a charge on the property, and that's why it makes no difference whether her husband died before 1937 or after 1937. And there they discussed what is the distinction between limited estate and restricted estate. The advocate for Shasha Reddy took a plea that since it is a court decree, it falls under subsection 2 of section 14, because in case of a court decree where there is a restriction to enjoy the property by imposing fetters, she cannot say that the property becomes her absolute property. The restricted estate enlarges into absolute estate because it is not a limited estate. There the Supreme Court again said, since she has a pre-existing right of maintenance even as per Shastric law, though not under Act 1937 or under Act 1956, she has such a right, and the Karta of the joint family has an obligation to maintain widow and unmarried daughters, that she got right against property, though not right in property, and such right enlarges into absolute right. That limited right enlarges into absolute right. So you have to read it under section 1, subsection 1 of section 14, rather under subsection 2 of section 14. That is the case law. Bharat Mata case next. What about the status of illegitimate son? In Bharat Mata case, Periya Mariammal filed a suit claiming property of her deceased brother, stating that he died unmarried and she is the legal heir for his property. The other side, Rangammal defended the suit, stating that she is the wife of Muthu Reddyar. They have live-in relationship, and she had 2 children to Muthu Reddyar, and that's why she is entitled for the property of Muthu Reddyar. Then Mariammal took a plea that Rangammal was the wife of one Alagara Swami, and their marriage was not dissolved, and it is still subsisting. The trial court rightly dismissed the suit. The trial court allowed the suit, whereas it went to High Court. High Court dismissed. High Court allowed the appeal and set aside the order passed by the trial court, stating that Rangammal has got a share. Then the matter went to Supreme Court. There the Supreme Court said that, considering for argument's sake Rangammal has live-in relationship with Muthu Reddyar, she cannot be treated as a wife because under section 16 of Hindu Marriage Act, a illegitimate son means a son who is born out of void or voidable marriage. Here in this case, there is no marriage at all. They have live-in relationship. So the children born to Rangammal through Muthu Reddyar are not entitled for any share. And again, there is Ravana Siddhappa case in 2011. Ravana Siddhappa case, they said that illegitimate children are entitled for ancestral property also. As can be seen from section 16, the legitimate or illegitimate children are entitled for share of parents. It is silent whether they are entitled for the share of the ancestors. While discussing the case law, the apex court, while deciding the case of Ravana Siddhappa, said that no, the amendment came in 1976 with a lofty idea that to treat both the legitimate and illegitimate children alike, with an exception that illegitimate children cannot demand for partition during the lifetime of father, but they are entitled, they are equal to all the rights, they can claim all the rights which the legitimate children can claim. That is the idea behind amending the Act, section 16 of Hindu Marriage Act in 1976, and finding that there is a conflicting judgment by equal bench, they referred the matter to the apex court. But so far, no judgment came. It was referred in the year 2011. But the opinion, there is a common opinion, and there is one finding which is common in both the judgments is marriage, there must be a marriage, void or voidable marriage. You cannot claim a status of wife under the guise that there is a live-in relationship. This was discussed in Nagapatla Venkatachalam versus Nagapatla Saroja and others by our division bench headed by Honorable Justice Sitaramurthy Garu. There the son claimed the job of the father under compassionate grounds. His father died and his mother, a Muslim, was married to his father and he was born to her. But he couldn't prove it. He could adduce evidence that his mother had live-in relationship with the deceased father. The division bench dismissed the petition, stating that unless there is a marriage, you cannot be termed as illegitimate child. To claim illegitimate child, you must prove that there is a marriage, whether it is void or voidable marriage. Section 16 is delinked from Section 11. Though Section 11 declares a marriage as a nullity, even then a son born in case of void marriage can claim a right as illegitimate child, and for that the condition precedent is that there must be some form of marriage, whether it is void or voidable. You cannot claim a right by way of live-in relationship. So it is to be discussed whether the children born during live-in relationship are entitled for any legitimate share are entitled for any share on par with legitimate children. That is left unanswered. Next concept is, Maneka Gandhi cases versus Indira Gandhi. There, they took a plea that deceased Sanjay Gandhi was a Parsi. The trial court, letters of administration, a petition was filed in the trial court for issuance of letter of administration regarding a company shares. Maneka Gandhi filed that petition. The trial court allowed the petition by dividing 3 equal shares. One is for Maneka Gandhi being the wife of Sanjay Gandhi, and another is for Varun Gandhi being the son of Sanjay Gandhi, and another is for Indira Gandhi being the mother of Sanjay Gandhi. The matter went to High Court. There, the High Court said that since there is no plea that Rajiv Gandhi is a Parsi, he is not a Hindu, the mother is entitled for a share along with the wife and son. Of course, Indira Gandhi didn't claim that share and she asked the court to give that share to Varun Gandhi. But the advocate there canvassed that by virtue of section 21 of Special Marriage Act, because a Hindu married a Parsi and their marriage is a Special Marriage Act, section 19, Sanjay Gandhi ceases to be a member of Hindu family under section 19 of Special Marriage Act. And by virtue of sections 20 and 21, he cannot claim the share in the Hindu joint family. There, the court said that you have not pleaded those aspects. For that matter, you have not pleaded that Sanjay Gandhi is a Parsi and not a Hindu. Why I am telling is that section 19, section 5 of Hindu Section Act. Section 5 of Hindu Section Act says that this Section Act is not applicable in contrast to the provisions of section 19 of Hindu marriage, the Special Marriage Act. So, suppose if it is inter-religious marriage under Special Marriage Act, you cannot claim any, though you are a Hindu, you will be ceased to be a member of Hindu family and you cannot claim any share in the ancestral property. This is the law. And another thing is, while dealing with suit for partitions, mother bequeathed some property to a daughter. She had 4 children. In the meanwhile, the property was acquired under Land Acquisition Act. The mother filed a claim statement and thereafter she died. Then the sons claimed share along with the daughter in that property. What do you say? Whether the sons are entitled for share? Yes, because by virtue of adoption under Indian Section Act, when will is you bequeathed some property under a bill, the nature of property is changed, or the property is lost, or the property is acquired, the will is not applicable. So all are entitled. This is decided in Kerala Koteswara and others versus Land Acquisition Officer Gunturu and others, 2010 Part 1 ALT 600 Division Bench. Justice Gopal Reddy, Honorable Justice Gopal Reddy decided the matter. So thank you very much for giving me opportunity. I thank the Chairman, Bar Council for giving me this opportunity.
Thank you, sir. I request Venkat Ram Reddy and Ram Reddy garu to come on to the dais to felicitate Sajara. Thank you, sir. Now, the formal session today, session number 10. Various aspects relating to specific performance of the contract with a special reference to the provisions in the light of recent amendments to Specific Relief Act 1963. I request Justice Sri Shiv Shankar Garu to come on to the dais. I request Ram Reddy Garu also to come on to the dais. Member Bar Council of India. I request Sudha Madam to offer a floor plan to the Honorable Sri Justice Shiv Shankar Garu. Justice Shiv Shankar Garu, maybe most of you know, he is a walking encyclopedia. Wherever he sits, wherever he is present, whatever the subject, this is readily like on the button, you will get back the results. I don't want to waste your valuable time. I request Justice Shiv Shankar Garu to present on the specific relief, specific performance of the contract, the special reference to the provisions of the light of recent amendments to Specific Relief Act 1963.
అక్కడ తీసి హలో, am I audible? సభ ఇది రావట్లే. సరిపోయిందా చూసుకో.
శుభోదయం. అందరూ చాలా సైలెంట్ గా ఉన్నారు. ఏమీ ఉప్పెన రాదు అంటే నాకు నిజంగా ఏమీ చేత కాదు పెద్దగా. ఏదో తెలిసింది, నా ప్రయత్నం చిరు ప్రయత్నం నేను చేస్తాను. మీరు నా మీద పెట్టుకున్న హోప్ కొంతైనా ఫుల్ఫిల్ చేయడానికి నా ప్రయత్నం నేను చేస్తాను. స్పెసిఫిక్ రిలీఫ్ అనేది ఇట్ ఈస్ గవర్నడ్ బై స్పెసిఫిక్ రిలీఫ్ యాక్ట్ 1963 యాజ్ అమెండెడ్ ఇన్ 2018. మీ అందరికీ తెలిసిందే. అందులో 3 parts ఉంటాయి, 8 chapters ఉంటాయి, 44 సెక్షన్స్ ఉంటాయి. 43-44 సెక్షన్స్ రిపీల్స్కి సంబంధించి 1974 అమెండ్మెంట్ తర్వాత అవి రెండు లేవు. సో 1 to 42 are the relevant sections. Out of 1 to 42 of the Specific Relief Act, we are mainly concerned with the definitions section, and sections 9 to 20 are highly important among those. And the amendments mainly relate to those other than section 6. Section 6 అనేది మీకు అందరికీ తెలుసు. Restoration of position, because no one can be evicted except through due process of law అనేది. The only amendment in section 6 by the 2018 is not only by the person victim or affected, but any person on his behalf. It is relaxing the scope of locus standi of the person entitled to claim the relief. మీకు బేసిక్ ప్రిన్సిపల్ క్రిమినల్లోకి వస్తే అంతులే కేసు. కాన్స్టిట్యూషనల్ బెంచ్ 1984 సుప్రీంకోర్టు అంటారు, there are no conventional protocols to maintain a criminal complaint or to set the criminal law in motion. Any person can even file a private complaint if he has some iota of common interest even able to show. For example, a trust is there. A trust misappropriates the property. No trustee or a member of its beneficiaries will not claim, but a public can maintain, questioning the modus operandi of the trust. That is the relaxing the conventional protocol of locus standi. మీకు దీనికి బేసిక్గా పబ్లిక్ న్యూసెన్స్, సూట్స్ ఫర్ పబ్లిక్ న్యూసెన్స్. పబ్లిక్ న్యూసెన్స్ అంటే మీ అందరి దృష్టి 133 ఐపీసీబీకి, సిఆర్పిసిబికి వెళ్ళచ్చు. ఎగ్జిక్యూటివ్ పవర్స్ టు అబేట్ పబ్లిక్ న్యూసెన్స్ బై ది కలెక్టర్ ఆర్ డిస్ట్రిక్ట్ మ్యాజిస్ట్రేట్ ఆర్ సబ్ డివిజనల్ మ్యాజిస్ట్రేట్ ఆర్ మండల్ మ్యాజిస్ట్రేట్ అనేది. అదే కాకుండా పబ్లిక్ న్యూసెన్స్ కింద ఎనీ సూట్ కెన్ బి మెయింటైన్డ్. దెర్ ఇస్ నో క్వశ్చన్ ఆఫ్ లిమిటేషన్, దెర్ ఇస్ నో క్వశ్చన్ ఆఫ్ క్లైమింగ్ adverse position, because it is a recurring and continuous cause of action. In case of recurring and continuous cause of action, every day, every minute, every second cause of action accrues and reoccurs. So there is no question of commencement of period of limitation. That is abatement of public nuisance concerned. For example, on the roadside, in the middle of the road, there is a temple constructed, or a mosque constructed, or a church constructed. Any public can maintain a suit for removal of the same, because legal position says right from 1933 Patna, including in 1967 Supreme Court, where a temple was asked to be removed, a Gandhi statue was asked to be removed even. It is established of more than 50 years, because It is intervenes with the public access of every inch and corner entitled by every person. This is the scope of law. And the landmark judgment on that is 1990 Supreme Court 396, Kalyan Singh versus Chotu. సురేష్ కుమార్ కూడా ఒక దాంట్లో పంచాయతీ సర్పంచెస్కి వాళ్ళకి రిలీజ్ చేయవలసిన షేర్స్ రిలీజ్ చేయటం లేదని చెప్పి గవర్నమెంట్ వన్ ఆఫ్ ది మెంబర్స్ అమాంగ్ ది సర్పంచెస్ వేస్తే లోకల్ స్టాండ్ లేదని రిట్ పిటిషన్లో ఆర్గ్యూ చేస్తే దాంట్లో ఆ జడ్జిమెంట్ రిఫర్ చేస్తే నేను తీర్పు చెప్పినట్టు గుర్తు. అదే సో కళ్యాణ్ సింగ్ వర్సెస్ చోటు 1990 Supreme Court 396 3-judge bench. There anybody having even a little interest, an iota of interest can maintain. So here, coming to the specific relief act, these are all personal reliefs. Reliefs are personal. In this regard, the reliefs may be either remedial or protective. Please make a note. The reliefs may be either remedial or protective. Earlier I have stated several sections, but not section 42. You may have a surprise. How section 42 is applicable? It is when relating to the injunctions, native injunctions. It is also relating to the performance of a contract. Thereby, I am drawing your special attention also to section 42. There it is positive or negative reliefs. Earlier I stated remedial or protective, and the other is positive or negative. For more clarity, I may be permitted to read section 42 of this specific relief act. Injunction to perform negative agreement. So it is not a right in rem. Injunction to protect my property is a right in rem against all except the true owner. Here, injunction to perform negative agreement in right in personam, notwithstanding anything contained in clause E of section 41, where a contract comprises an affirmative agreement to do a certain act coupled with a negative agreement. One is affirmative clause and the other is a negative clause. Express or implied, not to do a certain act. The circumstances that the court is unable to compel specific performance. Thereby, I have drawn attention to the wording of section 42. It is also part of specific performance, not mere injunction alone. Specific performance of the alternative agreement, affirmative agreement, shall not preclude it from granting an injunction to perform the negative agreement. So, injunction is to perform the negative agreement. Section 42 scroll చేయండి. 41 E తర్వాత 42. Provided that plaintiff has not failed to perform the contract so far as it is binding on him. So this is the wording to say section 42 is also connected to injunction in respect of the negative agreement for performance of an agreement. Now coming back to definitions in the specific relief act. Section 2. In this act, unless the context otherwise requires, obligation, you know obligation under Contract Act. There are two types of obligations. Legally enforceable obligation and the other is legally unenforceable, even a moral obligation. From this, if you read section 25 of the Indian Contract Act, only for academic purpose I am driving you to the Contract Act provisions, because even for specific relief act provisions we have to read Contract Act provisions. Agreement without consideration void unless it is in writing and registered, or is a promise to compensate for something done, or is a promise to pay a debt barred by limitation law. So even the debt is borrowed by limitation law. The obligation is not legally enforceable. It can be made legally enforceable by acknowledgement of a debt. It is not a mere acknowledgement as contemplated by section 18 and 19 of the Indian Limitation Act 1963. It is a specific acknowledgement of the debt already time barred. Hereby I agree to pay. There is no legal obligation. The other person cannot enforce because it is barred by time. However, there is a moral obligation. To fulfill that moral obligation, if he acknowledges the time barred debt agreeing to pay, it revives the life of limitation. So, it is an exception to section 27 of the Indian Limitation Act. Section 27 of the Indian Limitation Act. Prescription. Prescriptive right. So, this is the importance of obligation in understanding with reference to the specific relief act. Next definition, highly important, settlement. Settlement means an instrument other than a will or a codicil as defined in the Indian Succession Act 1925, whereby the destination or devolution of successive interests in movable or immovable property. Devolution, survivorship, succession. ఇందాక పర్సనల్ లాస్లో ముస్లిమ్స్కి ఇట్ ఈస్ ఓన్లీ రైట్ బై డెత్, ఓన్లీ సక్సెషన్, నో క్వశ్చన్ ఆఫ్ సర్వైవర్షిప్. అలాగే క్రిస్టియన్స్ ఆల్సో అండర్ ఇండియన్ సక్సెషన్ యాక్ట్ ఫస్ట్ 1 to 10 సెక్షన్స్లో ఇట్ ఈస్ ఆల్సో బై సక్సెషన్ ఆఫ్టర్ డెత్ అండ్ నాట్ ఎనీ రైట్ బై బర్త్. But Hindu succession is important, the uncodified law which recognizes right by birth. And my brother Sachara also explained how a self-acquired property will become unto whom a co-personary property. 3 generations. He has given an example. I am only clarifying. With permission, Mr. Sacharao is younger to me and is also my Shishya, no doubt. If I succeed the property of my father, he already explained section 30 of the Hindu Succession Act 1956 that I can deal with my property in my own way because I got under section 8 of Hindu Succession Act to dispose of under 30 of the Hindu Succession. Like a co-partner's share, a co-partner's property, here for my father's self-acquired property or own property, for me to succeed, it is not covered by co-partnerary concept at all. I got by succession under section 8 of the Hindu Succession Act. That is only after my father's father death, my father got it by succession under 8. Not as a co-partnerary property. It is not the co-partnerary property. Once my father's father property got by succession by my father, I cannot claim, even I am a person born as a co-partnerary property, though it is my grandfather's property in the hands of my father's property. To claim by me right by birth, my father shall not allow. Then, because in his lifetime he can alienate the property which he got by share under 8 of Hindu Succession Act, covered by 30 of Hindu Succession Act. After death of my father, intestate, without disposing of by will or codicil covered by Indian Succession Act, or by settlement. Then only the third generation will get the property that is called co-partnerary. It is a very important principle to be kept in mind by every advocate. This is the basic concept. This is the foundation of understanding the self-acquired property and co-personary property. Without that foundation, you cannot build a case. So that is an important concept only called out in Mulla Hindula in brief. Though in Raghavachari there is a detailed discussion on that. And Mains Hindula definitely it is there if you are able to search. But Mulla is very briefly mentioned and you can easily understand. These are the three standard books on Hindula for you to read and understand and digest if you got the capacity. Now coming back to settlement, because I have driven you from there. Settlement means an instrument other than a will or codicil as defined by the Indian Succession Act 1925, whereby the destination or devolution of successive interests in immobile property or movable property is disposed of or is agreed to be disposed of. Here it is important. You read the Transfer of Property Act section 122 to 129, gift. For Muslim law, a gift, no document is required. There are only three preconditions. Volition, voluntarily disposing of, dedicating, relinquishing and dedicating, conveying, in the presence of witnesses, by open expression and delivery of position. These are the three. But so far as Hindus governed by the Transfer of Property Act, because that Muslim gift is not governed by virtue of the specific section among 122 to 129 of the Transfer of Property Act, for Hindus, there must be giving and taking for a gift to be valid. Acceptance must be there. Without acceptance, there is no question of effecting or enforcing a gift or creating a right. Till then it is only contingent. After that, even a registered document is there. Unless I accept as a donee, it will not become a vested right. Once I have accepted, even position is postponed or position is not delivered or position is to be given after a lifetime by loosely wording as settlement, it is enforceable. Once there is an acceptance. So that is the basic principle. Here for settlement, they did not simply say a gift or settlement to be a completed contract associated with acceptance, an agreement also. Why it is provided? Is it contemplated for specific performance of an agreement to execute a gift? Definitely that doubt arises from reading of the definition, because many of you might not have read the definition of settlement only given in the specific relief act, nowhere under Hindu law, but for the dictionary definition. I am reading once again, it is important for you. Or is agreed to be disposed of. That is important. So an agreement for settlement is specifically enforceable. However, it shall not be one covered by gift, because gift is specifically exempted by Transfer of Property Act. I will come to the provisions of the specific relief act in this regard. Once there is a statutory provision governing for the relief, specific relief act has no application. That is the important basic principle to be kept in mind. Otherwise, by reading a simple definition, you will be landed in confusion. Am I clear? Am I unnecessarily driving you to somewhere instead of simple specific relief act, specific performance, whether contract to be enforceable or not? Because the definition understanding is such an importance. Trust, we can leave. Trustee, we can leave. All other words and expressions used herein, but not defined in the Indian Contract Act. Once it is defined, Indian Contract Act is mother, a general law. Specific relief act is a child, a special child as a special law. Once there is a provision under specific relief act, these provisions prevail. For understanding every provision of the specific relief act, the general principles of the Indian Contract Act that are applicable here thereby All other words and expressions used herein, but not defined and defined in the Indian Contract Act, have the meaning respectively assigned to them in that act. So, if there is any definition you require to understand the specific relief act, you tune back to Indian Contract Act provisions, whole provisions. Saving, except as provided, otherwise provided herein, nothing in this act shall be deemed to deprive any person of any right to relief other than specific performance, which he may have under any contract. So, under a contract other than specific relief, specific performance also, once you are entitled, by virtue of seeking a specific performance, you are not deprived of that relief. But for order to rule to CPC bar, once there is an accrued cause of action, you cannot give up a cause of action, and once given up or not claimed, it is deemed given up. So you cannot claim back later. That is the important principle, though a procedural aspect in CPC, which is a procedural law with adjectival law including rules of evidence, here it is a substantive provision to deprive like res judicata and other aspects. Now, to effect the operation of the Indian Registration Act on documents. So, Indian Registration Act, a compulsory registerable document, once not registered, it can be used only for a collateral purpose as contemplated by Section 49, explanations 1, 2, 3 of the Indian Registration Act, read with 17 of the Indian Registration Act. Otherwise, if it is 18, registration is optional. 17, registration is compulsory. Once registration is compulsory, an unregistered document cannot be used for any purpose other than for collateral purpose. What is defined as collateral purpose? There are good number of judgments right from that 2004 Supreme Court. Immediate ga naku memory loki raataledu. That judgment 2004 Supreme Court landmark judgment of the Supreme Court on that what is meant by collateral purpose. Otherwise, you can read the judgment of Buddha Jagadishwar Rao. Buddha Jagadishwar Rao judgment 2015. There I have described with reference to Privy Council judgments also what is meant by collateral purpose. Only for the limited purpose of 49 of the Indian Registration Act. Here you may got a doubt. Section 53A TP Act says, doctrine of part performance and agreement, though required to be registered, not registered, it can be used as a shield. That is amended with effect from 26/8/2001. That a possessory agreement is a compulsory registerable agreement under the central legislation by virtue of amendment to 53A TP Act, explanation, and 49 of Registration Act. Before that, there is an AP amendment with effect from 1499, which clearly says a possessory sale agreement is a compulsory. All agreements are compulsory registerable agreements. And possessory sale agreement, the stamp duty to be paid is as if it is a conveyance or sale. Non-possessory 100 rupees maximum. We need not go into it, but for the limited purpose of the provisions of Registration Act will not be taken away or affected by virtue of the provisions of the Specific Relief Act is the sum and substance of Section 3B. Now 4. Specific relief to be granted only for enforcing individual civil rights and not for enforcing penal laws. Specific relief can be granted only for the purpose of enforcing individual civil rights and not for the purpose of enforcing penal law. I need not elaborate it. Next, Section 5, recovering possession of property. 6, suit by person disposed of immobile property. The amendment is only, though whom he has been in possession or any person on his behalf can maintain a suit for summarily evicted by summary suit to restore back possession. You all know the judgment of 2004 landmark judgment, Ramegowda judgment, please make a note. Justice Lahoti judgment, Ramegowda versus some Naidu vastundi. Varadappa Naidu, Ramegowda versus Varadappa Naidu, 2004 Supreme Court. That is a landmark judgment. You can have right from 1955, 68 Supreme Court, 69 Supreme Court, 72 Supreme Court. These are all the landmark judgments on the scope of Section 6 Specific Relief Act and 109 of Indian Evidence Act, elaborately discussed therein. That Ramegowda judgment. Now coming to Section 7. Recovery of specific movable property, we need not go much into it. 8. Liability of person in possession not as owner to deliver to persons entitled to immediate possession, that is the legal obligation. Otherwise liable for mean profits or damages for use and occupation. And now chapter 2 mainly we are concerned with Section 9. Very important section for a defendant in opposing a suit for specific performance. This is not amended. Though Section 10 is amended with reference subject to 16, 14, 11b or 11.2. That is the wording of Section 10. We will come to that. Before that, Section 9, important. Defense respecting suits for relief based on contract. Defense respecting suits for relief based on contract. What are the defenses? Except as otherwise provided herein, in this chapter. Where any relief is claimed under this chapter in respect of a contract, the person against whom the relief claimed may plead by way of defense any ground which is available to him under any law relating to contracts. So, under the general law of contracts, all the defenses available, either saying breach of contract or unenforceability of the contract or equitable entitlement or disentitlement of the relief under the contract, including for damages. Two types of damages as contemplated, one by 73 Contract Act and the other 74 Contract Act. You can later read and know the distinction if you are able to make a note. What is the difference between 73 and 74 of contract? Because it is a different subject, I cannot drive you to it. And otherwise, quasi-contract principle with reference to Section 65 to 69, and also if at all you are able to have the understanding 71. And the basic judgment is 1998 Supreme Court judgment ఒకటి ఉంది, జస్టిస్ సాగిర్ అహ్మద్ అండ్ జస్టిస్ జగన్నాథరావు జడ్జిమెంట్. ఇమీడియట్గా నేను తీసివ్వలేను కానీ నా దగ్గర ఉంది. That judgment, it is worth reading. When that principle is to be applied to compensate, for no one can be entitled to unlawful enrichment from a deemed contract under 65 of the Indian Contract Act. That is an important judgment. Anyhow, this is the principle. Now, whether these defenses taken away, though from the amendment in 2018, once there is a contract for specific performance, the court shall is the mandatorily saying by Section 10. The specific performance of a contract shall be enforced by the court, subject to the provisions contained in 11.2, 14 and 16. That is important wording. But before that, Section 9 is there. Section 9 is not taken away. Under Section 9, all defenses are available to the defendant. Those defenses are not taken away. How the court shall? It is only subject to 9, though not stated as subject to 9. Because 9 is there. Then, specific performance in respect of contracts. The specific performance of a contract shall be enforced by the court subject to the provisions contained in subsection 2 of section 11, section 14 and section 16, and also subject to section 9 as I explained to you. Because all defenses are available to me to say or to show the plaintiff for specific performance is disentitled to main relief or any subsidiary relief even. Because all defenses are available under any law, not only under the Contract Act, under any law. Now, coming to 11.2, a contract made by a trustee in excess of his powers or in breach of trust cannot be specifically enforced. It is similar to the AP Hindu Religious and Charitable Endowments Act 1987, section 80-81, and granting of permission to alienate property by the commissioner. Leasing beyond 3 years provided by the provisions. Commissioner discretion is only 3 years and the government discretion is only 12 years. Commissioner discretion 5 years. If it is beyond that, these are the provisions similar to that. Beyond the scope of a trustee, beyond the scope of a person deemed trustee, if a power is exercised, that excess power is unenforceable. That is the wording of section 11.2 of the amended Specific Relief Act 2018. Now section 12. Specific performance of a part of a contract. లేటెస్ట్ సుప్రీంకోర్టు జడ్జిమెంట్ ఉంది, మీకు ఇస్తాను దీని మీద. అంటే గడ్డిపాటి దివ్య కేసు, సివిల్ అపీల్ నెంబర్ 4206 and 4207 of 2011. This is the latest judgment dated 18/4/2023. 18/4/2023. There, the important judgment, earlier tweet of (2022) by 3 judgments. Sujata Reddy judgment, I will come. 1 minute. Katta Sujata Reddy versus Siddham Setti Infra Projects Private Limited, 2023, 1 SCC 355, 3 judge bench judgment. These are the two important judgments in relation to the Specific Relief Act regarding the specific performance with reference to the impact of the 2018 amendments in the Specific Relief Act in this chapter 2. I will come to those judgments and its analysis a little bit later because we are at section 12. Except as otherwise provided, hereinafter provided in this section, the court shall not direct the specific performance of a contract. Negative wording. Here in section 10, we read the court shall. In section 9, we read all defenses under any law are available to a defendant to oppose the suit for specific performance of a contract. In section 12, the negative wording, except as otherwise herein provided in this section, the court shall not direct the specific performance of a contract. The 10 wording is shall, 12 wording is shall, 12:1. Please go through. Shall not direct. There shall direct. Now 12.2. Where a party to a contract is unable to perform the whole of his part of it. Here, once there are joint owners, 3 persons having interest over the property. If out of the 3, only 1 person executed the agreement, where a co-personary father manager alienating the property for legal necessity or benefit of estate to bind the minor son is different. And prior to 2005 Hindu Succession Amendment 39 of 2005 is different. And subsequently the doctrine of pious obligation also taken away. Thereby, this section 10 of the Hindu Adoptions and Maintenance, Hindu Minority and Guardianship Act, that automatically comes into play. Once a minor's interest is there, a guardian cannot alienate the property, but for to the legal necessity as contemplated by 65 to 69 of the Indian Contract Act. Only to the extent of legal necessity. Otherwise, he is a trustee, even though father manager, because pious obligation is taken away. For the personal debts of the father, the son's share is not binding after the Hindu Succession Amendment Act 39 of 2005. However, it is only retroactive, neither prospective nor retrospective, as held by the 3-judge bench of the Supreme Court by Justice Arun Mishra, that is already pointed out by Mr. Learned Judge Sacharao. You please keep it in mind, that is the 3-judge bench that prevails. And in other aspects, but for that, because that judgment is contrary to the basic principle laid down in Anar Devi case, Sheila Devi case. 2005 Supreme Court lo 2 judgments ఉన్నాయి. నోట్ చేసుకోండి, అనార్ దేవి, షీలా దేవి. హిందూ సక్సెషన్ యాక్ట్ లో నేను చెప్తున్నా సెక్షన్ 6 మీద. అనార్ దేవి కేసు, షీలా దేవి కేసులో క్లియర్లీ laid down that once a father died, succession already opened. Once succession opened, the question of daughter claiming a right by birth doesn't arise. But in the 3-judge bench expression, by saying retroactive, what they stated is a right traced back to the by birth. So once it is a by birth, irrespective of death of the father, even section 6, a notional partition by the legal fiction, as if there was a partition at the time of his death అనేది ఉన్నా కానీ ఆపరేట్ అయినా by virtue of retroactive operation, it is a indirectly a retrospective operation that traced back to the right by birth to the position as on 1956 Succession Act came into force. That is the expression. Anyhow, the correctness is as on today we are bound as per Article 141 of Indian Constitution as a binding precedent on all of us. Because we cannot revert the clock back unless another 3-judge bench refers the matter and another constitutional bench, a larger bench, decides the matter afresh. That is running against the basic tenets, basic principles that are clearly laid down in Anar Devi case and Sheila Devi case and also Anantalakshmi case 2006. Anyhow, we are not going into that aspect because we are deviating. Now coming back to 12.3. Where a party to a contract is unable to perform the whole of his part of it and the part which must be left unperformed. For example, as defined in definition of decree, decree definition which conclusively determines the rights of the parties with regard to all or any of the matters in controversy. That is the wording. So, a preliminary decree, there can be more than one. There can be even 5 preliminary decrees, but there is only one final decree. However, there can be a partly final decree, where for the entire relief granted in the preliminary decree, could not be worked out, a partly final decree can be passed. That is the expression of 1969 Supreme Court, more particularly with all elasticity in partition suits. That was the principle laid down, that was followed in Sai Reddy by the Supreme Court. Here, by virtue of the claim, I am bound to concede because of the legal position, though originally I am entitled to the co-personary property of 2 acres for which I entered agreement with Sacharao, because of the change from my sisters maintained an application and preliminary decree amended, saying my sister also a co-partner entitled. Sacharao, for what the entire consideration paid, either to take the share of me for 1 acre or rescind the contract and ask for return of the purchase money. He cannot ask me, compelling me to execute a sale for 2 acres co-partner. He is bound to pay full consideration. That was the mistake committed in Gadipat Divya case by the High Court, that is pointed out by Supreme Court. I will come to that aspect. He is bound to pay the entire consideration. If at all he is willing to take part of the property covered by the agreement, because the entire property is unenforceable, that is the spirit of section 12(3) of the Specific Relief Act to be kept in mind. Now, does not admit of compensation in money because it is not governed by 73-74. టోటల్గా పెర్ఫార్మ్ చేస్తున్నారు. ఇప్పుడు ఎకరానికే పెర్ఫార్మ్ చేస్తున్నారు. మిగిలిన దానికి నాకు కాంపెన్సేట్ చేయాలి, ఐఎమ్ ఎంటైటిల్డ్ అండర్ జనరల్ ఆఫ్ కాంట్రాక్ట్ అండర్ 73-74 అని అనడానికి లేదు. He is not entitled to obtain a decree for specific performance, but the court may, at the suit of the other party, direct the party in default to perform specifically so much of his part of the contract as he can perform. That is important, because I can perform only for my share. My share originally 2 acres I got by virtue of the preliminary decree, but by virtue of the change I got only 1 acre. If the other party in a case falling under clause A pays or has paid the agreed consideration for the whole of the contract, reduced by the consideration for the part which must be left unperformed, and in a case falling under clause B pays or has paid the entire consideration for the whole of the contract without any abatement of even a portion of the contract. That is the wording. Without any abatement, that is clause 1. 2. In either case, relinquishes all claims to the performance of the remaining part of the contract. So he has to relinquish that portion of money if at all he want to enforce for specific performance. There are the 4. When a part of a contract which taken by itself can and ought to be specifically performed stands on a separate and independent footing from other part of the same contract which cannot or ought not to be specifically performed, the court may direct specific performance of former part. Here, because where the respective extents can be construed as like independent contracts, though covered by one contract, severable, then for part of a contract for payment of consideration for that portion specific performance can be granted. This 4 is an exception to 3 and 2. Next, for the purpose of this section, a party to a contract shall be deemed to be unable to perform the whole of his part of it if a portion of the subject matter existing at the time of contract has ceased to exist at the time of performance. ఇందాక నేను మీకు చెప్పిన ఎగ్జాంపుల్, by virtue of preliminary decree change, though the agreement entered after preliminary decree, by virtue of the amended preliminary decree, there is a change. Now 13, section 13 is to be read with section 17 and 19. Please make a note. For proper understanding, section 13 is to be read with section 17 and 19. 13. Rights of purchaser or lessee against person with no title or imperfect title. When no title, no one can convey a better title than what he has. He cannot compel an impossibility of performance, basic principle. Here, where a person contracts to sell or let certain immobile property, having no title or only an imperfect title, it is subject to section 116 of the Evidence Act. That is also, you can read later, estoppel by tenant. I will come, but it is a different subject and I cannot confuse by driving into it. Please read and correlate for a proper understanding. Where a person contracts to sell or let certain immobile property, having no title or only an imperfect title, the purchaser or lessee has the following rights, namely, if the vendor or vendee has subsequent to the contract acquired any interest in the property, the purchaser or lessee may compel him to make good the contract out of such interest. మీకు ఇంకా సింపుల్గా అర్థం అయ్యేందుకు ఇందాక చెప్తా. మా సిస్టరు నేను మా తండ్రి తాలూకు యాన్సిస్టర్ ప్రాపర్టీ బై బర్త్ రైట్ మా సిస్టర్ క్లెయిమ్ చేస్తే ఆవిడకి ఏం రాదన్నా నేను కంటెస్ట్ చేశాను. షీలాదేవి అనారదేవి కేసు ప్రకారం సుప్రీంకోర్టు వాళ్ళ ఎగ్జిస్టింగ్ లా ప్రకారం తీర్పిచ్చేశారు. షీ ఈజ్ నాట్ ఎంటైటిల్డ్ బికాజ్ ఫాదర్ డైడ్, సక్సెషన్ ఆల్రెడీ ఓపెన్డ్, నోషనల్ పార్టీషన్ ఎప్పుడు అయిపోయింది, ఈజ్ ది సోల్ సర్వేయింగ్ కోపార్సనర్ కనుక ఆవిడ షేరర్గా ఆయన ఇంట్రెస్ట్లో వస్తుంది తప్ప కోపార్సనర్గా రాదు అని తీర్పిచ్చేశారు. ఆ సూట్ పెండింగ్గా ఉండగానే ఆవిడ అగ్రిమెంట్కి ఎంటర్ అయింది. నా తాలూకు ఆస్తి, నా వాటాకు రాబడే ఆస్తి ఏదైతే ఉందో అది నీకు ఇంతకు అమ్మేస్తానని. ఆ అగ్రిమెంట్ ఇక్కడ ఎన్ఫోర్స్ చేస్తున్నాడు. ఎన్ఫోర్స్ చేస్తున్నప్పుడు ఇక్కడ దాంట్లో 13 మీరు చదువుకోండి. Where a person contracts to sell or let certain immobile property having no title or only an imperfect title, the purchaser or lessee has the following rights, namely, if the vendor or lessee has subsequent to the contract acquired an interest in the property, the purchaser or lessee may compel him to make good the contract out of such interest. అలాగే కాకపోతే ఒక విల్లు దావా ట్రయల్ కోర్టులో విల్లు ప్రకారం క్లెయిమ్ చేస్తూ దావా పెండింగ్గా ఉండగా యాక్షనబుల్ క్లెయిమ్స్ అంటాం, ట్రాన్స్ఫర్ ఆఫ్ ప్రాపర్టీ యాక్ట్ కింద అమ్మేశారు, అగ్రిమెంట్ ఎంటర్ అయ్యారు. సబ్సిక్వెంట్గా ఆ విల్లు ఏమో ఫోర్జరీయా లేకపోతే నాట్ ప్రూవ్డ్ అన్నారు. అప్పీలేట్ కోర్టులో రివర్స్ అయ్యింది. దట్ ఈస్ మేడ్ ఫైనల్. అవాల్టికి లేని ఇంట్రెస్ట్ సబ్సిక్వెంట్గా వచ్చింది బై వర్చ్ ఆఫ్ ది చేంజ్ ఆఫ్ సర్కమస్టెన్సెస్ ఆర్ ఈవెంట్స్ ఆర్ ది కోర్ట్ లిటిగేషన్ యాజ్ ది కేస్ మే బి. దెన్ వేర్ ది కాంకరెన్స్ ఆఫ్ అదర్ పర్సన్స్ ఈజ్ నెసరీ. ఇందాక చెప్పా, 3 పర్సన్స్ ఎంటైటిల్డ్, ఒకళ్ళే అగ్రిమెంట్ రాశారు, వాళ్ళ చేత కూడా నేను ఒప్పించి రాయిస్తాను, వాళ్ళు నాకు చెప్పారు ఆథరైజేషన్ ఉందని. పవర్ ఆఫ్ అటార్నీ లేదు, ఆథరైజేషన్ ఉంది, ఆథరైజేషన్ లేదు. వాళ్ళు కాంకర్ చేస్తే ఫర్ వ్యాలిడేటింగ్ ది టైటిల్ అండ్ దే ఆర్ బౌండ్ టు కాంకర్ ఎట్ ది రిక్వెస్ట్ ఆఫ్ ది వెండర్ ఆర్ లెస్సార్. మైనర్స్ మేజర్ అయ్యారు, 3 years లోపల రాటిఫికేషన్ అలాంటిది. కానీ ది పర్చేజర్ ఆర్ లెస్సీ మే కంపెల్ హిమ్ టు ప్రొక్యూర్ సచ్ కాంకరెన్స్ and when a conveyance by other person is necessary to validate the title and they are bound to convey at the request of the vendor or lessor, the purchaser or lessee may compel him to procure such a conveyance. Next, C. Where the vendor professes to sell unencumbered property, but the property is mortgaged for an amount not exceeding the purchase money, and the vendor has in fact only a right to redeem it, the purchaser may compel him to redeem the mortgage and obtain a valid discharge and where necessary also a conveyance from the mortgagee. ఇక్కడ ఒక జడ్జిమెంట్ ఎకడమిక్ పర్పస్లో ఇక్కడున్న జస్టిస్ సుబ్బారెడ్డి ఆర్గ్యూ చేశాడు ఆ కేసు, నాకు తెలుసు. అటాచ్మెంట్ ఎవరు సుబ్బారెడ్డి అనుకున్నాను, కాదా? రామారావు పక్కన రామకృష్ణ అంటే సుబ్బారెడ్డిలా కనపడ్డాడు. రామాయణం సతీష్ కుమార్ వర్సెస్ Tammad Bhaskar Rao. Please make a note and read. Second appeal, 459 of 2017. SA 459 of 2017. Ramayanan Satish Kumar versus Tammad Bhaskar Rao. Whether agreement prevails or attachment prevails, and bona fide purchaser for consideration, the concept and amendment in 64 CPC in 2002, pre-amendment, post-amendment 1999, Supreme Court judgment, its impact, ఇవన్నీ కూడా ఎలాబొరేట్గా డిస్కస్ చేసిన జడ్జిమెంట్. అకాడమిక్ పర్పస్లో మీకు ఓపిక ఉండి సహనం ఉంటే ఈ కాన్సెప్ట్లో అవసరం కనుక చదువుకోండి. తర్వాత the provisions of subsection 1 shall also apply as far as may be to contracts for the sale or hire of movable property. మనకి పెద్ద అక్కలే. నెక్స్ట్ 14, 9, 10, 11, 2 చదివాం, 1 స్కిప్ ఆఫ్ చేసాం, 12, 13 ఇప్పటిదాకా చెప్పినాం. 9లోనేమో వాట్ ఆర్ ది డిఫెన్సెస్ అవైలబుల్ అండర్ ఎనీ లా అవైలబుల్ to oppose the suit for specific performance by a defendant to a suit. 10లో court shall grant. 11(2)కి వచ్చేటప్పటికి వర్డింగ్ వేరు. 12కి వచ్చేటప్పటికి కోర్టు షల్ నాట్ గ్రాంట్. అక్కడ ఇక్కడ షల్ గ్రాంట్కి, అక్కడ షల్ నాట్ గ్రాంట్కి రెండింటిలో కోరిలేషను. 13 part of performance of a contract for payment of whole consideration where there is an impossibility or circumstances I have already explained. Now 14, contract not specifically enforceable. The following contracts cannot be specifically enforced, namely, ఇది amended section అండి 2018లో. అక్కడ 1 ఉంటుంది, మార్క్ ఉంటుందమ్మా, కొంచెం కిందకి జరిపితే. 14 ఏమో న్యూ సెక్షన్ ఎక్స్పర్ట్కి. సెక్షన్ 14 టోటల్లీ రీరిటెన్. అంతకుముందు 14 ఒకసారి మీకు ఇక్కడైనా ప్రజెంట్ చేయగలిగితే అది చదువుకుంటే తప్ప 14 మీకు అర్థం కాదు పూర్తిగా. పాత సెక్షన్ చదవమంటే నేను చదువుతాను. కాంట్రాక్ట్స్ నాట్ స్పెసిఫికల్లీ ఎన్ఫోర్సిబుల్. ది ఫాలోయింగ్ కాంట్రాక్ట్స్ కెనాట్ బి స్పెసిఫికల్లీ ఎన్ఫోర్స్డ్, నేమ్లీ ఏ కాంట్రాక్ట్ ఫర్ ది నాన్ పెర్ఫార్మెన్స్ విచ్ కాంపెన్సేషన్ ఇన్ మనీ ఈజ్ ఎన్ అడాక్వేట్ రిలీఫ్. ఓల్డ్ 14 తీసారమ్మా 63 యాక్ట్ కింద. ఇది కాదు, ఇది అమెండెడ్ సెక్షన్. సరే, ఇది ఇలా ఉంచండి అమ్మా. ఇప్పుడు అమెండెడ్ సెక్షన్ అలా ప్లీజ్ డిస్ప్లే. ఇప్పుడు ఉన్నదే ఉంచేయమ్మా తల్లి. ఇది ఇలాగ ఉంచేసేయమ్మా. ఓల్డ్ 14 చదువుతాను, ఒక్కసారి వినండి. ది ఫాలోయింగ్ కాంట్రాక్ట్స్ కెనాట్ బి స్పెసిఫికల్లీ ఎన్ఫోర్స్డ్, నేమ్లీ ఏ కాంట్రాక్ట్ ఫర్ ది నాన్ పెర్ఫార్మెన్స్ విచ్ కాంపెన్సేషన్ ఇన్ మనీ ఈజ్ ఎన్ అడాక్వేట్ రిలీఫ్. ఒకవేళ కాంట్రాక్టు స్పెసిఫిక్ పెర్ఫార్మెన్స్ ఇవ్వకలేకుండా దాన్ని కాంపెన్సేట్ చేయడానికి డబ్బుల రూపేణా ఇవ్వగలిగితే specific performance cannot be granted even otherwise entitled. చాలా ఇంపార్టెంట్ కదా. That is the discretion to be exercised by the court under 14 read with 20 of the specific relief act, subject to the readiness and willingness right from the entering of agreement till passing of decree as contemplated by old 16 of the specific relief act. Next, a contract which runs into such minute or numerous details of which is dependent on the personal qualification or volition of the parties or otherwise from its nature is such that court cannot enforce specific performance in material terms. దీని మీద జస్టిస్ జగన్నాథరావు గారి జడ్జిమెంట్ ఒకటి 1984 ఆర్ 85 ఒక జడ్జిమెంట్ ఉంది కమిషన్స్ మీద. A commissioner cannot be appointed as to the alleged violation by a club time to time for a continuous supervision. It is coming within the prohibition contemplated in parameteria, though not directly, of 14B of the Specific Relief Act. ఆ జడ్జిమెంట్ మీకు ఎప్పుడైనా అవకాశం ఉంటే తర్వాత చదువుకోండి. కమిషన్ అపాయింట్మెంట్ మీద కమిషనర్ని కెనాట్ బి అపాయింటెడ్ అని చెప్తూ ఈ ప్రిన్సిపల్ని అక్కడ అడాప్ట్ చేసిన జడ్జిమెంట్ 1984-85 జస్టిస్ ఎం జగన్నాథరావు జడ్జిమెంట్. నెక్స్ట్, ఏ కాంట్రాక్ట్ విచ్ ఇన్ ఇట్స్ నేచర్ డిటర్మినబుల్, డిటర్మినేషన్ అంటే సీజ్ టు ఎన్ఫోర్స్, కాంట్రాక్ట్ ఆల్రెడీ డిటర్మైన్డ్, there is nothing for specific performance. A contract, the performance of which involves the performance of a continuous duty which court cannot supervise. అలాంటి కేసుల్లో కూడా స్పెసిఫిక్ పెర్ఫార్మెన్స్ కోర్ట్ కెనాట్ గ్రాంట్. సేవ్ యాజ్ ప్రొవైడెడ్ బై ది ఆర్బిట్రేషన్ యాక్ట్ 1940, no contract to refer present or future difference to arbitration shall be specifically enforced, but if any person who has made such a contract and has refused to perform it sues in respect of any such subject which he has contracted to refer, the existence of such contract shall or the suit. ఇది మీరు 28 ఆఫ్ ది ఇండియన్ కాంట్రాక్ట్ యాక్ట్ తో కలిపి చదువుకోవాలండి, నోట్ చేసుకోండి. సెక్షన్ 14 subsection 2 to be read with section 28 of the ఇండియన్ కాంట్రాక్ట్ యాక్ట్. 28 ఏమని చెప్తుందంటే, అగ్రిమెంట్స్ ఇన్ రెస్ట్రెయింట్ ఆఫ్ లీగల్ ప్రొసీడింగ్స్ వైడ్. Every agreement by which a party thereto is restricted absolutely from enforcing his rights under or in respect of any contract by the usual legal proceeding in ordinary tribunals, of which limits the time within which he may thus enforce the rights. Time limitation. For example, in arbitration, 3 months is the time stipulated within which an arbitration claim to be made from the dispute arisen, cause of action for the dispute arisen. Within 3 months he did not maintain arbitration proceeding, but the claim is within 3 years under Article 137 of the Indian Limitation Act. He can maintain a claim, but once there is a specific agreement under the arbitration clause, as per the arbitration agreement entered to stipulating within which the arbitration clause to be enforced from accrual of cause of action from the dispute arisen. If within 3 months not enforced, he cannot invoke arbitration. It is deemed an accepted matter under the Indian Arbitration Act. అది బేసిక్గా అర్థం చేసుకుంది. ఇంకా డీటెయిల్స్లోకి వెళ్తే మళ్ళీ మీరు కన్ఫ్యూజ్ అవుతారు. తర్వాత బి, విచ్ ఎస్టింగ్విషెస్ ది రైట్స్ ఆఫ్ ఎనీ పార్టీ thereto or discharges any party thereto from any liability under or in respect of any contract on the expiry of a specified period, so as to restrict any party from enforcing his rights, is void to that extent. There is the explanation. Saving of contract to refer arbitration dispute that may arise. So, a legal bar from the agreement not to enforce in a court of law is not an absolute bar. Once there is an arbitration clause provided, all agreements in restraint of legal proceedings void. But an agreement in partial restraint of legal proceeding in a court of law valid. You cannot go to court once there is an arbitration agreement. That is the spirit of section 8 of the Arbitration Act also, unless it is waived under section 4 of the Arbitration Act. Doctrine of waiver applicable to arbitration proceedings from the very wording of section 4 of the Arbitration Act 1996. ఇంకెంతకు మించి నేను చెప్పను, కన్ఫ్యూజ్ చేయను, ఎందుకంటే లిమిట్ ఉండాలి కదా, మళ్ళీ మిమ్మల్ని ఎక్కడికో డ్రైవ్ చేస్తే. నౌ 14 అమెండెడ్ సెక్షన్ చూడండి అమ్మా, ఇందాక మీరు డిస్ప్లే చేసి 14A అది ఎక్స్పర్ట్ మనకి అక్కర్లే. టైం అవుతుందా రామారావు గారు, టైం అవుతుందా? ఒక పావు గంట ఎంతో కంటిన్యూ చేయొచ్చు కదా, 10 minutes. అదే వెరీ గుడ్. Contract not specifically enforceable. The following contracts cannot be specifically enforced, namely, where a party to the contract has obtained substituted performance of a contract in accordance with the provisions of section 20. 20 ఏమిటో మనం వద్దాం. అమ్మా మార్చేకండి, మరి 20కి వెళ్తున్నారా? సబ్స్టిట్యూటెడ్ పెర్ఫార్మెన్స్ ఆఫ్ కాంట్రాక్ట్ అంటే ఏమిటో చెప్పారు. అది ఇప్పుడు అది కూడా అమెండ్ అయిపోయింది. 3 మీరు చూస్తే మొత్తం సెక్షన్ అంతా అమెండ్ అయింది 2018లో. నెక్స్ట్ పైకి వెళ్ళమ్మా, 14లో. రెండు, ది కోర్ట్ మే రిక్వైర్ ఆర్ డైరెక్ట్ ఎనీ పర్సన్ టు గివ్ relevant information. 14b, a contract the performance of which involves performance of a continuous duty. ఇదివరకు నేను చెప్పాను కదా. తర్వాత సి, ఏ కాంట్రాక్ట్ విచ్ ఈజ్ సో డిపెండెంట్ ఆన్ ది పర్సనల్ క్వాలిఫికేషన్, ఇందులోనే వచ్చింది. కాంట్రాక్ట్ విచ్ ఇన్ ఇట్స్ నేచర్ డిటర్మినబుల్. ఇక్కడ మీకు ఒక్కటి చెప్పాలి, ఓల్డ్ 14 ఎక్స్ప్లెనేషన్ ఒకటి చదువుతాను, దట్ ఈస్ ఇంపార్టెంట్. అందులో ఏముందంటే వన్కి సంబంధించి ఓల్డ్ దాంట్లో, ది కోర్ట్ షల్ ప్రెజ్యూమ్ దట్ కాంపెన్సేషన్ ఇన్ టర్మ్స్ ఆఫ్ మనీ ఫర్ స్పెసిఫిక్ పెర్ఫార్మెన్స్ ఇన్ సూట్స్ రిలేటెడ్ టు ఇమ్మూవబుల్ ప్రాపర్టీ ఈజ్ నాట్ అడాక్వేట్ అని. అది ఇందులో లేదు, ఓల్డ్ సెక్షన్ 14లో ఉంది ఎక్స్ప్లెనేషను. 14 ఓల్డ్లో 1 వరకు చదివాను నేను. ఏ కాంట్రాక్ట్ ఫర్ ది నాన్ పెర్ఫార్మెన్స్ ఆఫ్ విచ్ కాంపెన్సేషన్ ఇన్ మనీ ఈజ్ ఎన్ అడాక్వేట్ రిలీఫ్. ఏమండి, మమ్మల్ని కొత్తది పాతది చదివి కన్ఫ్యూజ్ చేస్తున్నారని అనుకుంటారేమో. ఇది అవసరము మీకు, ఎందుకంటే 2018 అమెండ్మెంట్స్ ఓన్లీ ప్రాస్పెక్టివ్. 2018 అమెండ్మెంట్స్ ఫ్యూచర్లో ఆ తర్వాత వచ్చిన వాటికే అప్లై అవుతాయి. అంతకు ముందు వాటికి 2018 అమెండ్మెంట్ లేనట్టుగా ఎంచుకుని మనం పాత ప్రావిజన్స్ చూసుకోవాలి. దానికే మీకు ఇందాక 2 సుప్రీంకోర్టు జడ్జిమెంట్లు ఇచ్చాను. ఇంకా కిందకి చెప్పండి. ఇంకా కింద ఎక్స్ప్లెనేషన్ ఉంటుంది. సరే, మీరు లేకపోతే తర్వాత చూసుకోండి. ఎక్స్ప్లెనేషన్ ఏమంటారంటే కాంపెన్సేషన్ ఇన్ టర్మ్స్ ఆఫ్ మనీ. ఒకసారి unless and until the contrary is proved, court shall presume that breach of contract to transfer immovable property cannot be adequately relieved by compensation in money. ఇది ఓల్డ్ సెక్షన్ 10 అండి. నేనే చెప్పడంలో 14 అని కన్ఫ్యూజ్ చేశాను. ఓల్డ్ 10, ఓల్డ్ 14, న్యూ 14 కలిపి చదువుకోండి. That the breach of contract to transfer movable property can be relieved except in the following case. So immovable property contract లో స్పెసిఫిక్ పెర్ఫార్మెన్స్ కి బదులు రిఫండ్ ఆఫ్ మనీ కానీ కాంపెన్సేషన్ బై టర్మ్స్ ఆఫ్ మనీ కానీ ఇస్తామంటే సరిపోదు అనేది బేసిక్ ప్రిజంప్షన్ 2018 అమెండ్మెంట్కి ముందర కూడా. ఇక్కడ మీకు 2 ఇంపార్టెంట్ ఆస్పెక్ట్స్ సెక్షన్ 9, 10లో. 9 ఏం చెప్తుంది? ఆల్ డిఫెన్సెస్ అవైలబుల్, బట్ ఏ కాంట్రాక్ట్ ఈజ్ ఎ కాంట్రాక్ట్ దట్ ఈజ్ ఎన్ఫోర్సిబుల్. వన్స్ ఏ కాంట్రాక్ట్ ఈజ్ ఎన్ఫోర్సిబుల్, there is an equitable discretion vested in the court to grant or refuse relief. A grant or refuse relief equitable exercise of judicious discretion by court ఏదైతే ఉందో, నేను ప్రతిదానికి స్పెసిఫిక్ పెర్ఫార్మెన్స్ ఇవ్వను, ఇన్ టర్మ్స్ ఆఫ్ మనీ ఇచ్చేస్తానని అనడానికి లేదు. బికాస్ దెర్ ఇస్ ఎ ప్రిజంప్షన్ దట్ కాంపెన్సేషన్ ఇన్ టర్మ్స్ ఆఫ్ మనీ ఈజ్ నాట్ ఏ సబ్స్టిట్యూట్ టు refuse specific performance even earlier. It is indirectly mandating the court to grant specific performance unless the plaintiff is disentitled to the discretionary relief. That is the sum and substance. And sir, ఎవరో ఒక్కసారి నించున్న సెక్షన్ 14లో లీగల్ పొజిషను బిఫోర్ అమెండ్మెంట్ ఆఫ్టర్ అమెండ్మెంట్ లో ఇప్పుడు మీకు నేను చెప్పింది, గతంలో కాంపెన్సేషన్ ఇన్ టర్మ్స్ ఆఫ్ మనీ ఈజ్ ఎన్ అడాక్వేట్ రిలీఫ్. అలాంటి దాంట్లో కోర్టు డిస్క్రిప్షన్ ఎక్సర్సైజ్ చేసి స్పెసిఫిక్ పెర్ఫార్మెన్స్ రిఫ్యూజ్ చేయొచ్చు ఓల్డ్ లా. ఎంఐ క్లియర్? కానీ సెక్షన్ 10లో ఎక్స్ప్లెనేషన్ ఏం చెప్తుందంటే, సూట్స్ రిలేటింగ్ టు ఇమ్మోబుల్ ప్రాపర్టీ కాంట్రాక్ట్స్ సంబంధించి కోర్టు కెనాట్ ప్రిజ్యూమ్ దట్ కాంపెన్సేషన్ ఇన్ టర్మ్స్ ఆఫ్ మనీ ఈజ్ అన్ ఈక్వలెంట్ ఆర్ సబ్స్టిట్యూటెడ్ రిలీఫ్ టు ది స్పెసిఫిక్ పెర్ఫార్మెన్స్. స్పెసిఫిక్ పెర్ఫార్మెన్స్ కి బదులు మనీ ఇచ్చేద్దామంటే దానికి ప్రిజంప్షన్ లేదు, ఎడాక్వేట్ రిలీఫ్ కోర్టు నిర్ణయించలేదు. ఆ ప్రిజంప్షన్ కోర్టుకి అగెనిస్ట్ గా ఉంది. అంటే కోర్టు కాషన్ ఏమని, స్పెసిఫిక్ పెర్ఫార్మెన్స్ ఎంటైటిల్డ్ అయితే నువ్వు స్పెసిఫిక్ పెర్ఫార్మెన్స్ ఇయ్యి. ఇట్ ఈస్ ఇండైరెక్ట్లీ సేయింగ్ కోర్టు షల్ గ్రాంట్ స్పెసిఫిక్ పెర్ఫార్మెన్స్ యాజ్ కాంటెంప్లేటెడ్ బై present 10 and present 14. ఇప్పుడు అందులోనూ ఇందులోనూ మీకు క్లోజ్గా చదివితే కానీ ఈ డిస్టింక్షన్ అర్థం కాదు. ఈ రెండింటికి ఎందుకు ఎక్స్ప్లెయిన్ చేయవలసి వస్తుందంటే, 2018 అమెండ్మెంట్ ఓన్లీ ప్రాస్పెక్టివ్, ఆ తర్వాత ఎంటర్ అయిన కాంట్రాక్టులకే ఇది వర్తిస్తుంది. పెండింగ్ సూట్స్ కానీ పెండింగ్ లిటిగేషన్ కూడా వర్తించదు. అది కట్టా సుజాతారెడ్డి అని 2003 1 SCC 335 అనుకుంటా 3 జడ్జి బెంచ్ మీకు చెప్పాను. అదే ఇప్పుడు గడ్డిపాటి దివ్య కేసులో 28/4/2023 జడ్జిమెంట్, సుప్రీంకోర్టు 18/4/2023 జడ్జిమెంట్ ఇప్పుడు మీకు దాన్ని ఫాలో అవుతూ చెప్పింది చెప్పా. ఇంతకు ముందు కాంట్రరీ వ్యూ 2020లో ఒకటి ఉంది, కానీ ఆ వ్యూ ప్రివైల్ అవ్వదు. బికాస్ 3 జడ్జి బెంచ్ ఆల్రెడీ laid down the law that is reiterated by the latest 2 judge bench in గడ్డిపాటి దివ్య కేస్. ఏమై క్లియర్? మీ కన్ఫ్యూజన్ క్లియర్ అయిందండి? యువరాన్లో అనక్కలేదు, మిస్టర్ శివశంకర్ అంటే చాలు. నేను ఎప్పుడో రెట్టు తీసేసిన తహసీల్దార్. సరే, ఇప్పుడు దీంతో నేను ఎండ్ చేస్తా, ఎందుకంటే టైం లేదని అన్నారు కనుక. బేసిక్గా ఇంకొకసారి ఎప్పుడైనా అవకాశం ఉంటే మనం కలవచ్చు.
Thank you, sir. For want of time, we could not proceed further. As I told you, it's very difficult to stop Justice Shivashankar Garu. But we have time constraints, we have other sessions, therefore I am compelled to ask my lord to stop. And otherwise, we can continue another hour also, but he will be able to present and he will be able to recollect so many cases. I request Venkataramaredi also to accompany with the Ramireddy and myself to Well State. I also request Chandrasekhar Reddy Garu to come onto the dais. Thank you. There will be a short break, as I told you, quickly within 10 minutes. We will have interesting session, and we will continue up to lunch. Quick, please. We shall reassemble within 10 minutes. డియర్ ఫ్రెండ్స్, బయట ఉన్న వాళ్ళంతా తొందరగా లోపలికి వస్తే సెషన్ మొదలు పెడదాం. బయట ఉన్న వాళ్ళంతా తొందరగా లోపలికి రావాలి. మనకి ఇక టైం పోస్ట్ పోన్ చేయడానికి లేదు, మళ్ళీ రేపటికి రీషెడ్యూల్ చేయడానికి లేదు. ఈ ఒక్కరోజే మనకి ఉంది కాబట్టి తొందరగా లోపలికి వస్తే మనకు ఉన్నటువంటి సెషన్స్ అన్ని కంప్లీట్ చేసుకొని నెక్స్ట్ వ్యాలిడేటరీ తోటి మీ సర్టిఫికెట్స్ అన్ని కూడా రెడీగా ఉన్నాయి. ఒక సిస్టమేటిక్ గా వాటిని అందజేస్తారు. అందరు తొందర రావాలండి.
సార్ అందరూ లోపల రావాలి సార్, సెషన్ స్టార్ట్ అవుతుంది. బయట ఉన్న అడ్వకేట్స్ అందరూ లోపల రావాలి.
We request all the advocates who are outside to please come inside. The session will commence in a short while. I repeat, all the advocates who are having their refreshments should come inside in a short while. We are commencing the session in a short while. A small announcement. We have found a lost ID card of advocate Mr. V.P. Vardhan. I repeat, we have lost an ID card of an advocate Mr. V.P. Vardhan. Mr. V.P. Vardhan, we request him to collect the ID card from the stage. I repeat, we have found a lost ID card of advocate Mr. V.P. Vardhan. Mr. V.P. Vardhan. We found it. A pen, please. I request Sri Kum.
జడ్జి గారికి ఇప్పుడు సీనియర్ ప్రొఫెసర్ పెట్టేసి
ఈయన జడ్జి గారా?
జడ్జి గారు.
I request Sri Ganta Ram Rao Garu, Chairman of Bar Council of Andhra Pradesh, to come over to the dais and adore the chair. I request Mrs. Mautushi Thakur to present a sapling to Sri Ganta Rama Rao Garu, Chairman, Bar Council. I request Honorable Sri Justice G. Ramakrishna Prasad Garu, Judge, High Court of Andhra Pradesh, to come over to the dais and adore the chair. I request Mr. Kamsai SVM, Associate Professor, to present a sapling to Honorable Sri Justice G. Ramakrishna Prasad Garu. Now I preside the session to Mr. Ganta Ramarao garu.
Justice Ramakrishna Prasad garu, Justice Rajshekhar Reddy garu, my colleagues in the Bar Council, advocate friends, faculty members, ladies and gentlemen. Justice Ramakrishna Prasad garu started his career as a lecturer. He practiced at Guntur for some time, but he did not take the single stop flight. He straight away went to Delhi without stopping at High Court at Hyderabad. And he practiced there on considerable time. He is having a vast experience as an advocate, and then become a judge. And especially this writ jurisdiction is having a exposure to that particular subject. Without loss of time, I request my Lord to present. I request my Lord not only narrating about the writ jurisdiction for some time, but also deal with the Kesavananda Bharati case, which is a celebrated case of having been completed 50 years. Thank you. I request my Lord to come and present on the subject.
Chairman Bar Council of Andhra Pradesh, my brother Justice Rajshekhar Reddy, dear friends, all participants here, senior advocates, law students. Mr. Ramarao, Ganta Ramarao has given me a vast syllabus with a little time. Although I'll still try to cover up to the extent possible, but minute in-depth study may not be really possible, because each article by itself in the Constitution is an ocean to study. One day, 1 month, 1 year, even one lifetime may not be sufficient. So in this background, we'll try to make it to the best possible. Now, the writ jurisdiction under Article 226, Part 6 of the Constitution of India deals with the state 3 organs, out of which the judiciary or the High Court of the respective state is one. Now, Article 226 that deals with writ jurisdiction, before we actually, because across the professional members here, there are also advocates from High Court as well as from the trial courts, then the law students. So I would like to just go a little back even before, because Article 226 is just one provision in the Constitution, and the Constitution itself is a bulky document. In fact, the longest Constitution in the world is the Indian Constitution. Now, when we go back in the making of the Constitution, and even prior to that, going back to the ancient times, from the time that we have advanced from the tribal culture, and then the tribal heads and so on and so forth, the society has progressed. As the society has progressed, the human development in terms of becoming sociable, then forming into groups, then forming into greater organizations, then the kingship, so on and so forth have come. The olden style of functioning, where be it the tribal head who would be the final, he would repose, he is the embodiment of making of law, which means the making of rules. He would be the embodiment of the executor. He would also be the embodiment of the ultimate adjudicator in case of a dispute. So one single person has wielded the power, which in today's common world, that it is organized by, handled by 3 organs of the state, namely the legislature, the executive, and the judiciary. This is how the three functions of a state was or handled by one single person called the king or the queen, and so on and so forth. Now, for the first time, how the law has developed, then the constitutional law, because you all had a very brainstorming session in terms of various statutes, the specific relief act, so on and so forth. The constitutional law, the approach towards this is entirely different. The instruments and the tools which are used to interpret the constitutional law are different from the rest of the statutory rules, and therefore one has to visit the constitutional law from a different perspective. Now, when you go back, how the law has developed, we did not just by waking up on a morning that find a big book of constitution. It is not that. Nor has even the constitutional law which we have adopted has developed just overnight. Over centuries of hard work and the intellect of human beings, that the principles of constitutional law have evolved. To start with, the Magna Carta, which we call 1215, 12th century, this has originated in England. Even prior to that, there are loose forms of law, but then it has never fructified into a form. The purpose for this development of constitutional law is because now, as the society grew, the power that is wielded by a single person the perception has changed, and the people's representatives have come into existence. So in 1215, it was during King Edward's time, for the first time, that you see the English, they are in the European geographical region, they had different conquest, wars with other nations, and so on and so forth. So the king had to raise a lot of funds to maintain an army. The king has imposed the local barons, the local leaders, to collect taxes. So as an exchange, as a barter, the local leaders said that we will collect taxes on your behalf, provided that you guarantee certain rights to the people. So for the first time, that is how the Magna Carta has come into existence. And then the participation of the people also have come into existence. How this is relevant is because today in the document, as we call it as Constitution, we have all the functions of the three organs of the state are well defined. This is what we call it as the Constitution. So for the first time, as in 1215, the Magna Carta has come into existence. This is called the law of the land. Magna Carta, sometimes people call it as Bill of Rights, but it is not so. It is actually, the Magna Carta means law of the land. It actually guarantees certain rights, and that is how commonly it is called as Bill of Rights. So after the Magna Carta has come into existence, then the creation of the parliament, then the parliament, that is the members from the society, would sit and then legislate, and it is only the king who will finally give approval to it. So slowly the system of these kingdoms and kings and all have given way to democratic thinking, the people's participation, and so on and so forth. In England, if you see, they don't have a written constitution. They have something called the supremacy of the parliament, and that is the sovereignty of the parliament. And they have constitutional conventions, but they do not have a codified constitution just as the way we have. So the first time in 1715, it was the United States which had declared independence to itself and then has formed the constitution, a written constitution for the first time. There you have the Article 1 dealing with the legislature, Article 2 dealing with the executive, and Article 3 dealing with the judiciary. Now, there the principle that has been adopted is the strict separation of powers, where Article 1 exclusively deals with legislature, Article 2 deals with executive, Article 3 deals with the judiciary. And the rule is that one organ of the state will not entrench or enter into the powers of another organ. So there has been a very strict separation of powers in respect of United States. How is this important? Is because the subsequent constitutions which have come into existence, they also have more or less followed a similar kind of principle. This is a deviation from the English system of the constitutional functioning, where it is the sovereignty of the parliament would prevail. It was for the first time in Stockdale versus Hansard, Sheriff of Middlesex it is called, that case, where for the first time the House of Lords have ruled that the power of the parliament is supreme. So any law that is made by the parliament cannot be questioned in any court of law, nor any court would have the power or jurisdiction to annul or strike down a legislation made by the parliament, British parliament. In that case, the House of Lords has gone to that extent of saying, as regards the sovereign power of the parliament, that today, if British parliament makes a law that if all men will be called as women and all women will be called as men, they said it shall be so for all legal purposes. That is the kind of power that the British parliament has wielded. So when the American Constitution has come into existence, this is a continental shift totally, that the parliament or the legislature of the United States has never treated as a sovereign or supreme power. They said the supreme power rests with the Constitution. The Constitution deals with and defines the functions and powers of each organ of the state, namely the three organs. And this is how it has entrenched itself, this power of separation of powers. Now, thereafter, you see, for every constitutional system, you would, as it grows and then as they judicially they get entrenched, the certain landmark decisions also would be, because Article 3 of the American Constitution says that ultimately the interpretation with regard to the Constitution is vested with the Supreme Court, United States Supreme Court. So when the Supreme Court has interpreted this Constitution, what it does is that naturally in the 18th century, as the constitutional law was developing, the judges had to pave way for the society, for the future, as to how the American society should function under the Constitution. So what is the power of the Supreme Court? To look into whether a legislation made by the American Congress is right or wrong. In Marbury versus Madison, Chief Justice Marshall has laid down, saying that the Supreme Court has the power to judicially review. This is called the doctrine of judicial review. To judicially review even a legislation made by the Congress and strike it down. This power is not available to the House of Lords in United Kingdom, whereas this power under the Constitution has become available by this decision rendered in Marbury versus Madison by Chief Justice John Marshall. Another landmark decision which is also very important in the American history. I'm discussing this, even the American constitutional development is for this reason, that even in India, we have certain landmark decisions which have now become firmly entrenched as the system and as a very part of the Constitution itself. So in United States, in one of the cases where in McCulloch versus Maryland, that they have two-tier form of governance, just as the way we have. As we have the central government and then the state governments, there it is called the federal government and the state governments. The difference is that in our Constitution, we have three lists which are called the Union list, the state list, and the concurrent list. There under the United States Constitution, they have only one list, that is the federal list. Federal powers are limited and all the residual powers are left to the states. the respective states. They have their own constitution and then they have their own powers. The 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 issue was that the American, how the federation is formed. Now 52 states overnight they did not become United States of America. They have slowly joined the federal government, state by state. The last state, I think, state of Philadelphia has joined in the year 1815 or so. So this is how state after state have joined. Then an issue arose when one of the state, that is Maryland, state of Maryland, wanted to secede away from the United States government, saying we have joined voluntarily. When we have joined voluntarily, we have the right to even go back and form an independent country. So that was an issue before the Supreme Court of United States, where with a very beautiful quote, the law has become so well established. That is, it said that the United States is an indestructible union of indissoluble states. Just look at the phrase. It is, when it comes to the union cannot be destroyed by all states put together. And at the same time, the union doesn't have the power to dissolve any single state. So this has become firmly entrenched. So when a state joins the Federation of United States, it can only join, but it cannot go back. At the same time, all states put together cannot join to say that the federal government will not exist hereafter, and we states, each state has become an independent country. So this is how very beautiful landmark decisions have been rendered by various courts in various countries, which have become the very power of the Constitution itself. Now, coming back to our Constitution, as we gained independence in 1947, now thereafter the task of drafting the Constitution has begun. There was a Constituent Assembly which has been formed. The Constitution, the exercise to draft the Constitution has begun. With all by then, very rich case law and situations were also available from the American Constitution as well as even from the United Kingdom, etc. So with all these, the Constitution of India has been drafted. The framers of the Constitution wanted to have fundamental rights be kept sacrosanct and untouched by anybody. The vicissitudes of the various governments, which means that if a government is elected with absolute majority, without almost zero opposition also, whether such very strong governments, if they become anarchic and if they want to do away with any provisions of the Constitution, whether that is possible or not. So, coming back to part 3, which is the fundamental rights, which it is a chapter that deals with fundamental rights. It is enriched in part 3 of the Constitution of India. It starts with Article 12. Article 12 defines what is a state. Now, the definition of state is very, very important for a constitutional lawyer as he practices in the constitutional courts, and also, even for that matter, the law is practicing in the trial courts, in the civil side, on the criminal side. You also have to know what is the Constitution. Now, a client comes to you with seeking an advice. You should be able to say whether it is a civil litigation or a criminal, or whether one has to go and seek remedy in the High Court. So you have to know what is state and what kind of rights are enforceable by a citizen against the state. Then when it comes to the state, what is the definition of the state? It says, it starts with an all-inclusive. State includes, and it goes on. So every provision in the Constitution has been so well, beautifully crafted and thoughtfully given to us that today, as traditionally what was conceived in the initial cases of Champakam Dorai Rajan and so on and so forth, when they said, they took a very conservative, very narrow approach towards understanding a state. Now, thereafter, the law has evolved. Today, so many things have come to be added. The local authorities have been defined, the other authorities have been defined, things which are formed by a statute and under a statute have been defined. It has gone to the extent of even making the educational institutions also responsible because they are performing sovereign functions. So this is how the definition of state has been evolved and then has been enlarged by various decisions of the Supreme Court and the High Courts. And today, now the only protection for a common man against the anarchy of the rulers, the executive, is only by resorting to the writ jurisdiction. That is, when a fundamental right is violated or any other, because Article 226 is fundamentally different from Article 32. Article 32, which gives the power to the Supreme Court to entertain writs where there is violation of a fundamental right. Here 226 is vast. It is even wider than 32 in as much as that apart from the fundamental rights violations, one can approach the High Courts under 226 for any other purpose also. The words are for any other purpose. For any other purpose has been interpreted to mean as whether any effective, when there is no effective alternate remedy. Now, even a statutory right can be enforced under 226 of the Constitution before a High Court. You have then the vast list of fundamental rights. Article 13.1 that deals with, it is a saving clause, ex post facto clause, they're all saved, and then any statute which is in existence or any law which is in existence which would be offensive to the provisions of the Constitution, they shall be void to that extent only. But such of those laws which pre-existed the independence and the Constitution, if they are not opposed to the fundamental rights, then such laws are saved under 13 clause 1. Now 13 clause 2 is very, very important. This is what I was telling you, that our constitutional framers have entrenched and fortified the importance of fundamental rights, which are part 3 of the Constitution, in such a manner that it says that the state shall not make a law which will take away or abridge any of the fundamental rights entrenched in the part 3 in this chapter. So Article 13 clause 2 is become very, very fundamental, that even the strong governments, even if they want to just wipe away the citizens' fundamental rights, they cannot do that. The reason is this, Article 13 clause 2. So then you have the equality clause, then the other 15 and 16 also deals with equality, and then the subsequent reservations which have been incorporated by way of the First Amendment of the Constitution, providing reservations for socially and educationally backward classes, both in educational institutions as well as for the state employment. Now thereafter you have Article 19, which is important, which guarantees fundamental freedoms to every citizen. One such freedom is right to property, 19(1)(f). This becomes significant when I touch upon Keshwananda also. That is why I am just particularly drawing your attention. Now, apart from 19(1)(a), which deals with the freedom of speech, and then right to form associations, freedom of movement, so on and so forth, these are fundamental guarantees which are necessary for a human to have a human existence, not as an animal, but to have a human existence, one has to enjoy these freedoms. Now, when it comes to these fundamental freedoms, they're not absolute, but they're only subjective to certain reasonable limitations. Thereafter, you have the Article 20 dealing with the right against self-incrimination and so on and so forth. These are available for an accused right of against double jeopardy, that he shall not be tried twice for the same offense. Then Article 21 forming a very important, very fundamental core. In fact, Baba Sahib Ambedkar, when he was asked to mention one article which is the core, the soul of the Constitution, he said it is Article 21 because it deals with life and personal liberty of a person. So it guarantees every human being, every citizen, and in fact, this Article 21 is also available to a non-citizen. So these are the ways in which our constitutional framers have guaranteed the basic, the fundamental rights to the Indian citizens. Now, coming back to the importance of fundamental rights, they are called as, because of Article 13(2), they are called as inviolable rights. Nobody can violate your rights. They are called transcendental rights, which means that they transcend from one generation to the other. These rights are passed on. So that is the description which our constitutional framers have given to this. 226, clause 2, it, by way of writs, the rights are enforced. Now, what are these writs? Again, we have to date back to the British constitutional system. These writs were called the prerogative writs because they do not have the written constitution. They are called just the prerogative writs, and the same under our constitution they are called as the constitutional writs. The writ of habeas corpus. Well, the lawyers practicing in the high courts know very well, and many actions are brought as. Sorry? What is that? I am coming to the writ of mandamus as well. Firstly, writ of habeas corpus, and then the writ of mandamus. Then you have the writ of prohibition, writ of quo warranto, and then writ of certiorari. Now, through these, we would exercise and then vindicate our fundamental rights whenever a citizen's right is violated. Writ of habeas corpus is where a person is detained illegally. It can be by the state authority or it can be even by a private person. Now, this is the only writ which is even which can be issued by the High Court or the Supreme Court, even against a private person. So, if a private person illegally detains a person, then anyone can bring an action and approach the court of law, and the high courts would issue necessary directions to produce the person before the court. And so long as the detention is not lawful, then a person would be entitled for a issuance of a writ of habeas corpus. Then the mandamus, as you were just mentioning. Now, mandamus means literally it's a command. Mandamus is a command. So the court directs where an action is found to be illegal upon consideration by the court. The court declares that action to be illegal, and mere direction of a declaration may not actually be helpful for a ultimate relief. So the court would furthermore give a direction to perform their duty, the executive, in a particular manner. So that is called the mandamus. It is a command. It is an order of the court that you shall do this in this particular manner. Is what is the writ, which is called the writ of mandamus. Then next is the writ of prohibition. Now, writ of prohibition and writ of certiorari, they virtually go together. A judicial body or a quasi-judicial body, when it acts in excess of its jurisdiction, or where the authority refuses to exercise their jurisdiction, either the quasi-judicial authority or the courts of law, then the issue comes. The writ of prohibition comes where the proceedings are pending. The proceedings are actually pending before a quasi-judicial authority or the judicial authority. It has entertained a petition or a cause without that particular authority having actual jurisdiction. Then you come to the court of the Constitutional Court seeking a writ of prohibition. So you would you make a prayer to prohibit that particular authority or the court concerned from proceeding further with that matter, because that authority does not have the jurisdiction to do that. Now, suppose the citizen has not come before the court at the time when the proceedings were going on, and finally the final order has been issued. Then you challenge it by a writ of certiorari. So you will challenge the order seeking a declaration to set aside, to call for the record and to set aside that order passed by either the quasi-judicial authority or the judicial authority, and to declare it as null and void. Now, in exercise of Article 13, as I was telling you, Clause 1, that saves the ex post facto laws which are consistent with the Constitution and which are not consistent with the Constitution are void. Now, there the constitutional courts employ various methods of interpreting to the extent of, it is called the doctrine of severability or separability. The doctrine of severability means only that part of the law which is offending the Constitution, if it can be separated by saving the rest of the provisions, then that can be saved, and only that part of the offending provision of the statute is struck down. So this is how the doctrine of severability or separability is also applied. Now, the writs as they were, that were issued, used to be issued in England, and the current writs which are being now employed in the in Indian system are entirely different. There, the writs could be issued only with regard to an executive action, but writs could not be issued to annul a legislation. That means to strike down a law saying that a law is arbitrary or unreasonable. Whereas Indian Supreme Court as well as the High Courts, by exercising the power of judicial review, they have started reviewing even the validity of a legislation on the touchstone of Article 14. Now, before we go to Article 14, I want to touch upon this phrase called rule of law. You all keep very often listening to the rule of law, the quoting rule of law. But what exactly is this rule of law? 1885, Professor A.V. Dicey has first propounded this rule of law. He said this rule of law has got three connotations. One is equality before law. The other is equal protection of laws. Then the third is the predominance of legal spirit. He had defined, keeping in view the system of the functioning of judiciary in England, and keeping that in mind, he said all people are equal before law, and therefore that is the equality before law. Now, what exactly is equal protection of laws? This is the second facet of the rule of law. Equal protection of laws means that all citizens of a country are subjected to one single law, which means that it's, he said, right from the constable up to the prime minister, for a distinct offense or a violation, they are dealt with under the same law. There is no separate law for a constable and a different law for the prime minister. This is what they mean, that equal protection of laws means. Then next is the predominance of legal spirit. Oh, according to Professor A.V. Dicey, the British people, for them, the Constitution was never written for them, and he says that the Constitution, just after waking up one fine day, that they did not find the Constitution, whereas over centuries of their intellect and caliber, that this constitutional law has developed. So every British citizen, there is legal spirit in the flesh and blood of every British citizen. That is how the predominance of legal spirit. In our parlance, in the democratic parlance, we can call it as respect to law. Adherence to law is predominance of legal spirit in that respect. Now, when Article 14, under Article 14, this embodies, one of the principle it embodies is the rule of law. The rule of law and the equality before law, equal protection of laws has been interpreted that where the arbitrary actions, executive actions can be struck down. And thereafter, whether the legislative actions of the parliament can also be struck down by way of a judicial review was a question. Now, as the 1947, as we got the independence, now the country was by then already impoverished. I'm just narrating these aspects because when we go to a lot of these land reform statutes which have been brought about since 1950 onwards, now they have directly offended with the provisions of the constitution, particularly the fundamental rights, and more particularly 19(1)(f), that is the right to property. So what is the significance is that when we got the independence, by then the British looted us, the country was so impoverished, our leaders have realized that 85% of the people were below the poverty line without any property, and 15% of the Indian population has held the entire landed property in their hands. So there was too much of a disparity between the landless and the landed. So unless we remove this disparity, the Indian society cannot progress further. So the parliament has decided to bring in certain land reform statutes, and it has also guided various state governments also to enact land reform statutes where ceiling limit has been put. So a single individual cannot hold more than say 5 acres of dry land and 2 acres of whatever it may be. So this is how the land reform statutes were to be brought in into existence. Then we have Article 19(1)(f) dealing with the properties. Right to property is a fundamental right. Now, when it is a fundamental right by agrarian reform, land reforms, whether the government is entitled to take away the land from the owner beyond a particular ceiling limit. So if somebody has about 25 acres, he will be entitled to keep only 5 acres and give back the 20 acres to the government so that that land can be distributed to the rest of the people. Now, how can this be achieved? Article 13, which says that you cannot abridge or take away anybody's fundamental right. Article 19(1)(f) guarantees a person to hold property. Right to acquire, hold and dispose of was a fundamental right, 19(1)(f). Now the Supreme Court has seen the difficulty that so long as this fundamental right of 19(1)(f) is in existence, then it cannot allow the government to take away the right to property of an individual. So various interpretations have been given, and finally in Shankari Prasad, thereafter in Golaknath, finally the court said that you cannot take away the fundamental right. Then the parliament has amended the statute to the effect that right to property will not be a fundamental right anymore. Now, will the parliament have the power? The Article 13(2) directly hits at the action of the parliament because parliament cannot take away the right, or even the state legislature cannot take away the right to hold property. Now, here again, by great social engineering, the Supreme Court has devised methods, and it has interpreted the statute saying that in public interest, the state has the power to annul or abridge the right to property and take it away and repeal it from the fundamental rights chapter and place it as a constitutional right. Article 300A has been enacted. So thereafter, the right to hold property was no more a fundamental right. It has become a constitutional right under 300A of the Constitution. Now, in this process, in state of Kerala, Land Reforms Act, Kerala Land Reforms Act of 1963 in which there was a ceiling limit that was fixed for individuals. Now, by amending the act, this was applied even for any institution also. So, this is a religious institution which was headed by Sri Keshwananda. Keshwananda Bharati was a religious head of the mutt. And the property which was given to the mutt by way of donations by various persons, the mutt held enormous property in its hand. Now, by this legislation, all this land was sought to be taken away. Now, he is the one who brought this action before the Supreme Court. By then, the Supreme Court has already ruled that in Golaknath, that the government has no right to take away the property. But the previous judgments of Shankari Prasad, Sajjan Singh, and so on and so forth, although they have upheld the right to take away the property, in Golaknath, all that was set at naught, which means that that right has been, again, the right to hold property was restored again to the individual. And by way of prospective overruling, because by then there were several land reforms, agrarian reforms which have taken place, and these agrarian reforms could not be rolled back because a lot of the property has been taken away by the state by then, and it creates a lot of confusion to give back the property. So Supreme Court has laid down this principle of prospective overruling, which means that the previous decisions have been overruled, but legally, actually, the effect of overruling is that it dates back to the very first situation itself. That is going to create a lot of confusion. Therefore, it said that all these judgments are overruled prospectively. That means from today onwards. From today onwards, the previous judgments will not have any effect. It is only to that effect. Then, in Keshwananda Bharati, having regard to its importance, it is a bench of the highest number of judges. 13 judges have sat. The Attorney General was Niren De, and you all heard of H.M. Sirwai? Have you all heard of H.M. Sirwai? Yes. Sirwai was the Advocate General for State of Maharashtra, but he is the one who led the majority argument on behalf of the state government and the central government. Now, on this side was Nani Falkiwala, Chagla, Daftari, Soli Sorabji. Soli Sorabji must have been a very junior advocate by then, but this is now what was being considered is what is the amending power that the parliament has, that it can amend, whether it can amend the fundamental right itself. So what kind of power? Because actually Article 368 that deals with, it lays down the procedure for amendment. But the government intends to give an interpretation that it gives the power to the parliament to amend. Then what kind of power does the parliament have to amend the constitution? The argument of Mr. Sirwai was that except short of repealing the constitution, parliament has got unlimited power to amend the constitution, which means except repealing, wiping out the entire constitution itself, except that power, parliament has got every power to repeal, to amend any part of the constitution, was the argument that was put forth by Mr. Sirwai. He is also a very great constitutional law expert. Now, on the contrary, Nani Falkiwala, who was representing the writ petitioner, Keshwananda Bharati, his argument is that the parliament, this is a procedure laid down to amend the constitution, and the power to amend the constitution has its own limitation. Then what is the limitation? He says that there is a basic structure to the constitution. Basic structure means we as humans, we have a skeletal structure. Without having this skeletal structure, the bones which hold us in a particular shape with head, hands, legs, and so on and so forth, without that, the body itself will collapse. So one has to have a basic structure. So Parliament may have the power to amend the Constitution, but that power is only limited to amending certain provisions without disturbing or destroying its basic structure. Say if one leg is removed, what happens? The body collapses. So the Parliament doesn't have the power to remove or amend any part of the Constitution by which the whole edifice of the Constitution itself will collapse. So then where does it get this power? He said it is not written anywhere in the Constitution, but it is by way of implied limitation. The power is implied. It is not written anywhere in the Constitution. The power that Parliament has got so and so power and so and so, it does not have so and so power, is not written anywhere in the Constitution, but it has, we have to understand that it is by way of a implied limitation, that the power of the Parliament is only restricted to that extent, that it can amend the Constitution, but while doing so, it cannot destroy this basic structure I was just mentioning. Then when it says it cannot destroy the basic structure, what is the basic structure? What is the basic structure in a human body? The basic structure are the bones, the skeleton which holds the entire body in a particular shape is the basic structure. For the Constitution, then what was the basic structure? The court said preamble of the Constitution is a basic structure. Why preamble of the Constitution is a part of the basic structure? It is because it is a very small, just a few phrases, but then it has a lot of meaning. Now, firstly, it is the Constitution, it paves the way to create the Constitution because it starts with we the people of India. So, firstly, the contract is, it is not between some power like the king or anybody, but it says the power is vested with the people. The people of India are drafting this Constitution. So it gives the power to the people of India to draft the Constitution. So the persons who have drafted the Constitution are also people of India, and that is how it is on our behalf that the Constitution is being drafted. Now, most importantly, apart from that, then we bring to ourselves by adopting this Constitution, it says. So the enacting clause by which the Constitution itself has come into existence is because of this phrase which is there in the preamble. It has the enacting clause. It finally says we have drafted this Constitution and then we are adopting it. So it is only by that adoption that the Constitution has come into existence. It is only by that. Therefore, preamble is a basic structure of the Constitution. Then the three organs of the state functioning under the Constitution with their well-defined powers and functions is a basic structure of the Constitution. The three organs of the state, they have to function within the four corners of how their powers have been defined under the Constitution. So this is a basic structure. Now the rule of law, they said, is a basic structure because it is enshrined and it goes like a common thread throughout the provisions of the fundamental rights of the Constitution, and therefore the rule of law is a basic structure. Well-defined powers has powers which are separated between the three organs of the state. So separation of powers is a basic structure. Basic structure in the sense of in whatever that our Constitution has contemplated, because it is slightly different from the basics, the separation of powers contemplated in the United States Constitution. But they said that the separation of powers by way of checks and balances is a basic structure. And then it goes on and on, then the fundamental rights, then the federal principle of the two-tier form of governance of the center and the state. Then the three lists that we have, well-defined union list, the state list, and then the concurrent list. These are all the basic structures. So now what has been laid down is that the power of the Parliament has now come to be well defined, that it is limited but it is not unlimited. So this is a landmark judgment we, for our current generation, you see, we need not be much bothered about how this principle came to be evolved. But since the evolution of this principle of basic structure and then the theory of implied limitations, now it has opened a new era, a new beginning to the Constitution itself. If you ask me as to name one judgment which is laid down by the Indian Supreme Court, which is in fact as important as the Constitution itself, I would say that it is a judgment rendered in Keshwanand Bharati's case. That it is because it has entrenched, it has consolidated the concept of constitutionalism, the supremacy of the Constitution, the limitations of the Parliament to control and to define its powers to amend the Constitution. You know, the attacks which have happened with regard to the provisions of the fundamental rights and several other provisions in the Constitution during emergency time by bringing in the 42nd Amendment. Now, all these have also come to be well defined to the extent that the Parliament, the power of the Parliament, in fact, if we would not have had this principle of basic structure and then the theory of implied limitations in this judgment was rendered on 24th April 1973. So it is only by application of this principle that several attacks that are made to the fundamental rights and other provisions of the Constitution during emergency time could be set at naught subsequently. Now the power of judicial review and then the theory of basic structure as propounded by the Supreme Court is a very ingenious social engineering by which we have consolidated our democratic and constitutional systems in our country. Now, our future generations, maybe for 200 years and 300 years, 500 years later also, can confidently say that this constitution will survive. This system will survive, the democratic system, the constitutional supremacy will survive. It is the Constitution which is the supreme, and there is no other body which is more supreme than the Constitution itself. This is the concept that we have to understand what has been evolved through this Keshwanand Bharati's case. Something which is very innocuously started as just a repetition, finally has become a principle of constitutional law and so fundamental to the governance of this country. Now, the democratic systems, we have our own, the setbacks in our democracy, but still, to say 70 years successfully, we've been carrying on with our democracy in whatever manner it is possible. But one thing is guaranteed, that this will continue. Democracy is also a basic structure of the Constitution. Adult suffrage is a basic structure. Then rule against arbitrariness, bias, all these have become well entrenched into the principles of constitutional law. So, you must all be waiting for your sumptuous lunch also. So, I would have time. Any questions if you have? Yes. Due process. Okay, I'll tell you that. Our friend's doubt is that Article 21, it says that no person shall be deprived of his life or liberty except by the procedure established by law. American Constitution Bill of Rights, 5th Amendment and the 14th Amendment, it also says more or less the same, except that it says that no person shall be deprived of life or personal liberty except by a due process of law. Now here, one has to go a little behind. At the time of drafting of the Constitution, the fundamental rights chapter was being drafted. It was V.G. Rao who was actually looking into Article 21. And then he was asked to interact with several judges in various countries. So he consulted Justice Frankfurter of US Supreme Court. Justice Frankfurter has remarked that yes, we by then already almost 150 years of the Constitution of America that was functioning already. So he said the constitutional experience in United States is that this due process is a very mischievous phrase. What is due? Due process means whatever that is due. So anything, a broad-minded judge can be very, very activistic in enlarging the scope to such an extent, whereas a narrow-minded judge or a judiciary can limit its scope to such a narrow extent that it can deprive the life and liberty of an individual. So he said this phrase is a very mischievous phrase. So he suggested that instead of this, you incorporate something else in the alternative. Due process as such has got two connotations. One is the substantive due process, the other is the procedural due process. So the one which can be an element of mischief is the substantive due process. So our constitutional framers thought that they will limit it. They will limit our life and personal liberty only to the procedural due process. So they have borrowed from Article 11 of the Japanese Constitution that was carried. And the Article 11 of the Japanese Constitution says that no person shall be deprived of his life and personal liberty except by a procedure established by law. So this is how this has been brought in this manner. So by this what happened is the substantive due process could not be brought in. So that was done very consciously by our constitutional framers. But there is an underlying twist also to it. Though this substantive due process has been eliminated from the Indian Constitution at the time when the Constitution was drafted and has come into existence, the constitutional framers did not understand, or rather they did not perceive the effect of Article 14, which gives unlimited power to the Supreme Court and the constitutional courts or high courts to strike down any arbitrary action, be it legislation or be it an executive action. Because arbitrariness is dealt with under Article 14 because of the reasonableness. So in fact, the Constitution, though it limited the under Article 21 to say only procedure established by law, which means that so long as the government follows the procedure in order to deprive the life or personal liberty, then if that procedure is followed, then the courts cannot do anything else. Even if the procedure that is followed is arbitrary, but still the procedure, since it is laid down in the law itself, then the court could not actually strike down any arbitrary actions because it is already a part of law. Whereas in America, under substantive due process, they could test the legislation on the touchstone of reasonableness and justness. It cannot be fanciful, it cannot be irrational, it cannot be despotic, in the sense very, very unilateral and so arbitrary that it deprives the life or liberty in a very unreasonable manner. In India, that was not available originally. But then thereafter, in the interpretation that was given in Maneka Gandhi's case, that substantive due process, which was originally removed, and only procedural due process was incorporated into the Constitution as the procedure established by law. The substantive due process was brought into the Indian Constitution through the back door, which was never intended by the constitutional framers, but the Supreme Court has brought it in by sheer interpretation in the form of judicial review. So in Maneka Gandhi's case, it said that because, as you all know, that the passport was impounded. Passport of Maneka Gandhi was impounded. She was a journalist. She wanted to travel abroad. When she was planning to travel abroad, the passport that was already issued to her was impounded by the authority, not allowing her to travel abroad. The challenge was with regard to freedom of movement, as well as with regard to the substantive right that that the officer cannot cancel my passport or impound my passport without giving a show cause notice to me. Reply given by the authority was that the Passport Act does not deal with a situation where if the officer wants to cancel the passport, the officers are not bound to ask for reasons or give any show cause notice. So there the Supreme Court has said that even in absence of a law, one has to follow the principles of natural justice. So this is how the substantive due process has been brought in. Sorry? That is with regard to center-state relations. Center-state relations under Article 254. That is not the topic of today. That only deals with the power of the governor in calling for the test and other things. So that can be dealt with in some other date. That's again a huge topic. That is not touching upon any fundamental rights. Thank you very much.
Then, excuse me.
Thank you, sir. The spellbound without looking at the book and also pen any paper. You are beyond our expectations. Give a big VR Reddy wants to say something, but was short of time. We will reserve. And that's what. 1 minute only.
With the permission of my Lord Ramakrishna Prasad and Chairman Bar Council, if my Lordship may not say that it may not be exaggerated, if I say something about my Lordship's lecture. Lord, generally, is there anyone to hear about what is this Justice Rohington Nariman's lectures? Generally, I used to hear through what is this videos. What is When I was hearing about the lecture which was being delivered by my Lordship Justice Ramakrishna Prasad Garu, I saw Justice Ramakrishna Prasad in the what is the approach and everything like Justice Nariman's speech. Today only I heard about the lecture which was delivered by Justice Nariman about the basic structure. Knowingly or unknowingly, while I was walking, I used to hear watch these videos and other things. I used to tell my daughter, who is also prosecuting at second year law, I used to say that we cannot find such a person like Justice Nariman who can deliver lectures without looking into paper and anything and referring all the ancient laws and other judgments and other things. Today, I saw the same exposure, everything in my Lordship Justice Ramakrishna Prasad. My Lord may not be considered this as exaggerative, but this is my opinion. I thought that being a Bar Council member, it may not be fair on my part to express my gratitude to your Lordship.
Thank you, VR. I request VR and Chidambaram to come on to the dais. Next session will commence before the lunch break. We'll finish and then go for lunch because only another session will be there because time is running out. Please kindly cooperate. Next session will commence.
Before starting the next session, a small announcement. We have found a lost ID card of Mr. Sudhakar Karra. I repeat, we have found a lost ID card of Mr. Sudhakar Karra. Please do collect it from the organizers. I now request Honorable Sri Justice A. Rashekar Reddy Garu, former Judge, High Court of Telangana, to come over to the dais and adore the chair. I request Sheikh Sajida to accompany Honorable Sri Justice A. Rashekar Reddy Garu. I request Mrs. Nupur Agarwal to present a sapling to Honorable Sri Justice A. Rashekar Reddy Garu. I now request Sri Venkar Ramareddy Garu, Member, Bar Council of AP, to come over to the dais and adore the chair. I request Sri Sindhu to accompany Sri Venkar Ramareddy Garu. I request Ms. Chandani Chowdhury to present a sapling to Sri Venkar Ramareddy Garu, Member, Bar Council.
Justice Rajshekar Reddy Garu, my friend V.R. Reddy, and other friends in the Bar Council and advocate friends. Rajshekar Reddy Garu, because I will take very short time because available time I don't want to take. I have opportunity to see my lords when at the bar, and I have an opportunity from the date of his elevation till date of retirement, and always is a human, and I can say he is a popular judge at that time. And popular, it is very difficult to become a perfect judge and popular judge. I can call him as popular and perfect judge. I call upon Justice Rajshekar Reddy Garu to present on the arbitration law and practice.
Esteemed brother Justice Ramakrishna and the learned Gantaram Rao, V.R. Reddy Bar Council member, other Bar Council members, my esteemed colleague Suresh, and my dear students, senior advocates, as well as advocates, and my dear junior advocates. It's my privilege to be here because at the time of separation of high courts, many of the advocates from this place requested me to opt for this place. I had an idea also, but I do not know because I am born and brought up in Hyderabad. So I had to opt that place. But anyhow, this is the chance for me to come here. My colleague Suresh was asking me for a lecture in the bar association, but somehow it missed because I was a little bit busy and summer vacations are going to start. So Bar Council of Andhra Pradesh has invited me. It's a privilege to be amongst you. And after lunch and before lunch, it is very difficult to speak. That too, my esteemed brother Justice Ramkrishna Prasad eloquently, without looking into book and paper, extempore lecture he has delivered. So I am not that competent in a way, and that too before lunch, because I'll be violating your human rights if I delay your lunch. At the same time, if you don't deliver proper lecture, I'll not be doing my duty. So in between, I am caught. Now I'm thinking what to do. So in such a precarious situation, I am here before a very eloquent speaker for lunch, and so anyhow, I'll try to do my best. Because some students are also there, and this arbitration subject, I think many of you might not have in your syllabus because we didn't have that subject when we were dealing with when you are studying law. Students are there whether you have the subject. Now you are having that subject, so you'll have idea what is meant by arbitration, because after retirement I am doing arbitration. If I do anything, if I am pro arbitration, you may call me because after retirement you are doing arbitration, you are arbitration. So it's not the case, because sitting as a several application under section 11, because you had a subject, they were pending for 10 years applications, and the lawyers used to come with loads of books saying that we want to argue. I said, I am not deciding your list. Then they were not able to is there to decide list only. Don't get confused. I am here only to appoint arbitrator, not to decide entire lists. You are coming books. Purpose of arbitration, to see that there is an existence of arbitration clause between the parties. I used to ask, read the contract, where is the clause? Then I asked whether you admit or you submit. That way I said, but then both lawyers got satisfied, then they used to choose there. I said, it's a choice. You can choose your arbitrator, any judge, any person like that. So that is what is arbitration? Arbitration is to determine. In Latin, arbitrary means to determine. Why all this determination required? From the beginning, human society, between two human beings, always there is a difference of litigation is bound to come. Differences are bound to come because with son and daughter, son and father, there will be disputes. Husband and wife, lot of disputes. Several disputes are there. So we can't imagine a society without disputes, because people say Ramarajyam, earlier Mahabharata time also there were disputes. So in ancient times also courts were there. They were called Pugas, Srenis, and Kulas, popular courts. And even in those days when litigation was very less, different countries have arbitrations because it is a different system. Alternate resolution was in existence from the times immemorial, not in India but in other countries also, because people thought that is the best effective, less cost effective, which is required for the society. Even in ancient India, also panchayats were there. Several trade matters were decided by the arbitrators. For that matter, sitting in the lap of my grandmother, We here in the courts, we sit on the dais. And villages, they used to what you call Rachabanda. My grandmother used to sit, and my father used to sit at Rachabanda, and I used to sit in the. People used to come and tell their problems, other things, oral executions. And sometimes no. So that is not new. Arbitration concept of arbitration is not new to us. I have witnessed, and most probably from villages. Most of you coming from the village background, you might have witnessed. So, and this arbitration for without reports used to be followed in villages by traditions. And for the first time in India, after the British scheme, the enactment 1899 enactment, and it only extended for few cities, Bombay, Calcutta, and Madras. So after that, civil procedure code schedule 2 also contains it, extended to several other places, and but it was not found expedient, and also they dealt with some certain aspects of the arbitration. So Arbitration Act 1940 was enacted, keeping in view Arbitration Act 1937 of the British, that is English Arbitration Act. And 1940 Act also, many of you, I think some of the matters under the old Act 1940 also was pending. Though arbitration was meant for quick, effective, and less cost-effective measures, 1940 Act was dealt in such a way that there is a lot of judicial intervention. At every stage, litigation cropped up, and mostly dealt with only domestic arbitrations. And the other two enactments, that is Arbitration Protocol and Convention Act 1937 and Foreign Awards Enforcement Act 1961, these were also in place. Those two enactments dealt with the enforcement of foreign awards. And ultimately, not lawyers I call, but legal philosophers, the trading community, they are not satisfied with the working of 1940 Act or the two enactments. So ultimately, the Parliament thought it fit that an effective system is required. And at the same time, the international trading community and the UN Assembly, General Assembly thought it fit that a comprehensive legislation covering the international commercial arbitration for the enforcement of foreign awards is required. So it established a United Nations International Commission on Trade Law, and it has recommended a model law which should be adopted by all the member countries. Because why litigation? You know that the world trade and all their aspects, there is a lot of litigation. There is no uniformity in arbitration laws, so they wanted a uniform law. For that, UN Assembly through United Nations Commission on Trade Law has framed a model law, and many of the countries have adopted the same thing. And keeping in view that 1996 Act was enacted, initially ordinance was issued, later the same was enacted, minimizing the role of the courts in deciding the arbitration matters. So several, even after 1996 Act, the same was amended in 2015, 2019, 2021, which shows that there is a lot of stress on our judicial system. And the other day I was hearing a lecture by His Lordship Justice Nageswara, former Judge of Supreme Court, wherein His Lordship quoted that it takes 326 years for deciding the present cases which are pending in our courts. And there are 5 crores of cases pending in the entire country. In Telangana, there are 2.5 lakh cases pending, and in Telangana 10 lakhs cases pending. Here I am told that 2.5 lakhs, almost around 2.5 lakhs cases pending in High Court. I do not know what is the pendency in trial courts. So imagine it takes 326 years. So one of the purposes is to reduce the load on the judicial system, because our litigation in the courts were compared to pressure cooker by one of the Chief Justices. What happens if pressure cooker, if you don't, doesn't have a valve, it bursts. Even our judicial system also, if you don't have a valve, it bursts. You know very well now, many of the civil litigations, small matters, they are not coming to courts, thinking that it will take years, and no one can tell this litigation will be disposed of in from starting from junior civil judge up to Supreme Court. It may take generations, and as lawyers, you are all aware, you are experiencing also. So for that purpose, this alternate dispute resolutions, which was prevalent in India and other countries, was given a legislative mandate, and ultimately 1996 Act was enacted. And one more aspect is, a country with effective judicial system doesn't include only courts. And the litigants want their disputes resolved in a quick manner, maybe in the courts or arbitration, and as provided in Section 18, and because in 2002 amendment, Section 18 also provides for arbitration and mediation, conciliation, judicial settlement through Lok Adalat. All those things are there, but while deciding, many times we forget about Section 89. There also it provides for. And apart from that, that's why legislature thought it for that a separate enactment is required, and Section 1996 Act is enacted. And Section and Section 8 is one of the important sections where, for example, I'll give you an example. Many of my friends who are lawyer friends also were asking me after retirement, what is the job you are doing? I said arbitration. Many of them are asking, are you giving the assignment of any arbitration post like that? Because many of them lawyer friends and non-lawyer friends, they are not aware what is meant by arbitration. Simple example, you want to sell your plot, you enter into a sale agreement. If any litigation crops up, you have to go to the court. If you introduce a clause, arbitration clause, if any litigation crops up, the matter can be referred to arbitration. That is arbitration. It may provide differently. Each party may have one arbitrator, and both of them may select a presiding arbitrator. And provisions of Arbitration Act, now presently 1996, covers the litigation, and they are tribunal is bound by the same thing. So sometimes what happens, even with the arbitration clause also, parties approach courts. When the matters come before the courts, and lawyers also, sometimes they file it. They should be careful when arbitration clause is there. They should go only for arbitration. If parties agree with consensus, an arbitrator can be appointed. If 3 arbitrators are there, each party can appoint one arbitrator, and in turn they will appoint a presiding arbitrator. In case of any there is no consensus under Section 11, they can go. But sometimes deliberately they file before the civil courts, even though the arbitration clause exists in the agreement. the matter, when the arbitration clause it can contain, the matter has to be referred to arbitration, provided certain conditions are satisfied. First is that there should be agreement, and the subject matter, the action before the judicial authority should be the same. And third is that they should enclose a copy of the arbitration agreement and also a certified copy of the same. If you do not have, an application can be filed saying that the arbitration agreement is with other party. Provided that certain conditions are satisfied, the matter can be referred to. That too, the objection is raised before filing the first defense statement, written statement in the suit. If the conditions are satisfied, then the civil court has to refer it to. Only the parties admit there is an arbitration clause. And those section is very clear, but the judicial interpretation is that if it is not an arbitrable dispute, which arbitrator cannot decide, so there is no purpose in referring the matter to arbitrators. For example, some criminal matters or trademarks or rent control matters where the Rent Control Act it has to be decided. That matters cannot be referred. That is the purport of Section 8. Then comes the Section 9. Many times these lawyers get confused between because if there is any urgency in the matter, they say straight away file civil suit and obtaining injunctions. But there is another provision, Section 9, providing for interim measures. There you can go to civil courts and say that there is an arbitration clause. We have intention to initiate arbitration proceedings. So meanwhile, the subject matter of the arbitration has to be protected. There are several measures for effectuating the arbitration. Then they can say that and obtain interim orders. And provided that after amendment 90 days, they have to commence the arbitration proceedings. Section 9, that is in Section 9 and 8. So several times they go straight away file suits. So the other side has to file an application. Again, the matter has to be referred to arbitrate. If you should know the distinction between Section 8 and 9. You can approach the court, but only thing is, it's only interim measure, pending arbitration proceedings. Then Section 10, only appointment of arbitrators. It should be even in number, one or even in number. And Section 11, if there is no kind of an arbitration clause provides in agreements, but there is no consensus, then under 11, they can approach the High Court in case of domestic arbitration, in case of international commercial arbitration, Supreme Court. And Section 11 and 8, at the stage of referral stage, several judgments have come from SBP, Patel Engineering Company, and Dura for Gangavaram Port, Vidyadoli, and Chloro Controls. Several cases under Section 8 and 11 were interpreted, and Section 11, the amendment Section 6A, 11, 6A also came into place, which said that only existence of arbitration has to be seen at the time of referring the matter to the arbitrator or appointing the arbitrator. So with later judgments, Vidyadoli and subsequent judgments also said that prima facie test to deadwood, completely barred by limitation, that also can be considered. Otherwise, there is no purpose in forcing the party to arbitration. And of Section 11, and that Section 11 applications have to be disposed of within 60 days, but unfortunately, those are all taking years together, decades together, and lawyers want to argue that Section 11 application as if deciding entire list. So I had to at least appoint 100 retired judges and as arbitrators. And many a time what happens, I used to convince them, when in case of doubt, matter has to go to arbitration. Even otherwise also, the advantages of arbitration, you see that, as a sitting judge, I had to decide daily 150 to 200 cases. And now as an arbitrator, I have a few cases. And one specific performance suit, I heard for 3 days satisfactorily to satisfaction myself and also to satisfaction of the lawyers. In the court, it was not possible also. I had to cut short. That is the advantage. So some matters, and very well, I used to tell the lawyers, Now we have a choice. You can select either retired High Court judge or Supreme Court judge or any judge, district judge. Sometimes the matter may go to before a junior civil judge. I don't say junior civil judge are not competent, but experience otherwise you count. You have better advantage. You need not stand in the queue. That is advantage. And it is not lost to the advocates also. And many times, even when I was a lawyer also, we used to feel that if alternate ADRs are adopted, they lose their briefs. It's not so. Arbitration also lawyers are involved. And in fact, I appointed lawyers as arbitrators. In fact, when I was asking lawyers when they appear before me, they were hesitant. When I asked them, you don't have confidence in your lawyers itself. They said, no, parties are said. In small matters, initially I started with less than 10 lakhs, juniors, more than that, advocates, some senior advocates, and some judges, because regularly they want retired judges. So it depends upon reputation in the profession. As a judge also, I have seen reputation of lawyer. In appointing an arbitrator, also reputation of judge we see. And even when consensus is there between the parties, they see the reputation of judge. Judge is always honest, but think they call now honest judge also. So while appointing also we have seen like that. So the advantage between regular court and arbitration is now you need not stand in the queue. Other in the court you have to stand in the queue. How best it is your case, if a specific performance suit is there, you have to stand in the queue. But arbitration is not there. It's only confined to that arbitrator few cases. So for quick disposal. That are the advantages. So I used to convince the lawyers. So then they used to agree, and even the parties, they used to put their parties and say that we're agreeable for arbitration. So that is the where you can utilize the services. And it's always an appointment under Section 11. You can always suggest the names of judges or any person. Arbitrator can be any person. Now Section that Schedule 8 is repealed. Section 43J, Section 8, Schedule 8 is repealed. So any person can be appointed as a judge. But preferably, most of the time, lawyers and judges in technical matters, engineers, in some accountancy matters, some chartered accountants are appointed. And there is also provision in the Act for seeking the assistance of the experts also for arbitrator. Since the time is short, I am giving a general outline of the Arbitration Act. And arbitration, you know very well, even if the award is rendered by the arbitrator, time limit is fixed within 1 year from the date of completion of the pleadings. And even for completion of pleadings, time is fixed. Many a time we are not following that is different aspect. Because our attitude, what is there in the courts, is always reflected before the arbitrator also. So, but there are a lot of advantages. And other thing is, you should understand, members of the bar, if 10 cases are given to a lawyer, because of pendency, 10 cases are not disposed of. Next time, he will not come to you. He will go to different lawyer. He also can't do anything because pendency of lawyer. Next time, he will not come to the court. Who will be the loser? Bar is the loser, not judges are. So at least some cases are disposed of through arbitration, through some mediation, conciliation like that. Where even mediation also lawyer can be trained, even conciliators also lawyer can be appointed. So you need not be afraid. In other countries like US, Singapore, where most of the litigation by way of conciliation before it comes to the court, it is decided. And members of the bar are flourishing in US and other countries. Singapore is the seat of arbitration because court intervention is very limited there. And they prefer that seat of arbitration will be at Singapore. So these are the advantages of arbitration. And Section 11 provides the time limits. And Section 12, the arbitrator should say that is impartial and he has to give certain things. In 13, the arbitrator can be challenged. 14 is termination of proceedings. 15 is substitution of arbitrators. So an arbitrator cannot perform his functions. But the party doesn't want an arbitrator. And Section 15, a substitute arbitrator can be appointed. And when I spoke on Section 8 and 11, only prima facie view about existence of arbitration clause. If the court is in doubt, then it has to go for arbitration. So the remedy of the party, because it's only prima facie view under Section 8 and 11. as held by Vijay Doli and Gangavaram Port, other major decisions, is only prima facie. Under Section 11, competence rule. That is, arbitrator now can go deep into the matter to find out whether there is a valid arbitration agreement. Section 16 you can raise all those aspects, and in case of frivolous arbitrations, it can be thrown out at that stage. And Section 16 1 and 2 provides that even if main contract is rendered void, still the arbitration clause has independent existence, and it can be looked into. Likewise, Section 17. Earlier, what used to happen when the matter is before arbitrator, any emergent situation, any interim measure, for example, a suit is pending before court, you want any interim measures, interim injunction, or order attachment before judgment, or anything urgent nature, arbitrator was not clothed with the power. After introduction of Section 17, same powers as under Section 9 were conferred on Section 17. Under Section 17, the only difference is during the pendency of arbitral proceedings after amendment. Earlier it was before enforcement, because after once the award is rendered, the arbitrator becomes functus officio. That is the reason Section 17 was amended. During arbitral proceedings, you can approach the tribunal for interim measures like injunction, appointment of receivers, several aspects. And even if you find that the remedy before the arbitrator is not efficacious, you can go before under Section 9. Because under Section 9, it provides remedies before or during and after passing of the award before it is enforced. That are the safeguards given to Section 17. And the interim orders granted by the tribunal and the final award granted is also deemed to be order of the civil court, and it can be enforced as an order of the civil court. And arbitrator can also take assistance from the court for leading evidence on certain aspects. And Section 19, you know very well the procedure. One of the advantages of arbitration is when you go to regular courts, cumbersome procedure under Civil Procedure Code 1908 has to be followed. And under arbitration, you can prescribe your procedure. Parties can prescribe, unless it is opposed to law, they can have a different procedure. And Section 19 provides that tribunal is not bound by the Civil Procedure Code or Indian Evidence Act, and both parties can agree on certain procedures. If there is no consensus, tribunal can follow the procedure which is in tune with following the principles of natural justice, and tribunal can decide regarding admissibility and other aspects of the matter. Section 20 regarding place of arbitration. When one seat of arbitration is decided, the place can be decided by parties, and with the consent of parties, the parties can choose the place of arbitration. Place of arbitration can be at any place. So that is the advantage in the arbitration. And one of the important aspect is Election Limitation Act is made applicable to the Arbitration Act. And what is the starting point of limitation? Section 21 provides for commencement of arbitral proceedings. That is issuance of notice by one party to other party. After receipt of the same, the arbitral proceedings commence. And from the date, limitation starts regarding arbitration proceedings. And you know very well, Section 23 provides for when the statement of claim and defense has to be filed within 6 months from the date notice is received by the arbitrators. And you also very well know that though CPC is not applicable, you have provision for counterclaim also, providing a comprehensive determination of the issues. And regarding hearings also, sometimes the oral hearings may not be required. The arbitrator may decide that no oral hearings are required. And basing on documents, both sides agree, the arbitration can go on. And in some rules, there is a fast track arbitration also, limiting the time. And the provision in Section 25 also provides that in case of default, the arbitrator can proceed or terminate the proceedings. And Section 26 provides for appointment of experts. Or in case it is a accountancy matter, chartered accountant can be appointed. If it is a technical matters, any engineer can be appointed. And Section 27 provides for existence of for taking evidence from the court. And the making of award, it should be signed by the majority of the members if it is more than one. And the time limit, Section 29A, that it should be within 1 year and the extension of another 6 months by the parties. And thereafter, you have to go approach the court and for extension of time, and sufficient reasons are shown, the court can extend the time. But many a time, with short experience as an arbitrator, but bar is in the same way, they are not giving much importance to arbitration, because disposal by arbitrator also disposal only, because it is as good as award. And another advantage is Section 34. It is not appealable like regular appeals before the court, only limited grounds. Section 34, you know, the limited grounds, where it is found that the dispute is outside the scope, decided outside the scope of agreement, the arbitration agreement is not valid, or no proper appointment is not made after giving notice, and proper procedure is not followed, only limited grounds. Those sections, the scope of Section 34 is expanded, but still the evidence can be reappreciated, and all errors of arbitrator cannot be corrected under Section 34. Because Section 5, you know that the judicial intervention is limited, except as provided in the Act. Section 34 is one of the exceptions where judicial intervention is provided. And now the amendment is there is no automatic stay. You have to file an application and obtain the stay. And Section 36, enforceability of the award. If the award has become final or confirmed, if it is unchallenged, if the limitation expired, it can go for before the civil court. And Section 36, subsection 3, proviso after proviso, there is an amendment, Section 2021 amendment, where it is obtained by fraud, whether the agreement or the award is obtained by fraud or corruption, then there can be blanket stay. So giving wide scope for the executing court to stay the award unconditionally. And Section 39 and Section 29B also provides for fast track procedure. And in different countries, we have different rules, and then a different nomenclature is given for different arbitrations. In our rules also we can frame and different kinds of domestic arbitrations. One is domestic arbitration, international and commercial arbitration, institutional arbitration, statutory arbitration. That is some of the enactments they provide for arbitration. So that act prevails over the General Act, that is 1996 Act. And ad hoc arbitration, fast track arbitration, look sniff arbitration, flip flop arbitration. These are different kinds of arbitration provided in the rules of different countries. And for the present, we have this fast track procedures under Section 29B and Section 30 settlement. Then one of the advantages of arbitration is the arbitrator can adopt any of the modes of ADRs, that is by way of mediation, conciliation, and facilitate the party to come to a settlement. And that settlement is also like an award, arbitrator award. And even before conciliator also, settlement can be arrived. And that is as good as arbitrator on merits. And form of contents of award. It should be signed and the place of arbitration should mention, the majority of the arbitrators should sign. And the reason should be given for non-signing of some of the arbitrators. And it also provides for grant of interest, form of award. Subsection 7 provides that from the cause of action till the date of award, reasonable interest can be granted. After the award is rendered, 2% more than the current rate of interest. And current rate of interest is as per Section 2B of the Interest Act. That is interest on deposits by the banks on the directions of the RBI under the Banking Regulation Act. And Section 31A provides for costs, regime of costs, that is arbitration costs, other things. The arbitrator can direct the parties to deposit the costs. And when the arbitration gets terminated, when final award is rendered, and it is terminated by the parties, or the arbitrator is unable to perform the functions, and he withdraws from the arbitration. And though there is no power of review, but Section 33 provides for amendment of award and regarding providing clerical mistakes, like Section 151 CPC. Additional award can be passed, and interim award also can be passed in the year of final award. So then the arbitral proceedings gets terminated. And one of the functions which I was saying is Section 34. The legislature did not provide for appeal, because the purpose is, if a regular appeal is provided, it will be like any other judicial proceedings. Initially, the very limited grounds were there, and subsequent amendments and latest amendments, the scope was widened. But at the Supreme Court, many of the cases held that under the guide of setting aside, you can't reappreciate evidence and correct all errors under the award. Section 35 provides for finality of the awards. That is when it has become final. It is without being challenged. Section 36 provides for enforcement as if it is civil court decree, and only exception is proviso, where blanket stay can be. And Section 13(7) provides for appeals against the Section 34, that is refusing or setting aside Section 34 against any interim measures under Section 9, and also orders passed by the arbitrator under Section 16, accepting that he doesn't have jurisdiction, and interim measures under Section 17, and from no other orders. This is also an exception to Section 5. This is Section 5. Section 5 of the Act says that no judicial intervention has provided. Section 34 is an exception. Section 37 is also an exception, where appeals are provided. And Section 37 clearly states that from no other orders. When a jurisdiction issue is raised before the arbitrator under Section 7, he does not accept the plea, then there is no appeal. One has to wait, and if the award is passed, he has to challenge the same under Section 34. If plea is accepted, then appeal lies under Section 34. Similarly, any interim basis are granted in 17, then an appeal lies. The scope of Section 37 also was restricted in the sense to see that at every stage and against every order of the arbitral tribunal, appeal should not be provided. Otherwise, you know what happens in the suits. Interlocutory applications are filed. The moment against that order, appeals are filed and the CRPs are filed. So, in the present case, also in some cases, there is an argument that whether writ is maintainable, whether petitions under Article 227 of the Constitution are maintainable. No doubt, Article 227 is very wide. Notwithstanding contained in any other provision in the Constitution, the powers can be exercised. When such is the power cannot limit the statutory. The statute cannot limit that power, constitutional power. But at the same time, the self-imposed restrictions which we have laid on ourselves, in case of alternate remedies, and efficacious remedies are provided. Normally, court will not interfere under 226 or 227. And the Section 38 also provides for certain deposits. 39, lien and arbitral award. The arbitrator has lien on the arbitral award, and in case of any dispute regarding fees, an application can be filed before the court, and that can be determined. And one of the special features is Section 40 of the Arbitration Act. On the death of the parties, the agreement is not discharged. It can be enforced against the legal representatives. Under Section 40 provides the same thing. And Section 42 says that in case of insolvency matters, other things, the matter cannot come to arbitration. However, the permission can be obtained if arbitral proceedings are commenced before or after the competent authority. Permission can be sought for continuation of the arbitral proceedings. And a jurisdiction, you know that against the filing of appeals, against filing of Section 34 applications, once an application is filed before a court in respect of any arbitration, that court will always have the jurisdiction till the completion against all the proceedings under the in that arbitration. And one of the features, Section 42A, confidentiality. Because the other day I was conducting the arbitration because on Saturdays lawyers will be free. So many of the lawyers came, we wanted all at 11 o'clock in the morning. I didn't notice the Section 42A, 2015 amendment. Just like call work, I called 4, 5, 6 cases. After everything is over, one youngster was pointing out to me, "Sir, arbitration is in confidentiality about to maintain." I said, "It's like a court, where is the confidentiality?" He said, Section 42A. So that is also advantage, because what happens in company matters, you see, the value of the shares. Because in court, what anything happens, it comes in newspapers, especially in high courts and supreme courts. In respect of big companies, in headlines it will come. Any observations of the court, any decision of the court, that will affect the market conditions. And some people feel it's prestigious because they come to the court, they are in litigation. That's the reason 2015 Amendment Act Section 42 capital was enacted. Confidentiality has to be maintained by the arbitrator, by the parties. Only when it comes to enforcement, if it's required, it has to be disclosed. So that is also advantageous. It will be between the two parties and the arbitrator. And all the three parties, the arbitrator and all the three, are prohibited from disclosing the information. That is one of the and the Section 42B. Because several times and court decisions will be challenged in the superior courts, and they say judge will be wrong, that and this. And for protecting, sometimes they may attack judge also personally. That's why Judges Protection Act is there. Similarly, arbitrator is also doing is a judicial act only. Maybe it's a private award, but still it's a judicial function. So a person may file a suit against arbitrator saying that you are not dealt with properly. Your judgment is not so. For his protection, Section 40 42B was enacted. Any action done in good faith is protected. And section 43 provides for a limitation. And when coming to limitation, section 34, which I forgot to mention, it provides 90 days and 30 days. Beyond the 30 days, 90 days and another 30 days, delay cannot be condoned. Though section 43 provides the limitation applicable, but even under section 5 also, section 5 is conditioned by section 34. The delay cannot be condoned 90 plus 90 days, 30, beyond 30 days. So section 5 is conditioned by that. But unlike section 37, there is no limitation is provided. So in that case, section 5 applies, but in arbitration matters, court is extremely slow in condoning the delay. That way, to safeguard, even refusing to condone the delay in applying section 34 also, appeal is provided under section 37 to safeguard sometimes the injustice done to the parties in arbitration. So every safeguard has been taken in the Arbitration Act to safeguard the interests of the parties and also see the quick and effective justice is rendered. And 2015-19 Amendment Act provided for the establishment of arbitration council to assist to make suggestions to central government to effectively deal with the arbitration, because you all know very well the law is also not like decision law is also not static, because what was there in 10 years because was not requirement of today. The legislatures know what is required of law, because several laws were repealed in recent times because they have become obsolete, and several acts have been enacted because what society requires the legislatures know. And even same thing, this hit and trial, because we can only make it skeleton and some rules, but ultimately it is the judges and the arbitrators who has to interpret the law. And because unlike other professions, computers cannot do a duty. A judicial function, a computer cannot do it. And arbitrators duty to determine. Even some websites say that if you feed the evidence, other things, some judgments are coming. I do not know whether they are as effective as because we have to see the witness demeanor, so many aspects, equity, so many aspects have to be seen. So I think no computer can replace it. It's only human beings which the judicial function has to be rendered. So how effective we render is important. And everyone wants peace in the society. If any litigation, we want that litigation should be end as soon as possible. But with the present trend, unless we adopt to one of arbitration at least, because conciliation parties have to agree. Arbitration, once they enter into agreement, whether they agree or not, the matter has to go for arbitration. If the consensus is there, consensus arbitrator can be appointed. Otherwise, the matter will go to the court and arbitrator will be appointed. Just like court, matter will be dealt. Then so much technicality will not be there, but still procedure is there. That is an advantage for arbitration. And arbitration also conciliation, the procedure can be adopted, mediation can be adopted, and settlement can be arrived. And chapter part 2 deals with the enforcement of foreign awards, where conditions, what are the conditions, and section 44 about the New York Convention awards, and enforceability, what is evidence to be filed, and Geneva Convention of part, and deal 3 is Geneva Convention awards. If you satisfy certain conditions, the awards can be enforced. So this is the broad outline and scope of the arbitration. And the latest judgment of the Supreme Court were regarding the stamp duty, which is one of the important judgment, that is NN Global. Because section 8 and 11, many times we come across agreements. Agreements should be enforceable agreements. That was interpretation given. And in SMST and Garware, the decision was, unless the agreement is stamped, main agreement is stamped, that cannot be linked into any of the provision contained in section 35 of Stamp Act. Unless it is impounded, that cannot be relied upon and looked into, and arbitration cannot be appointed, and the matter cannot be referred to arbitration. NN Global, they doubted the correctness of SMS and Garware, and the matter came before larger bench, and the 3:1, they said that unless the main agreement is stamped, the agreement cannot be looked into, and the proceedings under section 11 and 8 cannot go on. But minority views held that aspects can be looked under section 16 before the arbitrator, because the purpose of section 11 and earlier enactment of section 6A, which is now omitted, is to limit the judicial intervention. There also, as sitting judge, I could not have told that the judgment of Supreme Court is wrong. My brother Justice Ramakrishna Prasad could have also not told like that. But now I'm free to tell that erroneous. Because in NN Global, the majority view was that unless stamp duty is paid, is not enforceable. As it is, section 16(1) says arbitration clause is independent itself. When that is independent, what is the stamp duty that is paid? If it is not mentioned, I think more 100 rupees is the maximum. Otherwise, if it's a sale agreement, if it's something different. I think that aspect was not considered. And NN Global, it went on a presumption that Maharashtra Stamp Act did not provide stamp duty for arbitration agreement. But even for arbitration agreement, if stamp duty is not provided, as a subsidiary article is there saying that if nowhere it is provided, stamp duty is there. That aspect was not looked into. And bar contained under section 35 is curable, because many times when the matters came before me, I adjourned the matter under section 11 and they got the document impounded. But only thing is a delay. So, from practical point of view, section 16 is there for arbitrator. That impounding can also be done by the arbitrator. One way of looking at it. The purpose of Arbitration Act, the object for which it is enacted, we look into it, the minimum role of what you call minimum intervention by judicial authorities, then it can be debated. If someone raises a point, again, I think the matter may go before a larger bench, and in global also. So that is the latest judgment on this stamp duty and enforceability. So our mindset, bar and also bench, and the other aspect is that to see that the litigant gets the quick and effective justice, whether way of arbitration or judicial intervention or whatever may. So I found that not because I am doing arbitration, I am encouraging arbitration. Don't bear the impression, but only the advantages to bar also. At least some cases are disposed of to arbitration. Yet it will be beneficial. People will have confidence that at least we will have some faith. They don't have much distinction between arbitration and courts because they think that if they get relief, that is sufficient. So I don't want to detain and further violate your human rights. Thank you very much.
Thank you, sir. In other words, we are all subjected to your lordship to the humiliation and you that human rights violation, because under tremendous pressure, considering that fact and deliver the entire subject. Somehow you are successful, sir, in delivering the entire subject within the time. Thank you, sir. Thank you very much. I request my friends to join with us to fill state. Justice Rashid, I also request Suresh. Now all of you can go for lunch. I am thankful to all of you. In spite of this delay, you did not move from your seats. And this shows, this entire people shows they came here with a purpose, and they have shown their maturity. And definitely next, after the lunch break, we will have a short session. There is a last session. Whatever you acquired knowledge here, so that you can use the provisions of Transfer of Property Act. By using that knowledge, and you acquire the physical property. So please come quickly, because it's being a last day. Every day I am been asking you to have a only sufficient lunch, but not sumptuous lunch. But today you have a sumptuous lunch, because no, this is a last, being a last occasion. Have a sumptuous lunch and come. We'll finish the next session, but come in time, as early as possible, before 3 p.m.
ఏమవుతుంది? అయినా వీడియో చేసే కదా. అమ్మా పిలిపించమ్మా, వచ్చేస్తున్నారు సార్ వాళ్ళు.
హలో హలో
హలో మిత్రులారా, మరికొద్ది నిమిషాల్లో మన సెషన్ స్టార్ట్ అవుతుంది. బయట ఉన్న మిత్రులను కూడా ఫోన్ చేసి మెసేజ్లు పెట్టి లోపలికి రావాల్సిందిగా కోరుతున్నాం. అంతలోకే సంవిధానం పెట్టి
స్లైడ్ మీరు అక్కడ అక్కర్లేదు లేనా అక్కర్లేదు లేదా సార్ సెక్షన్ స్టార్ట్ అవుతుంది. బయట ఉన్న వాళ్ళందరూ లోపల రావాలి. ప్లీజ్ అడ్వకేట్స్ ఆర్ రిక్వెస్టెడ్ టు కమ్ ఇన్సైడ్. In few minutes, the session going to be start. Please.
आजादी के 5 दिन बाद 20 अगस्त 1947 को संविधान सभा फिर मिली, जहां एक तरफ स्वतंत्रता मिलने की खुशी थी, तो वहीं कई शिकवे शिकायतें भी सामने आने लगी।
सभापति महोदय, इससे पहले कि हम आज की कार्रवाई शुरू करें, मैं आपका ध्यान एक अहम मुद्दे की ओर आकर्षित करना चाहूंगा। खबर है कि स्वाधीनता दिवस को आगरा के किले में लाखों लोग झंडारोहण के लिए इकट्ठा हुए थे। आगे खबर है कि एक अंग्रेज अफसर ने कहा कि अगर यूनियन जैक नीचे उतार के नया झंडा फहराया गया तो वो किसी भी फौजी को इस समारोह में शामिल नहीं होने देगा। हम किसी भी रूप में अपने राष्ट्रीय ध्वज का अपमान सहन नहीं कर सकते। मेरी सभापति जी से प्रार्थना है कि आप सदन के लीडर पंडित नेहरू से कहें कि वो इस विषय पे बयान दें।
उन घटनाओं के मुतालिक जो 14-15 अगस्त को हुई, मैं सदन के नेता से गुजारिश करूंगा कि वो अपना बयान दे।
इस सभा में जो कुछ भी कहा जा रहा है उसे मैं पूरे गौर से सुनने की कोशिश कर रहा हूं, और जो कुछ भी कहा गया है उसका मुश्किल से मुझे 1/4 पल्ले पड़ा। हो सकता है कि यहां के एक्यूस्टिक्स बदल गए हैं, या तो फिर पिछले दिनों के उत्साह के कारण हमारी आवाजें बढ़ चुकी है।
Mr. President, sir, the loudspeaker system is not behaving as well as it used to till the 15th of August.
It has got infected by independence, like all of us.
हंसी खुशी और मजाक की बात तो अलग, पर अब संविधान सभा के सामने नई गंभीर चुनौतियां थीं। एक तरफ वो देश के लिए नया कानून बनाने बैठे थे, तो दूसरी तरफ देश भर में हर तरह के कानून तोड़े जा रहे थे। जैसा कि अमेरिकन इतिहासकार ग्रैनविल ऑस्टिन ने लिखा है, द फंडामेंटल राइट्स वर फ्रेम्ड अगेंस्ट द कार्नेज ऑफ फंडामेंटल रॉन्ग्स।
अध्यक्ष महोदय, मैं कुछ कहना चाहता हूं।
जी कहिए।
इससे पहले कि आज का कार्यक्रम प्रारंभ किया जाए, मैं आपका ध्यान इस
Suresh. గుడ్ ఆఫ్టర్నూన్. మరీ ఎక్కువగా సంతోష్ అన్నారని ఎక్కువ తిన్నారా? లెట్ us have the same energy. We are going to part with each other. We will have one session and it will commence. Meanwhile, the announcement that evening there will be 2 trips of the buses, one towards Guntur, one towards Vijayawada at 7 p.m. and 8 p.m. Depends upon your convenience. After completion of these sessions, after going to the rooms, please pack up and get ready, and whatever convenient bus you require to take, you go in that particular bus.
I request Sri Subbarao Garu, Member, Bar Council of Andhra Pradesh, to come over the dais and adopt the chair. I request Ashrita to accompany Sri Subbarao Garu. I request Rishika ma'am, Assistant Professor, to present a sapling to Subbarao Garu, Member, Bar Council. Vajra Srinivas. Suresh. ఎంతమంది ఉన్నారు సార్? Vajra Srinivas. I request Honorable Justice Sri A. Hariharanatha Sharma sir, Director, Andhra Pradesh Judicial Academy, to come over the dais and adopt the chair. I request Ashrita to accompany Hariharanatha Sharma sir. I request KMM Assistant Professor to present a sapling. I request Vajra Srinivas sir, Member, Bar Council of Andhra Pradesh, to come over the dais and adopt the chair. I request Ashrita to accompany Vajra Srinivas sir. I request Bhargavi ma'am, Assistant Professor, to present a sapling to Vajra Srinivas sir. I request Sri PSP Suresh sir, Vice President, High Court Bar Association, to come over the dais and adopt the chair. I request Ashrita to accompany sir. I request Kamsai sir to present a sapling.
Now the last session of the schedule, and Suresh Kumar will also deliver a short lecture which is not there in the schedule. I now request Sri Honorable A. Hariharna Sarma Garu to deliver his lecture on Transfer of Property Act.
A very humble good evening, rather good afternoon to all the dignitaries on the dais. Subbarao Garu, Srinivasrao Garu, Suresh Garu, and Ganto Ramarao Garu, Ram Reddy Garu of the dais, and other bar council members, learned advocate friends. At the outset, I say that I'm thankful to Andhra Pradesh Bar Council for providing me this opportunity to share my thoughts, particularly to the chairman of Bar Council of State of Andhra Pradesh and his companion office bearers. I am asked to speak on the subject Transfer of Property Act for over 40 to 45 minutes. Our time is being short. I will further restrict myself considering the time constraints, and I know that we are running short of time. 137 sections, 8 chapters of Transfer of Property Act. Great authors like D.C.V. Subbarao Garu, Avatar Singh and S.P. Sen Gupta wrote several books in volumes, concising them or concising the subject to a time of 30 or less than 30 minutes is really a Herculean task, particularly in the presence of this illuminating gathering. More particularly post-lunch session, after having both the delicious and sumptuous lunch, as said by the chairman Ganto Ramarao Garu. Particularly when the food starts working after 10 or 15 minutes, working as an anesthesia, takes the participants to a sleepy condition, which I experience in the Judicial Academy also. At times, it was really a tough task to make them out of the sleepy condition. Yet, it's part of the job of all of us. As an academician, particularly steering the Judicial Academy and interacting with the judicial officers every day on various topics, I believe that the interactive session is more helpful than one-sided dumping of information or thoughts. I get encouragement if some questions are shared by the participants. My concern is that I can share such questions with my officers. In turn, those officers may have to face those questions when they are on bench and encounter you from the bar at your respective places. That's my first request, rather the selfishness, which instead of they facing the question paper leakage, I request for this one thing. And there will be a mutual benefit with that. The caption Transfer of Property Act, the name itself suggests that there shall be property and there shall be transfer of such property. And the legislation is intended to regulate something in that regard. It is intended to regulate the transfer of property. If we see the preamble, not only this Transfer of Property Act, any act for that matter, any legislation for that matter, we have to study with reference to statement of reasons and objectives, preamble, and repealings and savings, and exact the body, exact the purpose of the legislation. The 4 components will be there for any statute. If we look at the preamble of the Transfer of Property Act, it says that it is an act to amend the law relating to transfer of property by act of parties. To amend the law, first component is, first catchword is amend the law. Second catchword is relating to transfer of property. Third catchword is by act of parties. 3 catchwords. By act of parties, amending the law, relating to transfer of property. This suggests that there is already some law dealing with the transfer of property. It is somewhere in 1882. So, what was the pre-existing law prior to 1882? 1872 Contract Act was there. And then it is by act of parties. It is inter vivas is what we hear in colleges regularly. Inter vivas is between two living persons and with the action of two parties to a transaction. Both must be present and activity or conduct of both parties must be there. Then the Transfer of Property Act would apply. And the act is intended to amend the existing law. Then if we go, the repealings and savings, as far as the act is concerned, what are saved and what are repealed. It does not say anything about the repealing exactly, but it says about saving of certain things. And the next question is, for any act for that matter, whether the act is complete by itself, in the sense whether we should look for a particular purpose for that act alone, or we supposed to look to any other enactments. When everything is there in that act, it is called as a self-contained and self-sufficient and complete act. But when we are supposed to, or we have to look into other enactments, then it is not complete, it is not exhaustive, it is supplemental to other acts. Transfer of Property Act Section 4 provides that it can be considered as part of the Contract Act for the transactions which appear like a contract, and it is supplemental to Registration Act in respect of certain provisions, particularly 54, 59 and 107, and mortgages, dealing with mortgages, dealing with the sales, dealing with gift 123. In respect of all these provisions, it is supplemental to the Registration Act. In respect of contract related issues, it is part of the Contract Act. So, for understanding Contract Act, we have to necessarily look into Contract Act also, as it is part of the Contract Act. Secondly, with respect to certain provisions with regard to sale, with regard to mortgage, with regard to gift, and with regard to leases, it can be considered as supplemental to the Registration Act, as the Registration Act contemplates the registration of those transactions. So these three acts invariably apply wherever, and we have to read all these three acts when we look at the Transfer of Property Act, when we encounter the Transfer of Property Act, when we depend on the Transfer of Property Act. This is one thing. Second thing, the catchword I said, by act of parties. Transfer of property is one catchword and act of parties is another catchword. Transfer of property. Whether transfer of property is defined under the act is the next question. Section 5 of the Transfer of Property Act provides what a transfer of property is. It is something, a person conveying his right over a property in present or in future to himself and to any other person or to any other person. So the transfers contemplated are conveyance of title, conveyance of right over the property to any other, to himself and any other. Transferring the property to himself is also contemplated under Section 5. What are the examples or what are the illustrations of such a person transferring a property to himself? Where is the need for transferring the property to himself is the next question. There do arise a situation where I may transfer a property to my daughter while retaining life estate to me, or I may have some property. I may settle this property to myself and my family members, the settlement deed, or transfer of property, retaining the limited estate and giving full rights to the other person. During my lifetime I will enjoy, and after my lifetime so and so will get. However, that right given to so and so after my lifetime is also a vested right, is also a transfer of full rights to the other person. So in that way, Section 5 ingredients gets satisfied. It is transfer of property either in present or in future. The future transfer is also contemplated. It takes place after. And taking place after my lifetime is again a little confusing aspect is where will is there, where will is executed, where a testamentary disposition is there, then also the property transferring or conveying in favor of the legatee, in favor of the beneficiary and the will arises. Then what is the difference between this transfer under a testament and transfer under an instrument? The word used in the Transfer of Property Act is conveyance. Conveyance is not defined in the Transfer of Property Act, but the conveyance is defined in the Stamp Act. The conveyance is in terms of an instrument, the rights will be transferred from one person or transmitted from one person to another person. This is conveyance under an instrument. But testamentary disposition, in the sense by way of will, is not covered by the Transfer of Property Act. It is covered by the Indian Succession Act. Even the introductory part of the Transfer of Property Act itself say that it is by act of parties. Act of both parties to the transaction must be there. In will, there will be act of only one party who is writing the will is called as a testator. Testator will write and legatee will get the rights, and that right the legatee will get after the lifetime of the testator. In case of the transfer, earlier said, I retain life estate and full rights are given to my daughter or son, whoever is. Then also the transfer takes place at a future time. That also covered by 5. But the will aspect is not covered by the Transfer of Property Act. It is covered by the Indian Succession Act. The reason simple is that Transfer of Property Act applies only inter vivas. It is between the two living persons. It is between two parties who are present to the transaction, who are there to the transaction. Then the questions do arise that if you see section 13 and 14, perpetuity, rule against perpetuity, in the sense I may transfer property, life estate to my daughter and thereafter to son of my daughter after her lifetime. That is also possible, who is not in existence. The transfer also takes place in future and that person is not alive. But one person shall be certainly alive. 2 living persons may be there and the third person need not be living, and still it gets clothed under the definition and purview of the Transfer of Property Act. That is permissible in terms of 13 and 14 of the Transfer of Property Act. That is one context. As far as the exhaustiveness is concerned, then first thing is it applies in respect of transfer of properties. Second thing, it applies transfer of both movable and immobile properties, but substantially to immobile properties only. Movable properties aspect is lightly covered wherever some gift, etc., or actionable claims, etc., are there. It is lightly covered. Whether the actionable claims falls under the movable property is again a debatable. That's a different issue. Forgetting about that, substantially it relates to immobile property only. If it is a movable property, again Sale of Goods Act and other things will apply. For that we have to look into Sale of Goods Act. That's again a different aspect. Now, what can be transferred and what cannot be transferred? What is transfer? We have seen transfer of property from one person to other between 2 living persons. Okay. Apart from the transfer inter vivas, in the sense transfer between the 2 living persons, are there any other kinds of transfer? Transfer, this is by act of parties. Transfer by conduct of parties. Then the next type of transfer is transfer by operation of law. Transfer by operation of law takes place where a person dies intestate, then succession opens, and as per the Succession Act, the property devolves on the successor. There also the transfer takes place by operation of law. Then there may be other situations where I enter into transaction of purchasing the property and it is not complied by the other side. I will file a suit for specific performance. Then law takes its course and a decree for specific performance, thereafter the execution of the decree. And or else I may file a suit for recovery of money and that decree is false, decree is not complied. Then I will file an execution petition for sale of property, and in sale the court sells the property, court transfers the property, courts execute the sale deed. Then it is again a transfer by operation of law. Insolvency, the receiver transfers. and some other situations where the government itself grants and transfers a certain property. That is again another context where by operation of law, by maybe by virtue of grants, pattas, etc., government granting. By authority of the law, by operation of law, transfer is one thing. By act of the parties, transfer is another thing. Then I am asked to speak on important provisions of the Transfer of Property Act. 137 sections are, every section is important by itself. But among them, what we usually and day in and out encounter and which are of most relevance and the most important if we see. As I said, for reading any act, firstly preamble, statement of reasons and objectives, then definition clause will be there in every act. If it is not a definition clause, there will be an interpretation clause like that will be there. So here also we have an interpretation clause as to with respect to Transfer of Property Act also. That also stipulates certain words how they are to be understood. Notice is one aspect. Notice is one aspect. The law, particularly the Transfer of Property Act, presumes that we know certain things. When the law presumes or the Transfer of Property Act presumes that we know certain things. There is no defense. It is not a defense to say that I do not know. If I refer to the principle or concept caveat emptor, the freshers will immediately catch it. The caveat emptor is the principle that a purchaser must be aware of whatever transaction he is entering into with respect to the sale of goods. Buyer beware. Buyer beware. Caveat emptor is buyer beware. Buyer is supposed to be aware of what is transaction he is entering into. Fine. There the burden is on the buyer. Whether it applies to immovable properties is the next question. It applies, it is in respect of Sale of Goods Act is one aspect. Coming closely to this, whether it can be made applicable, whether it is anywhere contemplated under this Transfer of Property Act is the next thing. Now knowledge aspect. Section 3 of the Transfer of Property Act interpretation clause contemplating about the knowledge, if we see, where by formal verification a person can know certain things. If he does not know, he has to blame himself. I went and purchased a property. I claim that he said that it is 10 floors, but it is only 4-story building, and in fact he said that it is a 10-story building. He has cheated me. Can I make such a allegation? Can I take such defense? Which by mere physical verification with common sense, an ordinary prudent man can verify how many floors it is there and how much extent it is there and what is it. Can I throw blame on the other side that he has not disclosed? So with ordinary prudence, with common intelligence, with common or formal or simple verification, a person can ascertain something, and if he fails to ascertain that, he has to blame himself. He cannot blame the other side. And law presumes that you know that it is only 4 floors, not the 10 floors of the building with which you are entering into transaction. That's one thing. Second thing, where there is any registered transaction, and where the law requires that such transaction shall be a registered transaction. Two conditions. Law shall require that such transaction shall be a registrable transaction, and the registration mandate is complied. Then the law presumes that you have knowledge of such registration. I go and purchase the property from some A. I say that A has already sold the property to B 10 years back. He has already sold the property to B 5 years back. He has concealed that sale and he has sold the property again to me. Thereby, I am cheated. Thereby, this transaction is bad. All these things I say. And it is a registered transaction. And it is supposed to be registered in terms of the Registration Act, Section 17. Section 17 is complied, registration is there. You can get it verified by EC, encumbrance certificate, or you can get it verified under the registrar office, or you can even get it verified if it is a property building something from the local revenue office like a municipality or the panchayat, what is the door number, in whose name it is standing, whether the mutation is affected or not, all these things you can ascertain. You fail to ascertain, then can you make a blame that the law presumes that where a transaction is supposed to be registered and it is registered, you cannot take the stand that I am kept in darkness, because the duty is there on your part to verify. Say, a transaction does not require registration, but the registration is affected. I sold the property to A, but prior to selling the property, I borrowed the amount, and I got that agreement of borrowing the amount a registered transaction. I got it registered. There is no bar to get a registration. Get registration of a transaction. Any agreement I can go for registration. Whether it is registrable or not is a different aspect. Registrability is a mandatory thing where it is supposed to be registered. Even an unregisterable transaction also can be opted for registration. I opted for registration of this lending and borrowing transaction. Tomorrow, my creditor who has advanced money to me, I sold the property after this registered transaction. And then he comes and say, it is a registered transaction, he has borrowed the amount, knowing pretty well about this borrowing, he has purchased the property, therefore the property is liable for all the thing. I stand prior in right, my right is prior one, and I have right to proceed the property against him. My right will be given, shall be given preference is what he say. Whether that is acceptable is the next question. Since that transaction does not require registration, as an abundant caution or for your own reasons, you have got it registered. That does not mean that you can take the defense of that registration. Only when it is a registrable transaction and registered, the constructive notice in terms of Section 3 of the Transfer of Property Act can be attributed, otherwise it cannot be attributed. That's what the understanding of that provision. Then, what are registrable, what need not be registered, 17 Registration Act, exceptions under 49, they are all again a big aspect. Then, the next issue is what can be transferred, who can transfer. What can be transferred, who can transfer. What can be transferred is property. We are dealing with the property. But what property can be transferred and what property cannot be transferred? Transfer of Property Act, Bear Act. Transfer of Property Act, Bear Act. Please. Okay, okay, very good. Okay. So what can be transferred and who can transfer are the two questions. Certain kinds of properties cannot be transferred. Certain kinds of properties can be transferred. Certain kind of property or right. Undi. Thank you. Mere right to succeed to a property cannot be transferred. Say, my father has self-acquired property. After my father, I will get the property of my father. Now, I am transferring this property to you for a so-and-so consideration, and I enter into a transaction of sale, whether it is permissible. There is no right in presenti for me. I cannot transfer anything in presenti. Therefore, such a conveyance, a mere right to succeed to a property cannot be transferred. This is one thing. Chance of succession, mere a chance of succession, chance of succeeding. Who knows that he executes a will? Who knows that he conveys or he sells the property for his own necessities? Therefore, that kind of possibility of succession cannot be, and a future right cannot be transferred is one thing. Second thing, important among these things, a possible defense. Easementary right cannot be transferred. I have a right of passage. I have a right to get the water. I cannot transfer. Always easementary right runs with the property, not with the person. My property has a right. I have no right. The easementary right is always a right to property, right which the property has. Which property? A dominant heritage has. Dominant heritage is one. That property cannot be properly enjoyed without such easementary right. Right of way is necessary. Way is necessary for any land. So to reach the land, way is necessary. Therefore, the right to have the way is the right of the property, right of that land. It is not the right of the owner. The right runs with the land, but not with the owner. Whoever is the owner may have that right to use, but that is not an independently alienable or transferable right. Next, among all these things, an interesting phenomena is a right to sue cannot be transferred. A mere right to sue cannot be transferred. How a mere right to sue cannot be transferred can be understood. How do we come across such situation in our regular practice is the question. ఇంకా కొద్ది క్లియర్గా ఇఫ్ యూ పర్మిట్ మీ కొద్దిగా డ్రౌజీనెస్ నుంచి బయటికి రావడం కోసం నేను కానీ మీరు కానీ కాస్త తెలుగులో కూడా వస్తూ ఉన్నాను. ఓకే, క్విక్గానే ఫినిష్ అవుతుంది. కేవలము నేను వ్యాజ్యము చేయగలిగినటువంటి హక్కును మాత్రమే ట్రాన్స్ఫర్ చేస్తున్నాను. రైట్ టు ట్రాన్స్ఫర్, ట్రాన్స్ఫరింగ్ ద ప్రాపర్టీ ఈజ్ వన్ థింగ్, ట్రాన్స్ఫరింగ్ ద రైట్ టు లిటిగేట్ వెదర్ ఐఎమ్ ట్రాన్స్ఫరింగ్ ఇస్ ద క్వశ్చన్. ఇలాంటి సందర్భం మనకి ఎప్పుడైనా ఏమైనా వచ్చే అవకాశం ఉందా? వస్తుంది. మీకు చాలాసార్లు వచ్చి ఉంటుంది. ఎలా వచ్చి ఉంటుంది, ఎలాగా అనేది ఒక్కసారి క్లోజ్గా చూసేసి క్లోజ్ చేస్తాను, ఎందుకంటే ఇట్ ఇస్ ఎ వాస్ట్ థింగ్ అండ్ టైమ్ ఇస్ టూ షార్ట్. Say, before saying that, I may request you to note down a case. Amrutam Kadumba versus Sharanam Kudumban. Amrutam Kudumba versus Sharanam Kudumba. 1991 AIR, page number 1256, Supreme Court. 1991 AIR 1991 Supreme Court, page number 1256, equivalent to 1991 SCR 2, page number 389. ఇక్కడ ఒక్క నిమిషం పాస్ తీసుకుంటాను. SCR సుప్రీం కోర్ట్ రిపోర్ట్స్, ఈ ఈఎస్సిఆర్ అనేది కొత్తగా సుప్రీంకోర్టు వారు ఇంట్రడ్యూస్ చేశారు. ఈఎస్సిఆర్ అనేది ఎందుకోసం ఇంట్రడ్యూస్ చేశారు అంటే, ఇట్ ఈస్ ఎ ఫ్రీ లీగల్ సాఫ్ట్వేర్. మీరు ఏ జడ్జిమెంట్ అయినా సరే, ఏ విధమైన రిపోర్టర్కు మీరు ఏ విధమైన బుక్కులు పర్చేజ్ చేయలేకపోయినా, మీ దగ్గర లైబ్రరీలో లేకపోయినా కూడా ఈ ఈఎస్ఆర్ అనేది మీరు ఫోన్ ద్వారా కానీ, మీ ఏదైనా కంప్యూటర్ ద్వారా కానీ, దేని ద్వారా కానీ యాక్సెస్ చేయవచ్చు. అది రెగ్యులర్గా మనం ఏదైతే ఈ మన్ను పాత్రలు కానీ, లేదంటే సుప్రీంకోర్టు కేసెస్లు కానీ, లేదా అడ్వకేట్ కోర్సులు కానీ, వీటన్నిటిలో ఎలాగైతే మనం చేస్తూ ఉన్నామో, ఈవెన్ గూగుల్ లాగా ఎలా చేస్తా ఉన్నామో ఆ విధంగా కూడా ఒక్కసారి ఈఎస్ఆర్ సాఫ్ట్వేర్లోకి వెళ్ళి మీరు యాక్సెస్ చేయవచ్చు. ఈఎస్ఆర్ సాఫ్ట్వేర్కు మీరు ఏమి డౌన్లోడ్ చేసుకోవాలంటే ఏమి అక్కర్లేదు. సుప్రీంకోర్టు సైట్లోకి వెళ్ళగానే ఈఎస్ఆర్ అనే ఒక లింక్ ఉంటుంది. అలాగే హైకోర్టు సైట్లోకి వెళ్తే కూడా ఈఎస్ఆర్ అనే ఒక లింక్ ఉంటుంది. ఆ ఈఎస్ఆర్ అనే లింక్ హైకోర్టు సైట్లో కానీ, సుప్రీంకోర్టు సైట్లో కానీ మీరు యాక్సెస్ చేసి దాంట్లో నుంచి సైటేషన్ యాక్సెస్ చేసుకొని డౌన్లోడ్ చేసుకోవచ్చు, అథెంటికేటెడ్. సో అది డౌన్లోడ్ చేసుకోవడానికి ఉపయోగపడుతుంది. ఇది 35,000 జడ్జిమెంట్లు దాంట్లో అప్లోడ్ చేయబడ్డాయి. 1950 నుంచి ఉన్నటువంటి జడ్జిమెంట్లు కూడా అప్లోడ్ చేయబడ్డాయి. లాస్ట్ ఇయర్ వరకు కూడా అప్లోడ్ చేయబడ్డాయి. చాలా యూస్ఫుల్ సాఫ్ట్వేర్, కాస్ట్ ఫ్యాక్టర్ ఏమీ లేదు, ఫ్రీ సాఫ్ట్వేర్. యూజ్ చేసుకోవడానికి ప్రయత్నం చేయండి. ఈఎస్ఆర్ మీద సపరేట్గా బార్ కౌన్సిల్ పర్మిషన్తో ఒకసారి మళ్ళీ మనము ఏదైనా సెషన్ ఏదైనా అకాడమీ ద్వారా కానీ మామూలుగా కానీ మేము చేద్దాము డెఫినెట్లీ. సో ఇక్కడ ఈ కేసులో ఏం జరుగుతుంది అంటే, ఒక మైనర్ యొక్క ప్రాపర్టీ, మైనర్ వాళ్ళ అమ్మకు ప్రాపర్టీ వాళ్ళ పేరెంట్స్ నుంచి వస్తుంది. ఆమె ప్రాపర్టీ ఆమెది సొంతంది అయిపోతుంది. ఆమె చనిపోయిన తర్వాత ఆమె భర్త ఈ అమ్మాయి యొక్క తండ్రి న్యాచురల్ గార్డియన్ వేరే వాళ్లకు ట్రాన్స్ఫర్ చేస్తారు, ప్రాపర్టీని అమ్మేస్తారు. న్యాచురల్ గార్డియన్ అమ్మేస్తారు. ఏం చెప్తాడు? ఈ పాప అవసరాల కోసం నేను అమ్ముతాను అని చెప్పేసి అమ్మేస్తాడు. అమ్మిన తర్వాత ప్రాపర్టీని మైనర్గా ఉంటుంది. మేజర్ అయిన 3 years లోపల ఆ అమ్మాయి వేరే వాళ్ళకి అమ్మేస్తుంది. సలహా ఇస్తారు అడ్వకేట్ గారు, మీ నాన్నగారు చెప్పిన ప్రాపర్టీ, అమ్మిన ప్రాపర్టీ అదేమి ఆ నాన్నగారు కూడా ఏం చేస్తారు, ఇంకో రెండో ఆమెను పెళ్లి చేసుకొని ఆమెకు వెళ్ళిపోయింటారు, ఈ అమ్మాయిని వదిలేసింటారు. ఈమె వీళ్ళ తాతగారి ఇంటికి అంటే అమ్మమ్మ వాళ్ళ ఇంటికి వెళ్ళిపోయి వాళ్ళ మెటర్నల్ గ్రాండ్ ఫాదర్స్ ఫ్యామిలీలో ఉండిపోతుంది. అక్కడ ఉన్న వాళ్ళు ఒక లాయర్ మంచి అన్నం ఏమన్నా అన్నాం, ఆయన సలహా ఇస్తాడు. ఏమని, ఆ అలినేషన్ చెల్లదు, అది కోర్టు పర్మిషన్ లేకుండా చేసినటువంటి అలినేషన్, దట్ ట్రాన్స్ఫర్ ఆర్ దట్ సేల్ ఈజ్ ఇన్వాలిడ్. So he cannot sell the property without the permission of the court. Permission of the court is mandatory as per the Hindu Minority and Guardianship Act. Without that, the property is sold, therefore invalid. నువ్వు ఒక సూట్ వేసేసి ఏం చెప్తారు, ఆమె సూట్ వేస్తుంది. వేసిన తర్వాత దాంట్లో వెదర్ ఇట్ ఈస్ ఫర్ ది నెసెసిటీస్ ఆఫ్ ద మైనర్ అనే ఒక క్వశ్చన్ వస్తుంది. వెదర్ పర్మిషన్ ఆఫ్ ద కోర్ట్ ఈజ్ అప్టైన్డ్ అనేది నెక్స్ట్ క్వశ్చన్ వస్తుంది. వచ్చి కింది కోర్టులలో అంతా ఏం చెప్తారంటే, అది పర్మిషన్ ఆమె నెసెసిటీస్ కోసం అమ్మినది కాదు, కోర్టు పర్మిషన్ కూడా లేదు అమ్మడానికి. గార్డెన్ గా నేచురల్ గార్డెన్ అయినప్పటికీ, ఆమె అవసరాలకైనప్పటికీ కూడా 8(2) ఆఫ్ గార్డెన్ అండ్ వాట్స్ యాక్ట్ లోకి చూసినట్టయితే, హిందూ మైనారిటీ అండ్ గార్డెన్షిప్ యాక్ట్ కానీ దీంట్లో ఈవెన్ మామూలుగా గార్డెన్షిప్ యాక్ట్ ప్రకారం చూసినప్పటికీ కూడా పర్మిషన్ ఈజ్ మ్యాండేటరీ టు హ్యాండిల్ ది ఆర్ సెల్ ది ప్రాపర్టీ ఆఫ్ ద మైనర్. సచ్ పర్మిషన్ ఈజ్ నాట్ అప్టైన్డ్, దేర్ఫోర్ ది అలినేషన్ ఈజ్ ఇన్వాలిడ్ అనే క్వశ్చన్ వస్తుంది. సో ఈ పాయింట్ సుప్రీంకోర్టు వరకు వెళ్తుంది. సుప్రీంకోర్టులో ఒకే ఒక లీగల్ క్వశ్చన్ రైజ్ అవుతుంది. ఏమంటారంటే, షీ హ్యాస్ రైట్ టు క్వశ్చన్ ది అలినేషన్. ఆమె ఎంతకు ఆమె అయితే మా నాన్నగారు అమ్మేదానికి అతను హక్కు లేదు పర్మిషన్ లేకుండా, ఆమె ఆ హక్కు ఆమెకి ఎప్పుడు వస్తుంది? ఇమీడియట్లీ ఆఫ్టర్ సేల్ షీ గెట్స్ ద రైట్ టు క్వశ్చన్ ది అలినేషన్ మేడ్ బై ఫాదర్. షీ కెన్ క్వశ్చన్ దట్ విత్ ఇన్ 3 years after attaining the majority, but she has sold the property without questioning it before the court. Before court to deciding whether her father can alienate or not, she has sold the property. Now the purchaser got not the right over the property, purchaser got right, జస్ట్ ఈ సూ చేసే రైట్ మాత్రమే ఆయన కొన్నట్టు లెక్క వేసుకోవాలి. ఆయన ఇప్పుడు సూట్ వేసాడు, ఆ సూట్ వేసే హక్కు ఆమెకు మాత్రమే ఉంది. ఆ హక్కు, ఆమెకు సూట్ వేసే హక్కు ఇతనికి వచ్చే ప్రసక్తి లేదు, రాదు అనే వాదన వస్తుంది. దాన్ని కన్సిడర్ చేస్తూ, ఇట్ ఈస్ నాట్ మియర్ ఎ రైట్ టు ఫైల్ ఎ సూట్, ఇట్ ఈస్ కపుల్డ్ విత్, సో హర్ ట్రాన్స్ఫర్ ఆఫ్ ప్రాపర్టీ ఈజ్ నాట్ మియర్ రైట్ టు సూ, విచ్ ఈజ్ ఇన్ఫాక్ట్ మియర్ రైట్ టు సూ. నేను ఎవరి దగ్గర అప్పు తీసుకున్నాను, ఇచ్చాను, ఆ అప్పు నేను రికవర్ చేసుకోవడానికి నా తరఫున నువ్వు రికవర్ చేసుకోని నేను చెప్పి ఎవరికైనా ట్రాన్స్ఫర్ చేస్తే, ఇట్ ఈస్ హిట్ బై మెయింటెనెన్స్ అండ్ చాంపర్టీ, కాంట్రాక్ట్ యాక్ట్ ప్రొహిబిట్స్ దట్ అండ్ దట్ ఈస్ బ్యాడ్ ఇన్ లా. బట్ హియర్ దిస్ ఈస్ నాట్ మియర్ రైట్ టు సూ ట్రాన్స్ఫర్. షీ హ్యాస్ రైట్ అండ్ ద అలినేషన్ ఇట్ సెల్ఫ్ ఈస్ ఇన్వాలిడ్, దేర్ఫోర్ హర్ రైట్ ఈస్ ప్రాపర్ అండ్ దట్ ఈస్ నాట్ కవర్డ్ బై ది ఎగ్జంప్షన్ అండర్ 6 కింద బార్లోకి అది రాదు. 6 లో ఎలాంటి రైట్ అయితే ట్రాన్స్ఫర్ చేయకూడదు అనేది ఉందో ఆ రైట్ కాదు ఇది. ఆమె ట్రాన్స్ఫర్ చేసినది ప్రొహిబిటెడ్ రైట్ కాదు, ఆమె ట్రాన్స్ఫర్ చేసినది ప్రాపర్ రైటే. ఇతను సూట్ వేసినది కూడా చెల్లుతుంది. ది సూట్ ఈజ్ వ్యాలిడ్ అండ్ వాట్ ఎవర్ ట్రాన్స్ఫర్ షీ హ్యాస్ డన్ ఈజ్ ప్రాపర్ అండ్ వ్యాలిడ్. దట్ ఈస్ నాట్ హిట్ బై ది ప్రొవిజన్ ఈజ్ వాట్ ది హానరబుల్ సుప్రీం కోర్ట్ సేస్ ఇన్ దిస్ డెసిషన్. So alienations are transfers. Humble and respectful pranams to my Lord Honorable Sri K. Manmadrao Garu, and taking lead and permission, I welcome my Lord. So my job is almost done. I conclude stating, ending up the topic, stating that there are many things under Transfer of Property Act you may please probe. And in fact, I thought of just another important aspect is 52 of Transfer of Property Act. Lispendence is also day in and out we come across. Whether the lispendence purchaser is a proper and necessary party is another important aspect. So lispendence purchaser, again, for this 3 things are there. Lispendence purchaser coming on record on his own. Lispendence purchaser adding lispendence purchaser by the plaintiff. Defendant insisting that there is lispendence transaction and add that lispendence purchaser is the 3 situations. 3 సందర్భాలు. ప్లెయింటిఫ్ అంతరకు ప్లెయింటిఫ్, కేసు మధ్యలో కొనుక్కున్న ప్రాపర్టీని యాడ్ చేయడం ఒక సందర్భము, ప్రాపర్టీ కేసు పెండింగ్ ఉన్నప్పుడు కొనుక్కున్నవాడు వాడంతకు వాడు రావడం ఒక సందర్భము, డిఫెండెంట్ ప్లెయింటిఫ్ ను డైరెక్ట్ చేయండి, ఈ థర్డ్ పార్టీ కొనుక్కున్న వాడిని యాడ్ చేయండి కేసులో అనేది 3 సందర్భాలు వస్తాయి. ఈ 3 సందర్భాల గురించి సుప్రీంకోర్టు వారు మన హైకోర్టు వారు జడ్జిమెంట్స్ లో కన్సిడర్ చేయడం జరిగింది. ప్లెయింటిఫ్ ఈస్ డామినస్ లిటిస్. వారు ప్లెయింటిఫ్ కేసుకు కింగ్, ఆయన ఎలా రాస్తాడో ఆయన ఇష్టం, ఫస్ట్ ప్రిన్సిపల్. సెకండ్ థింగ్, ఖచ్చితంగా యాడ్ చేయాల్సిన పార్టీని చేయకపోవడము అనే దానివల్ల కేసు పోతే వాడి కేసు పోతుంది. 2. మూడోది, లిస్పెండెన్స్ పర్చేజర్ by virtue of Order 1 Rule 10 and by virtue of Order 22 Rule 10 and by virtue of 52 also he is a necessary party. If he comes on his own, welcome him. If the plaintiff adds, welcome him. If the defendant insists, leave it to the fate of the plaintiff, is what the Honorable Supreme Court said. That's what the judgment also I will share. Kasturi versus VM Perumal, Kasturi versus VM Perumal and others. Civil Appeal number 2831 of 2005, decided on 25th April 2005, and the same view is approved almost. Gurmeet Singh Bhatia versus Kiran Kant Robinson and others. Gurmeet Singh Bhatia versus Kiran Kant Robinson and others. Civil Appeal number 5522, 5523 of 2019, decided by Honorable Supreme Court on 17th July 2019. You may please verify these judgments as to pendant late purchaser and adding and other things. Once again, I thank Bar Council of Andhra Pradesh for providing me this opportunity. Thank you all for patiently listening whatever I say. Thank you.
Thank you, sir, for delivering a wonderful lecture on subject Transfer of Property Act. I request Mr. Srinivas Vajja and Subbarao to felicitate Sri Hariharna Sarma Garu, Director Academy, Judicial Academy. He has some other program at Academy, he has to leave urgently, therefore we are relieving Sarma Garu. There are number of questions because some people are hesitate to ask questions specifically. We asked them to put in the box, so we have taken out them, and some of them are general in nature, some of them are on a specific subject. Therefore, based depend upon the nature of that particular question, we ask the who are having knowledge in that subject, we have divided them. Firstly, I request Sri Posani Venkateswarlu Garu, the senior counsel, come and answer those questions which are on the criminal side.
My friend Mr. Ramarao directed me to write examination without giving any subject. There are few questions. One of them, nowadays, SC, ST and Prevention of Atrocities Act under PO, POXO
under section 498A, false cases are filed by some people. To prevent them, is there any immediate ideas or provisions? Please clarify on it. Once again, I repeat, nowadays there are false cases are being filed under the provisions of the SC and ST Prevention of Atrocities Act, POCSO, under section 498A. What are the remedies against such persons? That is the sum and substance of the question. My answer is only malicious prosecution. It comes under the malicious prosecution. Chapter 10 of the Indian Penal Code speaks about the malicious prosecution. Apart from that, there are certain provisions in the Criminal Procedure Code also. Under section 195 CRPC, if there is any false information given to the public authority or to the court, either the public authority or the court may lodge a complaint. Here is also malicious prosecution comes under the chapter 10 of the IPC. It comes under section 195 CRPC. That's why if any information is given to the police officials, it comes under the false information. If that is a false information, then we may ask and we may request the police official, or if any information or any complaint was filed directly before the court, that is called private complaint, we can request the public authority to initiate proceedings under section 195 CRPC. Or otherwise, suppose certain proceedings were went on before the court, that is inquiry and trial, after lodging the charge sheet. Then there is a provision under section 340 CRPC. That section 340 CRPC enables the court to conduct inquiry about the false information, giving false affidavit, forgery and perjury, all other things. That's why the defense may file an application of section 340 requesting the court to conduct inquiry, find out whether he has committed any offense of giving false information or not. These are the sum and substance of the malicious prosecutions. These are. Apart from that, we can also claim the compensation for malicious prosecution, that is by way of private complaint. Suppose if you request the public authority to initiate prosecution under section 195, there is no response. Since there is no remedy available, then we can only approach the Honorable High Court under section 226, because it is an executive action. Under section 195, the private person has no right to initiate proceedings. Only either the public authority or the court. That too by way of complaint. Complaint means something on paper before the court. That is called private complaint. Then another question is, could you please let us know about cross-examination in medical negligence cases before the district forum? I think it is under the Consumer Protection Act. I heard that there is no provision to cross-examining the doctor in medical negligence case. In medical negligence case, the proceedings before the consumer forums are summary in nature. It doesn't mean that the procedure contemplated under the CPC or under the Indian Evidence Act is not applicable. But summary in nature, in general, basing on the affidavits and the material on record, that is the pleadings, the proceedings would be concluded. When it comes to the medical negligence, the law says unless and until there is an expert opinion, the respectable consumer forums may not come to a conclusion there is a medical negligence on the part of the doctor. If the opinion of the doctor is disputed and at the request of the respondent, the court shall summon, even though there is no provision. So the section 135, I think, and 136 of the Indian Evidence Act, insofar as these aspects are concerned, when the opinion is disputed, it is applicable, and such a person shall be subjected to cross-examination. So medical negligence cases are as good as quasi in criminal nature, not like other cases. Another aspect, what can we do in a case where one judge ordered a residential order in DVC matter to the complaint, where her husband living in one house, which the said house is a rented house, and if husband left the house without informing the rented house owner, but there is a court residential order to the complainant, that is the wife. Under the order, the wife is not leaving the house as she is having court residential order, and she is staying without paying rent, and her husband whereabouts are also not known to the house owner, because she has got the right to reside, right to claim residence, not in the residential rental house. The house, I think there may not be a specific answer to this. As long as he is there, as long as he is paying the rents, then she can only reside. The house owner may not be the party to the proceedings. Even otherwise also she cannot claim any right of residence against the house owner. Only she can claim the right against the. Then another aspect, are the police station CCTV footages, can we get under or ask under the Right to Information Act? But the CCTVs of the police station is different from in the police station. It is a part of the investigation, that is totally different. If it is not the part of the police station, there is another aspect. But whether it comes under the document or not, if it comes under the document, we can summon the CC footages. But I am not sure about this particular aspect. Mere not quoting the legal provision or subject matter in the affidavit is liable to be dismissed. The affidavit is only to ascertain the certain factual aspects. There is no necessity to enumerate, to mention any legal provisions. Even otherwise also, any petition is not supported by any legal provision, or there is any wrong legal provision. On that ground, it may not be rejected. Ultimately, the court should go by the exact prayer, exact relief sought. So, as far as this question is concerned, for not mentioning the legal provision in the affidavit, so that affidavit may not be rejected and the case may not be dismissed on that ground. In a Lok Adalat award, if an award was passed under the fraud or coercion or undue influence, that should be taken up by the trial only, but there is no provision to such issue. In such circumstances, how the victim can avail his legal remedy to overcome the said award? The award passed by the Lok Adalat is final. That is the law. But whereas the exception is if it is by way of fraud, coercion, and undue influence, then the remedy is only by way of under section under Article 226. That is before the High Court. It is not as if there is no remedy less. Please explain words observation and finding in the judgment. Finding or observations are more or less the difference between is very thin layer. Ultimately, basing on certain findings, the verdict may be given. While arriving at a finding, there may be certain observations. Findings are preceded by the observations. Without there being any observations also, findings are there. So there is a overall difference. Subject to, there are so many criminal experts and also civil experts are there. These are the questions which I came across. Thank you.
Thank you, Venkateswara. In fact, we contemplated a criminal session consisting of the public prosecutor Nagareddy Garu, who is our member, and the Posan Venkateswara Garu and C. Nageswara, another senior counsel. But it could, one way or other, it could not be materialized. And again, I asked him to come yesterday morning and today morning for an open session. That also could not be materialized. Ultimately, we could be able to use his services like this. Thank you, Mr. Posan Venkateswara Garu. And now I request Chandrasekhar Reddy Garu, a couple of questions were forwarded to him that he may answer those queries.
ముందుగా జస్టిస్ హనుమంతరావు గారికి ఒక నమస్కారం సమర్పించుకొని తదుపరి సభలో ఉన్న మిత్రులందరికీ నమస్తే సమర్పించి నాకు ఇచ్చినటువంటి 2 లెటర్లు, దీనిలో ఏమో పేరు లేదు ఊరు లేదు, ఇదే బార్ కౌన్సిల్ టెస్ట్ లాగా ఉంది. రాయిద్దన్నారా? మరి ఆయన ప్రాబ్లం మనకెట్ అవుతుంది. హౌ కెన్ ఇట్ బి లిమిటెడ్ టు దిస్?
That query will be answered to all who are not.
Civil suit in the district court without serving notice to the defendants from the court of the respondents. The court given a judgment that defendants set ex parte and they went for final decree also. Defendant went for the second appeal. Defendants, but that was not come to the bench. Appeal was dismissed. Even having a given opportunity, himself has filed. How can he neglect up to the dismissal of the appeal? So you have agitated everything in appeal. Whether it is a fraudulent decree, can it be filed under 39 of the Specific Performance Act for nullity and void of the judgment and decree? You yourself has lost that defense. In this suit, how can a case defendant will get the benefit benefit to the dismissal. I think from beneficial to the dismissal. Recall the suit. Finally, the suit schedule property was owned by defendant only by the unregistered will. So, it seems to be the most the defendant's negligence, having you have agitated the matter before the Honorable High Court by way of appeal. Otherwise, at the stage of preliminary decree, so you have not agitated, then the final decree is over, that became a final. By way of your filing a appeal, I think you have no case, since you can try by set-siding the fraudulent decree. If you have patience and with a unregistered will. That is the answer. If anybody is a better answer, kindly make it. Then other, a father executed a will in favor of his wife regarding his self-acquired property. Self-acquired property is his right, and he can execute the will, no problem. Only limits the vested right, vested interest, but he has not correctly rated. Yes, the limited right in what conditions and such things he has not enunciated here. Then his father died and property devolves his wife. At this juncture, vested interest, if it is there in the writings of that document only, the section 14 of the Specific Performance Act has to invite whether it is a limited or absolute, and the judgments also is there what property have the vested right of the what remainders he have to be right, choose there. Without having that document, how can we give the opinion whether you have any right to sue or think? That is the question to the answer of this question also. Further, with great difficulty, I want to submit yesterday regarding the insurance companies. The insurance advocate has stated of the limitations to receive the compensation. My question, for his limited questions, I am answering in this way. So far as the negligence concerned, without examining the driver, they cannot question the contributory negligence at any cost. 1994, law summary, page 90. And another thing, the settlement of old law, adverse inference in 1991, ACJ 267, Pandangarao Gari judgment, is still in existence. Later, the violations he has referred with higher reward. Higher reward in sense, anybody can write in this way. That is for the business purpose of the owner. Any vehicle is entrusted, either a car or a scooter also, he is entitled. In spite of it, our Supreme Court 2017 ACJ 1031 Justice Selmeshwar judgment is there. Kindly note it, useful if you use it. Other thing, regarding the dependency, touched and left it. 1987 Supreme Court 561 still in existing law, and later that in any nations, it is not under the Motor Vehicles Act, it is not a succession. It is not limited to a wife or children or either. Even a sannyasi, he was under in a ashramam. Whether the ashram is entitled the compensation, yes, that is the principle for regarding the dependence. The latest thing now, the These are all laws. Pay and recovery law extended even a inmate of the court and check bounce cases and so many things are violations of the permit is covered. Then so far as the negligence concerned, latest Supreme Court judgments to Justice Subhashan Reddy and other judgment, FIR is not a conclusive and charge sheet is not a conclusive. Which evidence has to be taken into the consideration? A witness in the box, which is that highest pedestal than the what all the evidences before the court. So even a negligence on the part of the victim deceased, the evidence, if any, came into the box, that is the Supreme Court judgments too recently, 2022 and 23, because I could not able to note the pages with me in the computer. I have now forgotten. Those can be taken and kindly and helpful to the victims and as well as the advocates.
Thank you, sir. Suresh, quickly come and answer those few questions.
Honorable Sri Justice Manmohan Garu, Chairman Bar Council and Bar Council members. I was given the task of answering nearly 5 or 6 papers. I will finish it quickly. In one question, one paper, it was very interesting. Whether Section 269 SS of Income Tax Act has any role to play in Section 138 of NI Act. The Section 269 SS of Income Tax was one of the important section, which says that any loans more than 20,000 rupees or so was given, it shall be by way of bank transaction, check transaction, and penalty was also imposed under Section 271 of the Income Tax Act. The penalty would be, it will be double the check amount. Now the question arises is, what is the situation if a check was bounced under 138 NI Act? So on this, we are having two set of analogies. In one case, R. Channakeshavarao versus P. Lakshmi Narsaya, 2017 2 ALT criminal, page number 279, and this was followed by subsequent judgments of our composite high court. They were being delivered by Justice Suresh Kumar Kait Garu, wherein it was held that an undisclosed amounts in the income tax returns, that was a black money, so it will not fall under the purview of legal enforceable debt. This judgment was one of the first judgment in our high court. Thereafter it was followed in 3-4 judgments. R. Channakeshavarao versus P. Lakshmi Narsaya, 2017 volume 2 ALT Andhra Law Times Criminal, page 279. Justice Suresh Kumar Kait Garu judgment, it was followed by Ayanade inkoka 2-3 judgments icharu 1-2 years lo. It was also followed in subsequently. So Section 269 SS of Income Tax Act will have a connection with 138 NI Act. Whether the amount is legally shown or not, it has its own impact. Similarly, inko question is there any time limit for filing written statement? Order 8 of CPC Rule 1 deals with filing of written statement, but 2002 amendment was there, which says that within 30 days from the date of receipt of summons, written statement has to be filed. But this was interpreted by Apex Court first time in 2005 in Kailash versus Nanku and others. It was reported in 2005 4 SAC, page number 480. This was an election matter. The provisions of Order 8 of CPC is also equally applicable to election petitions. So what Supreme Court said is, the language employed under Order 8 Rule 1 CPC is only directory but not mandatory. But how it was also said that we need to honor this particular time frame because quick disposal of cases. This Kailash judgment was also subsequently followed in Sandeep Thappar versus SME Technologies Private Limited. Sandeep Thappar versus SME Technologies Private Limited, AIR 2014 Supreme Court page 897. AIR 2014 Supreme Court 897. In this case, what the Supreme Court said is impose heavy penalty, heavy costs, since the written statement was not filed within the time. So another letter is, we are having, I don't want to read this, I have read this letter. The advocate who wrote this letter, his problem is there are various law journals like AIR, SEC, ALT, ALD, Live Law. Why should we have all these type of law journals? We want only one, but they are private law companies. Law companies are owned by various different private companies. Even myself and everyone can have our own law companies, but provided we shall register ourselves for the purpose of getting the authenticated judgments. So India, we can't say anything. There are various law journals, SEC, AIR, ALT, ALD. It is up to us to choose and opt what the best. So there will be different law journals. Another letter is, how many matters can be referred to one single arbitrator, and his question is that, can a single arbitrator be referred to number of cases in a particular year? And they also wrote that companies are doing some mischief things like that. So there is no time limit, there is no quantity limit in the Arbitration Act. If we can see in Hyderabad specifically, these companies, chit fund companies, they will have a standard arbitrators 2 or 3. Hundreds of cases will be referred to them by virtue of default appointment of arbitration clause in the loan agreement itself. Naturally, arbitrator will be appointed by the company only, that will be clause. So hundreds of arbitrators also can be appointed. So when we are writing and accepting the terms of the agreement, and if the procedure of appointment of arbitrator is accepted too, you can't oppose for appointment of arbitrator. Another question is, civil suit is filed and decreed in favor of the plaintiff. Thereafter EP was filed and the third party wants to implead. What is the provision of law? So this question, one missing part is there. What is a suit for was not mentioned. I will take it like this. If it is a suit for recovery of money and decreed, and EP is filed for some attachment of property, if a third party wants, he can file under Order 21 Rule 58 of CPC. It's a claim petition under Order 21 Rule 58 of CPC. As per the procedure contemplated under the Code of Civil Procedure Code, the moment when once a claim petition is filed, it has to be treated as a suit itself. Though it is an interlocutory application in pending EP, it's to be treated as a suit. The person, all the formalities of a suit has to be followed, including trial, cross-examination, chief examination. Another letter is, in the first portion, thanks for organizing such wonderful event. All the advocates finds benefited like this. It was a thanks to Chairman Garu and the team of Bar Councils in first paragraph of the letter. My request is, please suggest set of books to follow by junior advocates, which will be helpful. So set of books, what the junior advocates, set of books in the sense, as far as my knowledge is concerned, I request all of you not to go for big commentaries. Just to purchase bare acts first. First understand what the section, what the law, what the legislature is giving. First equipped with that. Thereafter go for big commentaries. There are some confusing books also. The section will be left away with small words and commentary will be highlighted. We will be confused because each publisher may have his own view of commentary. Have some bare acts. Today morning also we have seen many judges, they will refer to bare acts. What the exact legislature is saying. Thereafter go for some commentaries. It depends. Each, if criminal law is there, Ratan Lal, Dheeraj Lal. If constitution is there, H.M. Sirva and D.D. Basu. Likewise, it depends on the subject. And one question is, last question is, can a child also be added in a domestic violence case? Child also can be added, at least to the extent of getting monetary reliefs and interim maintenances. So, I think Chairman Garu for giving this opportunity. Thank you.
Thank you, Suresh. There are general questions. One question is, what is rule of law after address by the in the morning session by Justice Ramakrishna Prasadu? That question may not be now available. That the doubt may not be with them. Very much clarified. If After hearing, if it is not clarified, nobody will be able to clarify. And next is please include clause in drafting and pleadings. In fact, that was also included initially. Ultimately, option was given to Sharma Haryana Sharma Garu. He had chosen the Transfer of Property Act. Therefore, that was left. Next time, it will be there without fail. Next is delay in justice is injustice. Why justice delay in India, especially in civil cases and other? You, I, and others all are responsible. Let us do something more to expeditiously dispose that. And then, respected sir, if possible, provide the material. We tried this time. We could not succeed because so much time we have taken, but even to settle down what are the topics, who are the members, faculty members, resource persons, it become very difficult because it goes on fluctuating. Today they will say, will they come? Tomorrow they will not say, they are inconvenience. Therefore, our efforts stopped there only. We could not do more than that. In fact, we thought of supplying all the barracks in respect of those subjects which are taken up, but because of the time and other constraints, we could not do. Definitely, future we will request to give a note as well so that we can circulate. And another is suggest us an easier way to find citations. Personally, I have been facing a problem in finding so. What are the various sources to find good citations? As we are witnessing that almost in every week, this is one aspect. In fact, morning session, Narra Srinivas have put some efforts, and for want of time, we could not take up now. Next time, he will give you some how to trace out, and many number of persons who are using those softwares and who are using the internet, and how to take in neutral citation also Srinivas Rao explained in the morning. So for the other is concerned, this is relating to the students. As we are witnessing that almost in every week, this is different. As we are witnessing that almost in every week, we the advocates were being resolving boycott from court duties. Whether an advocate boycotting from his court duties comes under section 35 of the Advocates Act or not. It is very much said it is comes under 35 of the Act. Salem case and many number of cases subsequently came. And recently the Bar Council of India conducted a program with the chairmen of all the bar councils and vice chairmen of all the bar councils, deliberated, discussed, they laid down some guidelines, and ultimately they wanted to frame some rules. It is in the process. Boycotting without reason is a misconduct. In fact, recently one of the case arose in the High Court relating to the Guntur Bar Association. Guntur Bar Association, after deliberation, they passed a resolution not to resort to boycott. Previously, on the death of any member of the association, they used it to boycott. Now they stopped like that. Wisdom will prevail unless there is a cause, unless some exceptional circumstances. Advocates are not supposed to boycott. I hope that all of you, because you came from different places, please spread this message, prevail over all there with our brothers, and see that no boycott is there for silly reasons. Thank you. And other questions are general in nature. Some are appreciating the program, and some are suggesting that some topics to be included in the next sessions. They will be taken into consideration. And another is one complaint given against all of us. And students are roaming inside and outside. They shall be asked to sit. This question, if I seen, I would have requested sometime early. Now it has gone. Therefore, students shall be more careful in future. Instead of wasting the time, please use this opportunity. Don't roam outside and inside in future. There is a complaint against advocate friends also. They are murmuring, whispering, without paying attention, disturbing the others beside your people. I requested in the first instance itself not to resort to that. I hope and trust that future we will not repeat that, and we will take all the suggestions that are given in good spirit and try to improve our program in future. Thank you. And we have discharged our promise that every query will be answered, and I appreciate that at least now You came forward with suggestions and queries. Thank you. Thank you. With this, all the sessions comes to an end. Now the valedictory session, Justice Manmad Rao Garu already came long back, but we have detained him because of these difficulties. I apologize to my lord Manmad Rao, and we will go to the next session. మీన్వైల్ ఇంకో క్వశ్చన్ వచ్చింది. బాక్స్ లో వేసినాయి అని చెప్పాను, ఇప్పుడు వస్తాయి అట్లా క్వశ్చన్స్. వితౌట్ గెటింగ్ ద ఎన్ఓసి బై ప్రీవియస్ కౌన్సిల్, కెన్ ఎ న్యూ కౌన్సిల్ విల్ ఫైల్ వకాలత్ బై ది instructions of the parties in civil cases? What is the provision of that? No objection అడిగినప్పుడు ఇవ్వకపోతే there is a procedure. They can file an application in the concerned court, take the permission of the court, engage a fresh advocate. No objection అడిగినప్పుడు ఇవ్వటం మంచిది నాయన, ఉంచుకోబాకండి. నో అబ్జెక్షన్ అడిగితే ఆనందంగా బండిలు ఇచ్చేసి పంపించండి. అన్విల్లింగ్ క్లయింట్ ని ఎప్పుడు కూడా ఎంటర్టైన్ చేయకూడదు. మనకు ఉండే టెన్షన్స్ చాలు, అలాంటి టెన్షన్స్ క్రియేట్ చేసుకోబాకండి. మీ టయాన్ని సద్వినియోగం చేసుకుని మీ క్లయింట్ ఎవడైతే ఇల్లింగ్ వస్తాడో వాడికి సర్వ్ చేయండి. థ్యాంక్ యూ. అయిపోయినాయండి. ఇక లెట్ us క్లోజ్ ది చాప్టర్. థ్యాంక్ యూ.
Welcome to the validity section. Come. No, welcome to our section. First of all, call chief guest of that section. Then staff, then call.
All my students?
Which what is? Then after I will give the call. Done.
Or just a chief guest?
Chief guest and guest. One. 2.
No need for accompanying, only.
No, just 1, 2, 1, 2. Next call.
So 1, 2, 4, 5, 6, 7, 8, 9. A warm, hearty congratulations to everyone who have completed the 3 days 3 days refreshal program for advocates. I now invite the chief guests for valedictory session, Honorable Dr. Justice K. Manmada Rao Garu, High Court Judge of High Court of Andhra Pradesh. We invite you, sir. I request HOD of Law Department, Ms. Vijay Sudha Garu, to present a sapling for the Honorable Justice K. Manmada Rao Garu. I now invite Shri Ganta Rama Rao Garu, Chairman, Bar Council of Andhra Pradesh, onto the dais. I request Professor Mr. Kamsai SVM Garu to present a sapling to Ganta Rama Rao Garu. I now invite Vice Chancellor of KLEF University, Dr. G. Pathasarathi Varma Garu onto the dais. I request Mrs. Nupur Agarwal, ma'am, to come onto the dais to present a sampling to our Vice Chancellor, Dr. G. Pathasarathi Varma Garu. Now I request Sri A. Ramareddy Garu, Member Bar Council of India, to come on to the dais. I request Ms. Chandani Chaudhary Garu to present a sapling to Mr. A. Ramareddy Garu. I now invite Sri Chidambaram Garu onto the dais. I request Mr. Leela Krishna Garu to come onto the dais to present a sapling to Sri Chidambaram Garu. I request Sri Chandrasekhar Reddy Garu, Member of Bar Council Andhra Pradesh, to come onto the dais. I request Ms. Mautushi Thakur Garu to come onto the dais to present a sapling to Sri Chandrasekhar Reddy Garu. Now I request Sri Srinivas Rao Garu, Member of Bar Council, to come on to the dais. I request Mr. Hamad Garu to come on to the dais to present a sapling to Srinivas Rao Garu. Now I invite Sri Subbarao Garu, Muppala Subbarao Garu onto the dais. I request Ms. Kea Garu to give away a sapling to Subbarao Garu. Now I invite Sri Venkata Ramareddy Garu, Member of Bar Council, onto the dais. I request Ms. Rishka Seal Garu to present a sapling to Venkata Ramareddy Garu. I now hand over the program to Sri Ganta Ramarao Garu to preside.
Chief guest of this function, Justice Manmadrao Garu, Vice Chancellor of the KL University, Dr. G. Parsarathi Varma Garu, Bar Council of India member, Sri Ramireddy Garu, my colleagues in the Bar Council, Chidambaram, Chandrasekhar Reddy, Srinivasa Rao, Subbarao, and Venkat Ramireddy Garu. The Law Department HOD, Sudha Garu and his team of faculty members, university staff, my advocate friends, Senior Counsel Posa and Venkateswara Garu and other advocates, my dear friends who have been with us for these 3 days like extended family members, delegates, ladies and gentlemen, on Sunday we met here, started this residential program. Though it is not the first time, initially this kind of program was started as pointed out by me during the inaugural session nearly 15 years back, without having any idea, without having any experience, ventured to conduct such a program with only 100 people at a place with not that much infrastructure, with a single phase transformer, frequent power cuts. Even during night also power cuts are there. We used to sleep on the lawns. They cooperated. It went on well, though there are a number of deficiencies. One of the person vomited in the first day after lunch. One of my friend commented, he is only the sensible person. So the food is that is not good quality. Nobody pointed out. They existed. Because out of the entire state, those 100 people came. We said 100 people, first come, first serve. They came prepared because they don't know what is there. You stay there to learn something. Because what is going to teach also, they doesn't have it. No program sheet like this. No fixed program. Nobody knows what is the next session. Nobody knows what is going to happen next day. Because they cooperated in such a way that encouraged us. Subsequently, continuously, these kind of programs were conducted at Nalsar, at Ikfai, at Bhavani Islands, at Nagarjun Sagar, almost every year before that virus. And combined Bar Council is there. We have conducted. After bifurcation, because of the virus, various different reasons, we could not conduct. This is the first program that was conducted. I proudly can say this is the best team because you can raise any time, point out some defect, but I am thankful no one never tried to point out defect. Maybe in spite of, because university management has provided us excellent facilities. అంటే తెలుగులో చెప్పాలంటే ఒక అల్లుడు ఇంటికి వస్తే ఎలా చూశారో మనల్ని అలా చూసుకున్నారు ఈ కూతురు. వాళ్ళ ఇంట్లో పెళ్లి జరిగితే ఎంత అరేంజ్మెంట్ చేశారో అంతకంటే ఎక్కువ చేశారు మనకి. ప్రతి ఒక్కళ్ళు కూడా అంటే ఇక్కడ మనకి ఇక్కడ మనం చేసుకున్నంతసేపు లంచ్ దగ్గర, డిన్నర్ దగ్గర, ఎక్కడికి పోయినా, యోగాకి పోతే అక్కడ దారిలో సెక్యూరిటీ వాళ్ళైనా సరే, దే హ్యావ్ గివెన్ ఏ స్పెషల్ ట్రీట్మెంట్. We felt that we are at our own home. That is the one of the main reason for grand success of this particular program. First, I should thank to my friends in the Bar Council. They also never, these kind of programs never question, never stopped me. Always they encourage whenever I propose. Anonymously. That's how I could be able to plan and conceive and conduct these kind of programs. They extended unconditional support. My dear friends, this is a continuous process I am promising you. And it is the obligation of the Bar Council, by way of continuous education program, we are supposed to conduct these kind of programs. In fact, we had a schedule, entire 13 districts to complete within a 1 year, and we conducted one program at Guntur, one program at Kadapa. My friend Venkatraman Reddy is on the dais, and he has taken such a interest that so far, after the Bar Council, no program was conducted at Kadapa. It is the first time, due to the interest taken by my friend, we are able to conduct a program at Kadapa. After the Bar Council, though Honorable Chairman at that time hails from Kadapa district, Yalla Reddy is my good friend, because that culture is not there at that time. That's why I am saying, conducting program by us, spending some amount is not the consideration. It is ultimately cooperation of the members of the bar. You should not feel that it is something by attending you are helping helping us. It is not so. Wherever we conduct at the district level, you should take interest, you should demand, you should request, you should extend cooperation. Then only the Bar Council will be able to conduct these kind of programs. The interest you show will be the deciding factor for success of any program. I have no doubt in my mind that after these 3 days program and the way that you have conducted yourself here encouraged us, we will multiply efforts with more vigor and more confidence, and we will put all our efforts. And so far as this aspect is concerned, I can proudly say now also, in entire, I don't know the other parts of the country, entire southern bar councils, our council is a leading council so far as conducting of these continuous education programs are concerned. And another is cooperation among the bar council members. COP, you might have seen. COP conceived to eliminate the non-practicing advocates. I can proudly say it is only the Bar Council of Andhra Pradesh which has completed the entire process which is in our hands. And in fact, we prepared a list of defaulting advocates or non-practicing advocates, and the final formality we have to do, but we could not do because of that formality. Meanwhile, Supreme Court of India constituted a committee, and now it has to be done under their supervision. It will be delayed, but we have no option. And my dear friends, I don't want to waste time because chief guest is here. Chief guest is here, and I take this opportunity to thank the entire university management, Satyanarayana garu, in his absence because he has taken such a care. When I went to Sachan Garu with Srinivas, he readily accepted. Not only accepted, I was told that, in fact, as on that date, some staff are there. He called them in our presence. He entrusted the entire activity to them. And I was told that, in fact, he visited the campus. He has instructed all the deans and every possible thing that can be done in their hands, they have done. They extended unconditional support, but for their support, we could not have done this program in this manner. Therefore, I thank the management, I thank the Chancellor, I thank head of the department and other staff members because all these 3 days they have been with us. And I also thank students who have been with us. They are available with us. They did not allow us to do any work. They have undertaken on our behalf. And I thank all the persons. I will be failing in my duty if they don't thank Sri Dr. Venkata Ram, Professor, Pro VC Garu, Dr. V. Rajesh, Dean, and Dr. K. Subbarao Garu, Registrar, Hanumantrao Garu, Dean, Student Affairs, M. Kishore Babu Garu, V. Rajesh, Dean, Dr. Srinath, who was overall in charge of this program. He was made Dean of, Mr. Srinath was made for overall in charge. In fact, you will be surprising, this hall is not available. We were given only a seminar hall, which will take only 400 people. Therefore, we have closed the registration after reaching 350 within 3 days. Then they have taken efforts. They deployed the extra labor and they made it ready and handed over to us. And when they said that it is available, then again open. Now the total registration is 680 delegates were registered, and apart from the students. Dr. Hanumantrao Garu, Dean Student Affairs, who has taken care of accommodation of all the delegates, and Pavan Kumar Garu, Principal College of Law, and Shiv Kumar, Associate Dean and Professor of ECE, Mr. G. Vijay Sudha Madam, who has been with us. Even we go outside sometimes. She has been sitting here only, paying full attention. Mohsin Thakur, Deputy HOD, Hari Yoga instructor, and another factor is, in the morning, we conducted yoga also. When we went there these 2 days, I think that some of our delegates, but I have a complaint that though 300 people are staying here, you could not come to the yoga. The very few people attended there and got the benefit. I expected at least 200 of you will take advantage of that, because we attended. We know what is the advantage of that. And this facility is nearer to us, available. We will not realize the facility which is readily available. And we shall express our gratitude to Hari, who is the yoga instructor, Madam Pujita, who has taken a personal care, and all the law faculty members, students who are responsible for making this program a grand success. You should thank all of them with a big applause. Lastly, I thank all of you, because on the day I told you, don't disturb anything. You may not be able to help, but don't disturb. That was followed. Nothing, no complaint is received by us from the management that any of the delegate anywhere transgress their limits. Thank you very much, and thank everybody who made this program a grand success, including that lady who is here, always serving us with whatever is required. Thank you, one and all. Now I request Ram Reddy Garu, because the honorable chief guest has to go somewhere else, because other members volunteered that we need not talk on this occasion. I request Ram Reddy Garu, member Bar Council of India, to address for not more than 5 minutes.
Condition. Today's our chief guest, Justice Dr. Manodharav Garu, Ganta Ramararu, Chairman Bar Council of Andhra Pradesh, Professor Parsad Garu, Vice Chancellor of this university, my colleague members, Chandrasekhar Reddy Garu, Chidambaram Garu, Subbarao Garu, Vajja Srinivasarao Garu, Venkatram Reddy Garu, staff of the university, and my dear colleague advocates, ladies and gentlemen, good evening to everybody. I am very happy today's function. Morning, I told our chairman, in Telangana, ICFA University is there to good facilitate to the training programs. Now, Andhra Pradesh, KL University, we are a boom of that university in Andhra Pradesh to training program. We are very happy to conduct the program. I will thanks to Chancellor, Vice Chancellor, staff of the college, and students and professors. Very good arrangement of program. In Andhra Pradesh, the continually legal training program since 2007. Previously, they were not conducted properly. After 2007, continually, except 2 years Corona period, we are conducting the training program. And the Bar Council of India also conducted the training programs. But at Bhubaneswar, we are starting a law teacher training center. It is going on. And now, law training advocates academy at Goa, we have to start couple of months as early as possible. To entire country, there is only one law academy at Goa. We started. And the Bar Council of India has conducted the giant workshop shortly, Vijayawada, Anantapur, and Rayalaseema region, one region, along with the Bar Council of State. Regarding training programs, some of the students are asking to the advocates the study material. In Maharashtra, they are issuing the material, some concession rate. They simplify the subjects and study material to all the training students. Maharashtra Bar Council has supplied. And I suggest to our Bar Council members and chairman, we are also planning to next year, we have to print the study material for the cost of lowest cost, not for a free of cost, but minimum cost of that books we will provide. I am assuring you that with the permission of our chairman members, we have to give that study material. It is useful to the training as well as the practice also. And regarding training programs, so many students advocates are not interested to participate. But once participate the program, they will be happy because net is very, even we have to see the mobile phone 1 hour, 2 hour, but hearing is half an hour is better than that net program. So that's why everybody physical hearing is most benefit to the practical advocates. And as well as Bar Council of India, COP, and other programs were continually conducting the program. So many advocates are not submit the COP. That is why the COP to postpone to the other some other days. ఈ మధ్యనే సుప్రీం కోర్టు ఒక మానిటరింగ్ కమిటీ ఏర్పాటు చేసింది. 9 members of monitoring committee to verify the COP. 2 is Supreme Court judges, 2 is High Court judges, 2 is Supreme Court advocates, and 3 is Bar Council members, and other 2 members. 9 members are monitoring committee appointed by the Honorable Supreme Court, so that the fake advocates will be detained by the monitoring committee. And one more thing is the Advocate Protection Act is pending Union Law Minister. We are trying to implement that Advocate Protection Act. I am also one of the committee in that Advocate Protection Act Bill Act. So as early as possible, advocate protection bill, and insurance, nationwide insurance policy also. Now we are in a state bar council mediclaim policy, and we are trying to nationwide mediclaim policy also getting. We have met so many times Prime Minister, Union Law Minister, as early as possible. We will come to the proposal. And once again, I thank you to the university authorities, and thank to the Bar Council of Andhra Pradesh, my colleague members and our chairman, to take risk since 15 days. It is not so easy to conduct the training program. Resource persons, very organized, very difficult to the minimum 10-15 days. This program will be arrangement to take risk. That's why I must congratulate our chairman and our colleague members, and to give the opportunity to the training program to the university chancellor, vice chancellor, and staff of the university. Thank you once again. Particularly congratulate the participants of the advocates, juniors and seniors. I thank you very much. Thank you very much.
Now I request the Honorable Vice Chancellor, Dr. G. Pardasarathi Varam Garu, to address all of us.
The dignitaries in the dais, and the delegates of this 3-day workshop or refreshment course. And we're very happy that actually the participants was from first day onwards to here. The number of participants is presented here. And the other side, the judges, out of their time, actually sparing valuable time, their valuable time in the campus, and from the Chief Justice to everyone, actually they spend their valuable time and given a lot of clarity on the activities at this place. And other side, actually, our team, like university team, was wonderfully arranged. Everyone actually at the activity, from the management to down level, down to everyone at this place, was committed to do the service to the Bar Council at this place. In the moment, actually, the Ganta Ramaragaru approached our Chancellor, he immediately instructed me to, Chancellor instructed me to take care of this activity and we will sponsor everything at this place. And our side at this place is we have started, we have a law college in the campus, law school here, and definitely this is a great opportunity for all our students to have a connect with every one of you. And already the batches was passed out. Every faculty spend that almost from 1 week they're spending their valuable time here. They're working at this place, connecting with you, and that is what is expected from our side. Actually, from that is going to be a benefit for us. Definitely, this is a right gathering where we can serve for the people and also take the inputs that take the advantage that the exposure for our students and the faculty will definitely change from these activities. That is what is the expectation. With that expectation, we worked out actually. Not only that, actually, our dean, the student affairs, he is in charge of the hostels. He is working for this from last 1 month, and day and night he is here and taking care of everyone's care at this place. And he is a committed man. 24 hours he works on that. Actually, I really appreciate the team working in this process. The other side, the Srinath is in charge for this, and from last 1 month he is running after everyone actually and taking care of the activity at this place and to a grand level, because we want this activity to be a grand level at this place. And Dean P&D Rajesh Garu took this as a challenge actually, and this is this conference hall is not ready at the time actually, and he is taking care of the converting that. And this conference hall is there. This auditorium is ready. Is there, but because of the summer we do some maintenance process. In that case, he made everything is possible to happen within a week. Actually, the maintenance has happened out there. So, other side, the Department of Law was taken this as a challenge, and from principal to the HOD and the faculty, everyone of here at this place, and they learned several things, organizing skills, connections, and the exposure for them has improved. The students who organize everything. I really appreciate the student efforts in this place. Every student is taking care of this. Every student is here, and I really appreciate the student efforts in this place. And combining all this with a nice, a delegation here, and and the mentorship of the judges and the lawyers and the bar council, this was made a wonderful grand success in this place. Now I'd like to announce that actually from here onwards, anything is needed from the bar council, we are ready to arrange for it, and we also expect a national-wide bar council meeting can also be conducted in our campus, and we are ready to take it up, and we'll support everything at this place, and definitely this is a wonderful event has happened. One and whoever is been at this place and worked for this activity, I really congratulate them and really thank them for making this event a grand success. Thank you very much.
Thank you, sir. Now we can proudly claim that we are ready to hold not only the Southern Bar Council meet, but also All India Bar Councilors meet. Thank you very much, sir. Now we are waiting for the message of the chief guest, Justice Manmadharao Garu. Justice Manmadharao Garu started his journey as an official advocate, as a practicing trial courts, and after gaining considerable experience, shifted to the High Court, and after practicing in the High Court, rightly elevated to the bench, and he is already having considerable experience as a judge of the High Court. He is the right person to address us on this occasion. I request Sri Justice Manmadharao Garu to give his message.
ఈరోజు మీ అందరి ముందు ఇలా రావడానికి నన్ను బార్ కౌన్సిల్ తరపున బార్ కౌన్సిల్ చైర్మన్ గంటా రామారావు గారు, మీరు ఏదైనా ప్రోగ్రామ్కి మేము 3 days ప్రోగ్రామ్ జరుపుతున్నామండి, మీరు 3 రోజుల్లో ఏదో ఒక సెషన్లో ఏదో ఒక సెషన్ చెప్పడానికి వస్తే బాగుంటుందని నన్ను అడిగారు. అయితే సెషన్స్ కన్నా కూడాను నేను కొద్దిగా ఇలా మాట్లాడడానికి ఇష్టపడతాను కాబట్టి సెషన్ కన్నా నాకు ఇంకేదైనా అవకాశం ఉంటే ఇవ్వండి అని అంటే ఆ రోజు ఆఖరి రోజు ఫైనల్ చేసుకోవడానికి నా దగ్గరికి చిదంబరం గారును గంటా రామారావు గారు వచ్చినప్పుడు, సరే సార్ మీరు అడిగినట్లుగా మేము వాలిడిక్టరీలో మిమ్మల్ని చీఫ్ గెస్ట్గా పిలుస్తాము అన్నారు. అన్నట్లుగానే నన్ను ఈ కార్యక్రమానికి పిలవడం జరిగింది. అయితే ఈ కార్యక్రమాన్ని ప్రారంభించే ముందుగా బార్ కౌన్సిల్స్ మెంబర్స్ రామారావు గారి గంట చైర్మన్ గారికి, అలాగే రామిరెడ్డి గారు మెంబర్ బీసీఐ గారికి, చిదంబరం, చంద్రశేఖర్ రెడ్డి గారు, శ్రీనివాసరావు, సుబ్బారావు ముప్పాళ్ళ, వెంకటరామరెడ్డి, వీరందరికీ, అలాగే ముఖ్యంగా ఈ కార్యక్రమాన్ని ఇంత ఇదిగా ఇక్కడ జరుపుకోవడానికి బార్ కౌన్సిల్ వాళ్ళకి అవకాశం ఇచ్చినటువంటి కేఎల్ యూనివర్సిటీ ఛాన్సలర్ కోనేరు సత్యనారాయణ. ఎందుకంటే అడ్వకేట్లు జరుపుకునే కార్యక్రమానికి ఇటువంటి ఒక గొప్ప, అంటే ఫెసిలిటేట్ చేయటం వేరు, ఆ ఫెలిసిటేషన్లో వీళ్ళందరూ చెప్పిన ఈ 3 రోజుల ప్రకారం చూస్తే చాలా సక్సెస్ఫుల్గా గంటా రామారావు గారి కార్యక్రమాన్ని వాళ్ళ మెంబర్స్ తన ఆలోచనలకు అనుగుణంగా ఈ కార్యక్రమాన్ని ఎంత చక్కగా తీసుకెళ్లాలనుకుంటే దానికి తగ్గ ఇన్ఫ్రాస్ట్రక్చర్, ఇక్కడ ఉన్నటువంటి సౌకర్యం, అనేది ఎంతో ఈ ప్రోగ్రామ్ సక్సెస్ కావడానికి అవకాశాన్ని కల్పిస్తుంది. అటువంటి అవకాశాన్ని ఇచ్చినటువంటి మరి యూనివర్సిటీ వారికి ప్రత్యేకంగా ధన్యవాదాలు తెలుపుకోవాల్సిన అవసరం ఉంది. అయితే ఇక్కడ ఇదే వేదిక మీద ఉన్నటువంటి పార్థసారథి వర్మ వైస్ ఛాన్సలర్ గారు డాక్టర్ ఆల్రెడీ తన అభిప్రాయాన్ని వెలిబుచ్చారు. ఇటువంటి కార్యక్రమాలు ఎన్నో మా యూనివర్సిటీలో జరిగితే మేము ఎల్లప్పుడూ ముందుండి తగిన సహాయ సౌకర్యాలు అందిస్తాం. తప్పకుండా ఈ కార్యక్రమాలు బాగా జరుపుకునేదానికి అవకాశం ఉంటుంది. సో వారికి కూడా ధన్యవాదాలు తెలుపుకుంటూ మీ అందరికీ గత 3 రోజులుగా ఇక్కడ ఈ కార్యక్రమంలో పాల్గొనే దానికి నేను నా కొన్ని సూచనలు మాత్రం మీ అందరికీ తెలియజేయాలనుకుంటున్నందుకు, నాకంటూ అవకాశం ఇచ్చినందుకు అందరికీ ధన్యవాదాలు తెలుపుకుంటూ, అయితే ఈ కార్యక్రమం ఎలా జరుపుతున్నారు అని విన్నప్పుడు, తర్వాత ఇక్కడికి వచ్చి చూసిన తర్వాత నాకు అనిపించింది ఏంటంటే, అంటే దగ్గర దగ్గరగా 680 మెంబర్స్ ఎన్రోల్డ్ అయినారు ఒక కార్యక్రమానికి రావడానికంటే. నేను మొట్టమొదటిసారిగా అడ్వకేట్స్ లో ఇంత ఉత్సాహంగా ముందుకు వచ్చి రాష్ట్ర వ్యాప్తంగా జరుగుతున్నటువంటి కార్యక్రమంలో పాల్గొనటం, అవకాశాన్ని కల్పించిన బార్ కౌన్సిల్ వారి ఆలోచనకు నిజంగా హ్యాట్స్ ఆఫ్ చెప్పాలి. ఎందుకంటే ఒక రోజు సెమినార్ జరపటం అంటేనే ఈరోజు ఆలోచిస్తున్న పరిస్థితి. సో అలాంటిది 3 రోజులు ఈ రెసిడెన్షియల్ ఓరియంటేషన్ ప్రోగ్రామ్ జరగటం నిజంగా చాలా గొప్ప విషయం. అయితే మీ అందరి ముందు కూడా ఈరోజు గొప్ప ఈ కార్యక్రమం జరిగిన తర్వాత మీరు మీ మీ ప్రాంతాలకు వెళ్ళిన తర్వాత ఎంతవరకు ఈ కార్యక్రమంలో మీరు అంటే మీకు తెలియని విషయాలు చెప్పారని నేను అనుకోను. ఎందుకంటే ఇక్కడ గమనించినంతలో స్టూడెంట్స్ ఉన్నారు, తర్వాత స్టూడెంట్స్ తో పాటుగా అడ్వకేట్స్ అంటే దాదాపు ఒక 3 ఏజ్ గ్రూపులుగా కనపడతా ఉన్న పరిస్థితి నాకైతే కనపడతా ఉంది. మరి రామారావు గారు మరి ఈ క్రైటీరియా ఎలా ఫిక్స్ చేసుకున్నారు నాకు తెలియదు, కానీ అంటే నేను అనుకుంటున్నంతలో బిలో 5 years కానివ్వండి, బిలో 10 years కానీ అప్ టు 20 years దాకా ఉన్నోళ్ళు కూడా ఉన్నారేమో ఈ కార్యక్రమానికి. అబౌవ్ 30 కూడా అంట. గుడ్. నిజంగా 32 years తర్వాత కూడా ఇంకా మేమేదో ఇక్కడ వెళ్ళారని చేయాలి, ఇక్కడ నేర్చుకుందాం, ఇక్కడ ఏదో చెప్తారు అన్నటువంటి ఒక ఉత్సాహాన్ని నిజంగా వారు చూపిస్తున్నందుకు కూడా. ఎందుకంటే అడ్వకసీ ఎప్పుడు నేర్చుకోవాల్సిందేనండి. ఈ రోజుతో ఏదో లా కాలేజీలో 3 ఏళ్ళు చదివాము, తర్వాత ఒక జూనియర్ దగ్గర ఒక సీనియర్ దగ్గర జూనియర్ గా ఉన్నాము, ఏదో దానికేం పీరియడ్ లేదనుకోండి ఒక సీనియర్ దగ్గర జూనియర్ గా ఉండడానికి. సో అక్కడితో మాకెంతో వచ్చేసింది. ఒకవేళ మేము ఇండిపెండెంట్ ప్రాక్టీస్ వెళ్ళాలనుకుంటే మాకెన్నో విషయాలు తెలుస్తాయి, అందుకని ఇండిపెండెంట్ ప్రాక్టీస్కి వెళ్ళిపోవచ్చు, విషయాలు తెలుస్తాయి, ఇండిపెండెంట్ ప్రాక్టీస్కి వెళ్ళిపోవచ్చు అనే అభిప్రాయం మటుకి అలా అనుకుంటే ఈ వృత్తిలో ఏమి నేర్చుకోనట్టేనండి. ఇంకా నేర్చుకోవాల్సింది ఎప్పుడూ ఉంటుంది. అందుకే ఒక రకంగా 30 years దాటినటువంటి ఎక్స్పీరియన్స్ దాటినటువంటి న్యాయవాదులు కూడా ఈ కార్యక్రమానికి వచ్చారు అంటే నిజంగా గొప్పగా వాళ్ళ ఈ 3 రోజులు ఈ రెసిడెన్షియల్ ప్రోగ్రామ్ నిజంగా టైం స్పెండ్ చేయడం అంటే గొప్ప విషయం. అందువల్ల వాళ్ళందరినీ కూడా ప్రత్యేకించి అభినందించాల్సిన అవసరం ఎంతో ఉందనిపిస్తుంది. ఎందుకంటే న్యాయవాదిగా ఇప్పుడే అనుకున్నట్లు న్యాయవాదులుగా మీరు ఎన్ని సంవత్సరాలు, అది సీనియర్ అడ్వకేట్స్ కానివ్వండి, ఇది నిరంతరం ఎప్పటికప్పుడు ఈ రోజున ఇక్కడ ఉన్నటువంటి బార్ కౌన్సిల్ మెంబర్స్ లో కూడా సీనియర్ అడ్వకేట్స్ ఉన్నారు. సీనియర్ అడ్వకేట్స్ అంటే హైకోర్టు గుర్తించి చెప్పండి సీనియర్ అడ్వకేట్స్ అవనివ్వండి, అలాగే మీ ట్రయల్ కోర్ట్స్లో కూడా బై వర్చ్యూ ఆఫ్ ఏజ్, బై వర్చ్యూ ఆఫ్ ఎక్స్పీరియన్స్ వాళ్ళని సీనియర్ అడ్వకేట్స్ అంటూ ఉంటారు. కాబట్టి ఆ క్రమంలో కూడాను వాళ్ళు ఎప్పుడూ నిరంతరము తెలుసుకోవాల్సిన విషయాలు ఎక్కువ ఉంటాయే కానీ ప్రత్యేకించి ఇది ఇంతటితో అయిపోయింది అని అనుకోవటంలో ఇది ఇంత ఈ రోజుకి ఇది చాలు, ఇది నేర్చేసుకున్నాము, ఇంకొచ్చేసినట్టే, లా సబ్జెక్ట్ అంతా వచ్చేసినట్టే, మేము వృత్తిలో చాలా నైపుణ్యాన్ని సంపాదించాము అనుకుంటే అది ఏ విషయంగానూ ఆలోచించే విధానం కరెక్ట్ కాదు. ఎందుకంటే మనం ఎంత నేర్చుకుంటే ఈ వృత్తిలో ఏదో లా 3 సంవత్సరాలు చేశాము, 3 సంవత్సరాలతోటి ఈ 3 years ఇప్పుడు వచ్చినటువంటి 5 years కోర్స్ అయితేనేమండి, మీకు 3 yearsలో ఆ 3 years కోర్స్ చేసిన వాళ్ళు కానీ 5 years కోర్స్ చేసిన వాళ్ళలో కూడా అప్పుడు ఉండేవే ఇప్పుడు ఉన్నాయి. యూనివర్సిటీ ఫస్ట్లు, గోల్డ్ మెడలిస్టులు, సబ్జెక్ట్ వైజ్ గోల్డ్లు, టోటల్ సబ్జెక్ట్లో గోల్డ్ మెడలిస్టులు, వీళ్ళందరూ కూడా ఉండే పరిస్థితి అందరూ చూసున్న పరిస్థితి. అయితే గోల్డ్ మెడలిస్టులు వచ్చిన వాళ్ళు ప్రాక్టీస్లో ఎంతవరకు షైన్ అయ్యారు, అలాగే ఏ మెడలు లేకుండా ఉన్న వాళ్ళ మెడతోటి, మెడల్స్ లేకుండానే ఉన్న వాళ్ళ మెడతోటి ఎంతమంది ప్రాక్టీసుల్లో షైన్ అయిన వాళ్ళు ఉన్నారు. సో గోల్డ్ మెడల్ అనేది ఓన్లీ చదువుకునే వరకే ప్రధానం కానీ వ్యక్తిగతంగా మనం వృత్తి నైపుణ్యంలో కానీ వృత్తిరీత్యా కానీ అది ఎంతవరకు దోహదపడుతుందనేది మీ అందరికీ పాటికి అర్థమైపోయి ఉంటుంది. అది నేను ప్రత్యేకించి చెప్పాల్సిన అవసరం లేదు. ఎందుకంటే కొత్తగా వచ్చినటువంటి అడ్వకేట్స్, ఎన్రోల్ అవుతున్న అడ్వకేట్లకి అది పెద్దగా డిఫరెన్స్ తెలియకపోవచ్చు, కానీ మరి మినిమం ఏదైతే క్వాలిఫికేషన్ మీరు అందరితో ఇక్కడ వచ్చున్నారు కాబట్టి అన్ని విషయాలు మీకు తెలిసే ఉంటాయి. ప్రత్యేకించి నేను చెప్పాల్సిన పరిస్థితి అయితే లేదని అనుకుంటున్నాను. అయితే మనం ఈ ప్రోగ్రామ్స్ ఎందుకు, ఈ ప్రోగ్రాంలు తీసుకోవాల్సిన అవసరాన్ని గనక వీటన్నిటిని గుర్తించాల్సిన అవసరం చూసుకుంటే, చాలా ఇప్పుడు బార్ కౌన్సిల్ కార్యక్రమాలు ఒక 3-day ప్రోగ్రాంగా ఇది జరపడమే కాకుండా కొన్ని చోట్ల ఈ మధ్య కాలంలో డిస్ట్రిక్ట్ వైజ్ కూడా కొన్ని కార్యక్రమాలు జరుగుతున్నట్టుగా, కొన్ని కార్యక్రమాలకు అప్పుడప్పుడు మేము కూడా హాజరు కావడం జరుగుతుంది, అటెండ్ అవుతా ఉన్నాం. సో ఆ కార్యక్రమాలు సరిపోవండి చెప్పాలంటే. ఈ 3-day ఓరియంటేషన్ ప్రోగ్రాం కూడా సరైన క్రమంలో మీకు ఫుల్ ఫ్లెడ్జ్డ్గా తెలుస్తుందన్న విషయము పూర్తిగా రిఫ్రెష్ అవుతుంది. అంటే ఎప్పటికప్పుడు లీగల్గా మనం అప్డేషన్లోకి వెళ్తున్నామా లేదా అని ఆలోచించుకుంటున్న పరిస్థితుల్లో, ఎందుకంటే ఇంతకుముందు ఇప్పుడు ఇక్కడ ఈ క్వెరీ బాక్స్ గురించి మాట్లాడుతూ కొన్ని సైటేషన్స్ సెర్చింగ్ విషయంలో కూడా ఎలా ఉంటుంది అన్న విషయాన్ని ఇంకా కొన్ని ప్రాంతాల్లో సరైన అవగాహన లేని పరిస్థితిగా మాట్లాడినటువంటి ఒక ప్రశ్న అడిగినటువంటి పరిస్థితిని గమనించుకుంటే, అయితే ఇప్పుడు ఒకప్పుడు ప్రాక్టీస్కు అంటే ఫర్ ఎగ్జాంపుల్ నా వరకు నేను తీసుకుంటే, నేను 30 సంవత్సరాలు ప్రాక్టీస్ చేసి తర్వాత న్యాయమూర్తిగా వచ్చిన తర్వాత, అది ఒక రూరల్ బ్యాక్గ్రౌండ్ నుంచి దాదాపు 8 సంవత్సరాల పాటు ట్రయల్ కోర్టులో ప్రాక్టీస్ చేసి ఆ రోజుల్ని గనక చూసుకుంటే, ఈ రోజున ఉన్నటువంటి మా సబార్డినేట్ కోర్ట్స్ని కనుక చూసుకున్నా కూడా డిఫరెన్స్ అయితే చాలా ఉన్నదండి. నేను అబ్జర్వ్ చేసినంతలో, నేను 91లో నా లా పూర్తి చేసుకొని 98 వరకు నేను ట్రయల్ కోర్టులో ప్రాక్టీస్ చేశాను. ఆ క్రమంలో మాకు లైబ్రరీ ఫెసిలిటీస్ కానీ అంతగా అంటే ఆ బార్లో ఉండే అప్పటి సీనియర్ అడ్వకేట్స్, బార్ అసోసియేషన్స్ వాళ్ళ ఉన్న ఇంట్రెస్ట్ని బట్టి లైబ్రరీస్ ఉండేవి, కానీ ప్రత్యేకించి లైబ్రరీలు చాలా చోట్ల లేని పరిస్థితి. అలాగే ఇంకా ఎన్నో విషయాల్లో ఈ రోజున టెక్నాలజీ వచ్చింది, ఎన్నో అవకాశాలు వచ్చినాయి, అన్నీ కూడాను మనం త్రూ నెట్ ద్వారా అన్ని చూడగలుగుతున్న పరిస్థితి. అయితే అందరికీ ఈ కంప్యూటర్ ఎడ్యుకేషన్ ఉన్నదా, టెక్నికల్ స్కిల్స్ని మనం ఎంతవరకు చూడగలుగుతున్నాము అంటే ఈ రోజున ఎక్కువ మంది జూనియర్స్ ఎవరైతే ఫ్రెష్ జూనియర్స్ అంటే ఇటువంటి కార్పొరేట్ కాలేజీల్లో చదువుకొని కేఎల్ యూనివర్సిటీ లాంటి లా కాలేజీల్లో ఇంకా కొన్ని అదర్ యూనివర్సిటీస్ నుంచి వచ్చే ఈ కార్పొరేట్ ఓరియంటేషన్లో చదివి వస్తున్న 5 years కోర్సు వాళ్ళకు మాత్రమే ప్రత్యేకించి కంప్యూటర్స్లో స్కిల్స్ నాలెడ్జ్ ఉన్నటువంటి వాస్తవాన్ని దానికి సంబంధించినటువంటి సబ్జెక్ట్స్ని తీసుకోవటం జరిగింది. అయితే వీటన్నిటినీ వాళ్ళు నేర్చుకుంటున్నారు, ఇప్పుడున్న తరం నేర్చుకుంటూ ఉంది. మీరందరూ కూడా అది క్రాస్ అయ్యి వచ్చారు. మరి మీరు నేర్చుకోలేరా, మీరు తెలుసుకోలేరా, దానికి అలవాటు పడలేరా అంటే చాలా ఈజీ అండి. అందరం వాట్సాప్లు వాడుతున్నాం, వాట్సాప్లో మెసేజ్లు పెట్టగలుగుతున్నాం, వాట్సాప్లో చాటింగ్లు, వాట్సాప్లో యూట్యూబ్లో ప్రోగ్రామ్స్ మనకు నచ్చినవి చూస్తున్న పరిస్థితిని ఈరోజు అందరికీ అలవాటు వచ్చింది. నాకు తెలిసి ఒక 10 ఏళ్ల క్రితం నేను హైకోర్టు అడ్వకేట్గా ఉండి మొబైల్ వాడలేదు, కానీ ఆ తర్వాత 10 ఏళ్ల తర్వాత 10 ఏళ్ళు వెనక్కి అని అనుకుంటే అందరికీ అప్పుడు దాని గురించి అవగాహన వచ్చిన పరిస్థితి. ఇప్పుడు ఇంకా దాని మీద ఇంకా పెరిగింది దాని గురించి. అయితే వీటన్నిటికి కాను చాలా మంది ఇప్పుడు ఆపరేట్ చేస్తాం, నేను మొబైల్ వాడుతున్నాను. చాలా మంది ఇప్పటికి మా పిఎస్ల మీద నేను ఆధారపడుతుంటాను. కొన్ని ఇష్యూస్ ఏవైతే సపోజ్ ఏదో మనీ ట్రాన్సాక్షన్స్, ఏదో ట్రైన్ బుకింగ్స్, అలాగే ఫ్లైట్ బుకింగ్స్, ఇలాంటివన్నీ కూడాను మా పిఎస్ల మీద ఆధారపడాలి. కానీ అదే ఇప్పుడు మా పిల్లలు ఉన్నారు, వాళ్ళందరూ అలాగే మీ పిల్లలు కూడాను వాళ్ళందరూ కూడా అలవాటు పడి వాళ్ళే చేస్తున్న పరిస్థితి. అయితే మనం ఈ వయసులో మీరు ఆ టెక్నాలజీని మనం తీసుకోగలమా లేదా అంటే తప్పకుండా తీసుకోవచ్చు. అలాంటి దానికి మీరు అలవాటు ఎందుకంటే ఈరోజు ఒకప్పుడు లేదు. ఈ కరోనా ముందైతే కరోనా తర్వాత అనుకుంటే టెక్నాలజీని వాడుకోవడానికి కరోనా తర్వాత అందరం అలవాటు పడ్డాం. ప్రతిదీ టెక్నాలజీ ద్వారానే నడుస్తున్న పరిస్థితి. అయితే అందువల్ల ఆపర్చునిటీస్, ఎన్నో అవకాశాలు పెరిగాయి. ఆ అవకాశాలను అందిపుచ్చుకోవాల్సినటువంటి అవసరాన్ని, ఏదో ట్రయల్ కోర్ట్స్లో ఉన్నాం, ఏదో ప్రాక్టీస్ నడిచిపోతా ఉంది, ఏవో వస్తున్నాయి, బెయిల్స్ వేసుకుంటున్నాం, సరే మెజారిటీ క్రిమినల్ ప్రాక్టీసే కాబట్టి ఈ రోజున సివిల్ కోర్టుల్లో సివిల్ సైడ్ అంత ప్రాక్టీస్కి పెద్ద ప్రిఫరెన్స్ లేదు, క్రిమినల్ ప్రాక్టీసే ప్యాషన్ ఎక్కువగా కనపడుతున్న పరిస్థితి. అది మేము చేసినప్పటి నుంచి ఉందండి, ఇప్పుడు ప్రత్యేకించేది ఏం కాదని నేను దాన్నేమి విమర్శగా చెప్పట్లేదు. మోర్ ఇంట్రెస్ట్ ఏది ఉంటే అది ఎక్కువ వెళ్తాం కాబట్టి. అలాగే ఆ క్రమంలో ఎన్నో ఈ క్లాసెస్, మన ఈ బార్ కౌన్సిల్ ఈ ఓరియంటేషన్ క్లాసెస్ పెట్టడం గురించి రావడం గురించే కాదు, ఇప్పుడు యూనివర్సిటీస్ కూడా చాలా మన లీగల్ సబ్జెక్ట్స్ మీద చాలా సబ్జెక్ట్స్ ఆఫర్ చేస్తున్నటువంటి పరిస్థితి ఉన్నది. సో నేను ఆ క్రమంలోనే కామన్ హైకోర్టులో హైదరాబాద్లో ప్రాక్టీస్ చేసేటప్పుడు దాదాపు 1991లో ప్రాక్టీస్ పూర్తి చేసి ప్రాక్టీస్లోకి వచ్చేసి మళ్ళీ 2001లో హైదరాబాద్లో ప్రాక్టీస్ చేస్తున్నప్పుడు సెంట్రల్ యూనివర్సిటీ వాళ్ళు పీజీ డిప్లొమా ఇన్ సైబర్ లాస్ అని చెప్పి ఒక కోర్సును ఇంట్రడ్యూస్ చేశారు. ఫర్ అప్డేషన్ యాజ్ ఏ అడ్వకేట్గా ఆ సబ్జెక్టుల మీద నాకు అంత అవగాహన ఉండేది కాదు, కానీ ఓ కొత్త సబ్జెక్ట్. ఎందుకంటే లాలో ఎప్పుడు మనకు చాలా కొత్త సబ్జెక్టులు వస్తూ ఉంటాయి. చాలా మంది నేను గమనించింది ఏంటంటే మన అడ్వకేట్స్లో ఉండే ఆలోచన, మైండ్ సెట్. నేను ట్రయల్ కోర్టులో ప్రాక్టీస్ చేసేటప్పుడు లేదు నేను హైకోర్టుకి వెళ్తున్నాను అంటే, ప్రాక్టీస్కి వెళ్ళిపోతున్నాను, షిఫ్ట్ చేస్తున్నాను అంటే చాలా మంది అడ్వకేట్లు, అంటే దాదాపుగా 9 సంవత్సరాల తర్వాత నేను ప్రాక్టీస్ షిఫ్ట్ చేస్తుంటే నా కొలీగ్ అడ్వకేట్స్ అందరూ కూడాను, అరే 9 సంవత్సరాలు ఇక్కడ ప్రాక్టీస్ పుటప్ చేసి ఫైలింగ్ ఉండి మళ్ళీ ఇప్పుడు వెళ్ళి కొత్తగా అక్కడ పెట్టుకుంటావా, ఏం పిచ్చిగాని లేదా, ఎందుకు వెళ్ళటము, అన్ని డిస్టర్బెన్సెస్ ఉంటాయి, ఓ ఫ్యామిలీ అంటూ ఏర్పడింది నీకు అన్న క్రమంలో నేను కూడదనుకొని హైదరాబాద్ ప్రాక్టీస్కి వెళ్ళాను. ఆ తర్వాత ఈ 1999లో హైకోర్టు ప్రాక్టీస్కి వెళ్ళాను. సో ప్రాక్టీస్ చేస్తున్న క్రమంలో ముందు హైకోర్టులో ప్రాక్టీస్ ఉండేది కాదు, ట్రయల్ కోర్ట్స్కే వెళ్ళి ట్రయల్ కోర్టు 9 ఏళ్ళు అలవాటు పడి వచ్చాను కాబట్టి ట్రయల్ కోర్టుకే వెళ్ళాను. ఆ క్రమంలో ఈ సెంట్రల్ యూనివర్సిటీ వాళ్ళు సైబర్ లాస్ కోర్స్ వేయటం. సరే సైబర్ లాస్ అంటే ఏంటో, ఫ్యూచర్ ఎంత ఉంటుందో దీనికి మనం తెలుసుకోవాల్సిన అవసరం ఉంది. దీని మీద ఏదో నేర్చేసుకుంటాము, దీనివల్ల ఏదో హైదరాబాదులో ఆ రోజున ఉన్న పరిస్థితుల్లో 2001లో అంత సాఫ్ట్వేర్ కూడా లేదు, జస్ట్ ఇట్ ఇస్ సాఫ్ట్వేర్ వస్తున్న పరిస్థితి. సో అవుట్ ఆఫ్ ఇంట్రెస్ట్, అవుట్ ఆఫ్ క్యూరియాసిటీ, ఒక సబ్జెక్టు ఒక కొత్త చట్టం కింద వచ్చింది కాబట్టి దాన్ని నేర్చుకుందాం అన్న ఇంట్రెస్ట్తో సైబర్ లాస్ నేర్చుకున్నానండి. ఆ సబ్జెక్ట్లో చేరాను. సెంట్రల్ యూనివర్సిటీ అంటే ఇదంతా చెప్తున్నానంటే నేనేదో చేశాను, దీన్ని నేను చెప్పుకోవడం కాదు. మనం ఎంత చెయ్యొచ్చు, మనం ఎంత నేర్చుకోవచ్చు, లీగల్గా ఉన్నటువంటి ఇదేంటి, అకాడమిక్గా మనం ఎంత ఛాన్స్ తీసుకోవచ్చు. అయితే ఇక్కడ స్టూడెంట్స్ కూడా ఉన్నారు కాబట్టి అటు మీకు వాళ్ళకి ఇది ఉపయోగపడుతుందనే ఉద్దేశంతోనే చెప్తున్నాను. అంటే ఆలోచించగలగాలి మనం, ఇది ఎవరో చెప్తే వచ్చేది కాదు. తెలుసుకుందాం ఒక కొత్త చట్టాన్ని, ఒక కొత్త చట్టం ఎన్నో వస్తున్నాయి, ఎన్నో చట్టాలు వస్తున్నాయి. అన్నిటికీ నేర్చుకోవాల్సిందంటే చదువుకుంటే చాలు, బట్ టెక్నికల్గా కొంచెం దాని బ్యాక్గ్రౌండ్లోకి వెళ్ళి చూద్దాము, ఆ సబ్జెక్ట్ గురించి తెలుసుకోవాల్సిన అవసరాన్ని గుర్తుంచుకొని తెలుసుకుందామని చేరి అది కంప్లీట్ చేశాను. 1 year డిప్లొమా ఇంట్రడ్యూస్ చేశారు వాళ్ళు. సో ఆల్ ఓవర్ ఇండియా సెలక్షన్ అది. సో దాంట్లో ప్రత్యేకించి డిస్టెన్స్ మోడ్ కాబట్టి 10 years ఎక్స్పీరియన్స్ క్రైటీరియాగా ఫిక్స్ చేస్తూ, అంటే ఎక్స్పీరియన్స్కి తర్వాత ఉండే మార్కులకి పర్సంటేజ్ ఇచ్చుకుంటూ వెళ్తారు. ఎవరికి ఎక్స్పీరియన్స్ ఎక్కువ ఉంటే వాళ్ళకి 10 marks అవుట్ ఆఫ్ 10, ఎక్స్పీరియన్స్కు 10 marks పడతాయి. అప్పుడు అడ్వకేట్గా నేను దాదాపుగా 12-13 సంవత్సరాల ఎక్స్పీరియన్స్ ఉంది. సో వాళ్ళు పెట్టినటువంటి కట్ ఆఫ్ 10 marksకి నేను ఎలిజిబుల్ అయినాను. సో ఆల్ ఓవర్ ఇండియా 80 మందిని సెలెక్ట్ చేస్తే 80 మందిలో నేను ఒకడిని. సో ఇది చాలా మందికి తెలియదు. ఏదో మనం అఫ్షియల్లో ప్రాక్టీస్ చేసి ఉన్నాము. అప్పుడు నాతో పాటు వచ్చిన వాళ్ళు కూడా కొంతమంది ట్రయల్ కోర్టు అడ్వకేట్స్ కూడా ఉన్నారండి. ఇదంతా నేనంటే హైదరాబాద్లో ఉండి ఉండొచ్చు, వాళ్ళు కూడా తెలుసుకొని వచ్చారు. వాళ్ళల్లో సెలెక్ట్ అయిన వాళ్ళు ఉన్నారు. ఇది 2001 సంగతి చెప్తున్నాను నేను. ఆ రోజే తెలుసుకొని దీని గురించి నేర్చుకోవాలన్నటువంటి ఒక ఆలోచనతో అది కంప్లీట్ చేశాను. తర్వాత ఎల్ఎల్ఎం చేయాలని అనిపించింది నాకు. మంచి అప్పుడు యాక్చువల్గా 91లో లా చేసినప్పటికీ దాదాపు 10 సంవత్సరాల గ్యాప్ తర్వాత మనం ఏం చేయగలం అని అనుకునేదానికన్నా కూడా ఆ 10 yearsలో మనము ఒక ఇష్యూని అంటే ఇది ప్రొఫెషనల్స్కి అనమాట, ఎస్పెషల్లీ ఎంత అనలిటికల్గా మనం ఇష్యూస్ని మనం ఆలోచించగలం, ఎంత దానికి సొల్యూషన్ ఎలా తీసుకురాగలం అన్నటువంటి ఆలోచన మనలో పెరుగుతుంది. కాబట్టి ఆ క్రమంలో చదవటం కూడా చాలా ఈజీ అవుతుంది. మనం లా చదివిన పరిస్థితి వేరు ఒక స్టూడెంట్గా, ఆ ఏజ్లో, ఆ ఏజ్ గ్రూప్లో. తర్వాత ఒక మెచ్యూరిటీ వచ్చిన తర్వాత ఓ సొసైటీలో మనం తిరుగుతూ, సొసైటీ గురించి మనం రిప్రజెంట్ చేస్తూ, సొసైటీ ఇష్యూస్ మీద మనం రిప్రజెంట్ చేస్తూ మనం ముందుకెళ్తున్న క్రమం. సో అలా చాలా మెచ్యూరిటీ అనిపించింది నాకు. ఎగ్జామ్ రాస్తున్నా కూడాను, ఆ రోజులో 10 సంవత్సరాల క్రితం ఒక ఎగ్జామ్ రాస్తున్నాము, ఇప్పుడు మళ్ళీ 10 సంవత్సరాల తర్వాత క్లాసులకు వచ్చాను. 10 సంవత్సరాల తర్వాత వాళ్ళు కాంటాక్ట్ క్లాసులు ప్రోగ్రామ్స్ పెడితే క్లాసులకు వెళ్ళాను. 10 సంవత్సరాల తర్వాత ఒక ఎగ్జామ్ కూర్చొని రాస్తున్నాను. ఒక డిఫరెంట్ ఫీలింగ్, అది తప్పగా అందరూ ఎంజాయ్ చేయొచ్చు ఆ ఫీలింగ్. సో ఆ తర్వాత ఎల్ఎల్ఎం చేశాను ఉస్మానియా యూనివర్సిటీ. ఎల్ఎల్ఎం చేద్దామని దాదాపు అప్పటికి నా లా అయిపోయి కూడా 91లో లా అయితే 2005లో ఎల్ఎల్ఎం కంప్లీట్ చేశాను. ఎల్ఎల్ఎం చేసిన తర్వాత మార్క్ లిస్ట్ తీసుకోవడానికి వెళ్తే, ఏమంటే మీరు పార్ట్ టైం పిహెచ్డి సీట్ వస్తుంది సార్, ఇఫ్ యూ ఆర్ ఇంట్రెస్టెడ్ టు జాయిన్ ఇన్ పిహెచ్డిని ఆ సూపరింటెండెంట్ మార్క్ లిస్ట్ ఇస్తూ నాకు చెప్పారు. ఓహో, అప్పటి వరకు నేను చేయాలని అనుకోలేదు, వాస్తవంగా ఆలోచన లేదు. కానీ తర్వాత కూడా ఆలోచించి పిహెచ్డి నాకు సేమ్ పిహెచ్డిలో కూడా సేమ్ ఇదే ఎక్స్పీరియన్స్ క్రైటీరియా ఉంటుంది. అలా పార్ట్ టైమర్స్లో ఆంధ్ర యూనివర్సిటీలో అప్పుడు కరెక్ట్ ఎగ్జాక్ట్గా బైఫర్కేషన్ ఇష్యూస్ జరుగుతూ ఉన్నాయి. ఉస్మానియాలో సీట్ కోసం అడిగితే ఇప్పటికే ఆంధ్ర వాళ్ళు ఎక్కువ ఉన్నారు, మా తెలంగాణ వాళ్ళకి ఆపర్చునిటీస్ రావట్లేదు, మీకు సీట్ ఇవ్వము అన్నారు. సో లక్కీగా నాకు ఆంధ్ర యూనివర్సిటీ, నేను ఆంధ్ర యూనివర్సిటీ అక్కడ విశాఖపట్నంలో చదివి ఉండటం, ఎన్విపి లా కాలేజ్ చేసి ఉండటం, అక్కడ ఉన్నటువంటి మాస్టర్లు పరిచయాలు, యూనివర్సిటీలో ఉన్న నాకు పరిచయాలు, నేను మళ్ళీ పిహెచ్డి వైపు వెళ్ళి పిహెచ్డి కూడా అందరూ చేసినట్టుగా అన్ని సబ్జెక్టులు చేయకుండా ఏదో కాన్స్టిట్యూషన్ లా, కాంట్రాక్ట్స్, సిఆర్పిసి, బెయిల్ అండ్ జైలు ఈ టాపిక్లు కాకుండా ఇంటలెక్చువల్ ప్రాపర్టీ రైట్స్, మేధో సంపత్తి హక్కుల చట్టం, అది అప్పుడు మనకి ఇప్పుడు లేటెస్ట్ గా వస్తున్నటువంటి ఓ సబ్జెక్ట్. ఇలా మనల్ని మనం అప్డేట్ చేసుకోవడానికి ఎంతో స్కోప్ ఉన్నటువంటి ఒక వృత్తి, నన్ను అడిగితే న్యాయవాద వృత్తి కన్నా ఆ లైన్లో ఇంకా ప్రత్యేకంగా ఇంకో వృత్తి నేను కనపడదని అనుకుంటా. అంటే ఆలోచిస్తే అకాడమిక్ లైన్లో ఉండే వాళ్ళకు పిహెచ్డి అవసరం, లాయర్గా పిహెచ్డి అవసరమా? అవసరం లేదు. ఎందుకంటే జడ్జిగానే చూసేది బిఏ ఎల్ఎల్బి, బీకామ్ బిఎల్ఎల్బి ఆర్ బిఎస్సి ఎల్ఎల్బి, పిహెచ్డితో సంబంధం లేదు. పిహెచ్డి ఉన్నా జడ్జి పోస్ట్ ఇవ్వాలని లేదు. అంటే నేను ఎంత ఎందుకు చెప్తున్నానంటే, నేను చేశానని కాదు, నేను చేయగలిగాను కాబట్టి మీరు చేయొచ్చు అని చెప్తున్నాను. మీరు ఎకడమిక్గా అంటే ఇక్కడ ఏదో వేరే ఎకడమిక్స్ గురించి చెప్పట్లేదు, లీగల్గా ఎన్నో అవకాశాలు ఇలాంటివే. జస్ట్ ఒక 3 days ప్రోగ్రామ్ ఎలా మీరు రాయగలిగారు, అలానే యంగ్స్టర్స్ ఉన్నారు, ఏజ్డ్ గురించి నేను చెప్పట్లేదు, ఒక ఏజ్ దాటిన వాళ్ళ గురించి నేను చెప్పట్లేదు, యంగ్స్టర్స్ ఉన్నారు. బీకామ్ బిఎల్ చదవగానే చదువు అయిపోయింది, ఏదో లా ప్రాక్టీస్కి వచ్చాం, మన ఊళ్ళో మన దీంట్లో మనం ప్రాక్టీస్ చేస్తున్నాం, ఏదో మా అమ్మ నాయన ఏవో ఒక ఇల్లు ఇచ్చారు, పెళ్లి చేశారు, ఇక్కడ ఏవో ఆస్తులు ఉన్నాయి, ఇక్కడ ఉండిపోదామని అనుకోకుండా, ట్రయల్ కోర్టు గురించి ఆలోచించకుండా, ఒక హైకోర్టు లాంటి ఒక ఉన్నత న్యాయస్థానం ఉంటుంది, అక్కడ కూడా ప్రాక్టీస్ చేయొచ్చు, అక్కడ కూడా ఇవన్నీ ఏంటంటే కష్టపడిన ఏది రాదండి, సిన్సియర్గా కష్టపడాలి. మరి అక్కడి నుంచి వచ్చి నేను ఎన్నో స్టాండింగ్ కౌన్సిల్స్ చేశాను, ఆ వచ్చినటువంటి అవకాశాలన్నీ అందిపుచ్చుకున్నాను. ఈరోజు మీ ముందు జడ్జిగా నిలబడి మీ ముందు మాట్లాడేదానికి నాకు అవకాశం ఇచ్చారు బార్ కౌన్సిల్ ఆఫ్ ఆంధ్రప్రదేశ్ చైర్మన్ గారు రామారావు గారు. ఎందుకంటే బహుశా నేను జడ్జిగా లేకపోతే నాకు ఈ అవకాశం రాదు, ఎందుకంటే మీలో ఒకడిని, బార్ కౌన్సిల్ మెంబర్ని కూడా కాను. సో మరి నాకు ఎలా ఆపర్చునిటీ వస్తుందండి మీ ముందు మాట్లాడేదానికి? అందరిలాగే మీలాగే కూర్చొని, మీలాగే సెషన్స్కి, మీలాగే ఇక్కడ ఈ సెషన్స్ అంటే నేను సెంట్రల్ గవర్నమెంట్ కౌన్సిల్గా ఉన్నప్పుడు సెంట్రల్ గవర్నమెంట్కి నేను జిఎస్టీకి, తర్వాత ఎన్ఫోర్స్మెంట్ డైరెక్టరేట్కి, డిఆర్ఐకి, వీటన్నిటికీ పీపీగా స్టాండింగ్ కౌన్సిల్గా చేశాను. ఆ క్రమంలో మినిస్ట్రీ ఆఫ్ లా వాళ్ళు మాకు ఆల్ ఓవర్ ఇండియా అని కాదు, ఆల్ ఓవర్ ఇండియా ఎప్పుడు జరగలేదండి, సౌత్ ఇండియా కాన్ఫరెన్సెస్ ఈ ప్యానల్ అడ్వకేట్స్కి ప్రత్యేకించి ఈ ఓరియంటేషన్ ప్రోగ్రామ్స్ పెడుతుండేవాళ్ళు. నేనున్న 10-12 సంవత్సరాల పీరియడ్లో బెంగళూరు, కేరళ, తర్వాత చెన్నై, ఈ 3 ప్రాంతాల్లో మా అందరికి 20 క్లాసులు ప్రోగ్రామ్స్ జరిగాయి. అయితే వీటన్నిటికి కూడా తప్పనిసరిగా మేమందరం హాజరయ్యేవాళ్ళం. ఎన్నో విషయాలు, ఎంతో మంది జడ్జెస్. అప్పుడే అనుకున్నాను, అప్పుడు కూడా మీలాగే విన్నాను, నాకంటూ అవకాశం వస్తే బాగుండు, నేను కూడా కొంత నేను నేర్చుకున్న దాన్ని చెప్పుకునేదానికి, అసలు ఎవరో నేర్చుకున్న దాన్ని చెప్పడం గురించి కాదు, నేను నేర్చుకున్నది ఏంటో. సో అలాగే నాకంటూ ఒక అవకాశం వచ్చింది, మీ ముందు నిలబడ్డాను. అందువల్ల నేను మీకు చెప్పేది ఏంటంటే, ఏదో అయిపోయింది, లాలో చేరాము అయిపోయింది అని కాకుండా, తర్వాత ముఖ్యంగా 30 సంవత్సరాలు అడ్వకేట్గా ఉండి సంవత్సరం 4 నెలలు న్యాయమూర్తిగా ఏంటి డిఫరెన్స్ అనేది కూడా మీతో షేర్ చేసుకోవాలనుకుంటున్నాను. ఎందుకంటే 30 ఏళ్ళ అనుభవం న్యాయవాదిగా, 1 సంవత్సరం న్యాయమూర్తిగా. నేను గమనించినంతలో ఇది గమనించిందేనా నేను, ఇట్స్ మై అబ్జర్వేషన్. హైకోర్టుకు వచ్చిన తర్వాత, హైకోర్టు ప్రాక్టీస్లో ఉన్న తర్వాత చాలా మందికి, అందరికీ కాదు, చాలా మందికి హైకోర్టు జడ్జి కావాలనే కోరుకుంటుంది అంతర్లీనంగా, పైకి ఎక్స్ప్రెస్ చేయలేకపోయినాను. సో ఆ క్రమంలో చాలా మంది దానికోసం ప్రయత్నాలు జరుగుతూ ఉంటాయి. ఆ ప్రయత్నాల్లో నాకంటూ వచ్చిన అవకాశం మెజారిటీ స్టేట్ గవర్నమెంట్ కౌన్సిల్స్గా రిప్రజెంట్ చేసిన వాళ్లకు, సెంట్రల్ గవర్నమెంట్ కౌన్సిల్స్గా రిప్రజెంట్ చేసిన వాళ్లకు ఈ అవకాశాలు ఎక్కువగా ఉంటాయి. నా వరకు నాకేం పొలిటికల్ బ్యాక్గ్రౌండ్ లేదు. ఉంటే అవకాశాలు జనరల్గా, అది అందరికీ తెలుసు, నేను ఎక్కువ డాష్ మీద అవన్నీ మాట్లాడకూడదు. స్టేట్ గవర్నమెంట్, సెంట్రల్ గవర్నమెంట్ కౌన్సిల్స్కి అవకాశాలు ఎక్కువ ఉంటాయి కాబట్టి ఆ క్రమంలో నేను సెంట్రల్ గవర్నమెంట్కి దాదాపు 16 సంవత్సరాల పాటు వేరియస్ డిపార్ట్మెంట్స్కి చేసిన క్రమం. అయితే నేను చేసిన క్రమంలో ఇక్కడే మనతో పాటు కూర్చొని ఒక న్యాయవాది మిత్రుడు సురేష్ కుమార్ ఉన్నారు. ఆయన అయితే మేమంతా అంటే నేను సీనియర్ మెంబర్గా ఉండేవాడిని, తను జూనియర్ మెంబర్గా ఉండేవాడు. నౌ హీజ్ అతని కెరీర్ని అతను మలుచుకుంటున్న పరిస్థితి. అంటే అలా అవకాశాలు రావగలగాలి, వాటిని అందిపుచ్చుకోవాలి. అందరిలాగే అందరూ అనుకోవచ్చు, ఈ రోజున ఇక్కడ కూర్చున్నటువంటి గంటా రామారావు గారు కావచ్చు, చిదంబరం గారు, రోజా శ్రీనివాసరావు గారు, రామిరెడ్డి గారు కావచ్చు, ఎవరైనాను వాళ్ళ వృత్తిలో, వాళ్ళ ప్రయత్నాల్లో వాళ్ళకు వాళ్ళుగా ముందుకు వచ్చారు. కానీ ఎవరో ముందుకు రాకపోతే ఎవరు ముందుకు నెట్టలేరండి. బార్ కౌన్సిల్ మెంబర్లుగా మేము ఉండాలి అని వాళ్ళు ముందుకు వచ్చారు. సరే, వచ్చిన వాళ్ళలో వీళ్ళు అని చెప్పి మీరు వడపోసి వాళ్ళని ఎన్నిక చేసుకున్నారు. ఆ క్రమంలో ప్రెసిడెంట్, చైర్మన్లు, ఆ పదవులు. సో అలా ఈ వచ్చినటువంటి అవకాశాలను అందరూ అందిపుచ్చుకోవాల్సినటువంటి అవసరాన్ని గుర్తించుకోవాలి. వారు మేము బార్ కౌన్సిల్ మెంబర్లుగా, చైర్మన్గా అవుతామని హైకోర్టు ప్రాక్టీస్కి రాలేదు. ఉన్న వాళ్ళందరూ హైకోర్టు అని నేను అన్ను, ట్రయల్ కోర్టులో కూడా ఉన్న అడ్వకేట్స్ ఉన్నారు. అలాగే నేను కూడా జడ్జి కావాలని రాలేదు. అవకాశాలు వచ్చాయి, అందిపుచ్చుకున్నారు, వచ్చారు. ఎవరు ఏ పదవుల్లో ఉన్నా అయితే దానికి తగ్గ శ్రమ కావాలి, దానికి తగ్గ కృషి చేయాలి, వీటన్నిటికి తగ్గ పేషెన్సీ ఉండాలి. ప్రతిదాన్ని రిసీవ్ చేసుకోగల పేషెన్సీ డెవలప్ కాదు. నో డౌట్ అడ్వకేట్ ప్రొఫెషనలిస్ట్కి ఎప్పుడూ పేషెన్సీ ఉంటుంది. ఎందుకంటే మరి ప్రొఫెషన్ అలా సాగుతూ ఉంటుంది. అది ఓవర్ నైట్ ప్రొఫెషన్ రాదు, ఓవర్ నైట్ ప్రొఫెషన్ పోవచ్చు, కానీ ఓవర్ నైట్ ప్రొఫెషన్ అయితే రాదు. అయితే ఓవర్ నైట్ ప్రొఫెషన్లు కూడా ఉంటాయండి. అవి ఎక్కువ క్రిమినల్ సైడ్ కనపడతాయి కానీ సివిల్ సైడ్ కనపడవు. అందుకే ఎక్కువ క్రిమినల్ సైడ్ ఎక్కువ మంది కాన్సన్ట్రేషన్ ఉంటుంది, సివిల్ మీద తక్కువ ఉంటుంది. సరే, ఇవన్నీ విషయాలను పక్కన పెడితే నేను ఇంతకన్నా ఎక్కువ వాటి గురించి మాట్లాడను. కానీ ఎందుకంటే దాదాపు 3 రోజులుగా మీరు మీ కుటుంబాలను వదిలి పూర్తిగా బార్ కౌన్సిల్ వారి ప్రోగ్రాంకి అంకితం అయిపోయి ఇక్కడ కేఎల్ యూనివర్సిటీలో 3 రోజులు సక్సెస్ఫుల్గా కార్యక్రమాన్ని చేసుకొని వెళ్తున్నారు. సో అందువల్ల ఈ కార్యక్రమాల గురించి నేను చెప్పే సూచన ఏంటంటే, సార్ రామారావు గారు, ఇప్పుడు మీరున్నారు, మిగతా మెంబర్స్ ఉన్నారు, ఇది నిజంగా యూనిక్ ప్రోగ్రాంగా నా వరకు నేను చెప్తానండి. ఎందుకంటే దాన్ని యూనిక్ అనడానికి కూడా దీనికి పూర్తి సహకారం ఇచ్చినటువంటి కేఎల్ యూనివర్సిటీ వాళ్ళకు కూడా ఇందులో భాగం ఉందని నేను అంటున్నాను. అందుకే యూనిక్ కాగలిగింది. ఇటువంటి ప్రోగ్రాం ఇంతవరకు బార్ అసోసియేషన్, బార్ కౌన్సిల్ పరంగా ఎప్పుడో జరిగినట్టుగా చెప్పారు, కానీ అది మనం బైఫర్కేషన్ అయిన తర్వాత మొట్టమొదటిసారి ఇటువంటి కార్యక్రమం జరపాలి అని ముందుకు రావడం బార్ కౌన్సిల్ నిజంగా గొప్ప విషయం. ఇటువంటి కార్యక్రమాలు ఎన్నో చేయాలి. అయితే ఇక్కడ ప్రోగ్రాంలో దాదాపు 3 రోజులు మీకు ప్రోగ్రాం పెట్టి చాలా హెక్టిక్గా డిఫరెంట్ సెషన్స్ నడిపిన పరిస్థితి. అయితే ఇంత హెక్టిక్గా కాకుండా ఇంకా నెంబర్ ఆఫ్ ప్రోగ్రామ్స్ చేస్తూ, అంటే ఇక్కడ మెయిన్ చూసిన వాటిల్లో అంతా రెగ్యులర్ ప్రోగ్రామ్సే ఉన్నాయండి. ఒకటే అడుగుతున్నారు, ఇక్కడే కాదు, ఈవెన్ మా జ్యుడిషియల్ అకాడమీలో కూడా అందరూ సిపిసి అంటారు, అందరూ సిఆర్పిసి అంటారు, ఎవిడెన్స్ అంటారు, ఇవే చెప్పుకుంటున్న పరిస్థితి. అయితే ఆ స్పెసిఫిక్ ట్రైనింగ్స్ ఆస్పెక్ట్లో వెళ్తున్న పరిస్థితి కాబట్టి ఆ సబ్జెక్ట్ చెప్తున్నారు. ఇక్కడ కూడా అన్ని ఓన్లీ ఇవన్నీ ఒక రకంగా చెప్పాలి అంటే ఓల్డ్ డిస్కషన్సే. ఇంకా న్యూ సబ్జెక్ట్స్ వాటన్నిటి మీద కూడా మంచి తరువు ఉన్నటువంటి ఈ రోజున అన్ని సబ్జెక్ట్స్లో ఆల్ ఓవర్ ఇండియా మంచి లెక్చర్స్ ఇవ్వగలిగినటువంటి డిఫరెంట్ ఫీల్డ్స్లో, ఎస్పెషల్లీ లీగల్లో, అదర్దాన్ కాదు, చాలా మంది ప్రొఫెసర్లు ఉన్నారు ఇక్కడ, వాళ్ళల్లో ఎమినెంట్ సబ్జెక్ట్ని చెప్పగలిగిన వాళ్ళు. ఇదంటే మనం సెక్షన్ ఆఫ్ లా ఎలా చెప్తాం, కొత్త సబ్జెక్టుల మీద కూడా ఇప్పుడు ఐటీ యాక్ట్ కావచ్చు, అలాగే సైబర్ లాస్ కానివ్వండి, ఇంటలెక్చువల్ ప్రాపర్టీస్ కానివ్వండి, వీటన్నిటి మీద కూడా చాలా అవేర్నెస్ వస్తున్న పరిస్థితి. వాటన్నిటికీ ఈ రోజున దాదాపు ఈ యూనివర్సిటీస్ వచ్చిన తర్వాత, ఈ 5 years కాన్సెప్ట్ వచ్చిన తర్వాత, మన 3 years కాన్సెప్ట్లో లిమిటెడ్ లాస్ నేర్చుకున్న పరిస్థితి. వీళ్ళు 5 years లో చాలా ఎగ్జాస్టివ్గా వెళ్తున్న క్రమం ఉన్నది కాబట్టి ఆ సబ్జెక్ట్స్ మీద కూడా స్పెషల్గా ఏదైనా సెమినార్స్ ఇలాంటివి కండక్ట్ చేస్తే మన ఎప్పుడే వీసీ గారు అన్నట్టు అటు స్టూడెంట్స్కి ఇటు అడ్వకేట్స్ కూడాను చాలా బాగుంటుందేమో అని ఆ విషయాన్ని కూడా ఆలోచించి ఇటువంటి ప్రోగ్రామ్స్, నెంబర్ ఆఫ్ ప్రోగ్రామ్స్ అన్ని చోట్ల అని కాదు, అన్ని చోట్ల ఓకే, సబ్జెక్ట్ వైజ్ రెగ్యులర్, మీ టాపిక్స్ వైజ్ మీ లోకల్లో అక్కడ ఆ కోర్టు దీని వరకు ఉండే సబ్జెక్టుల ప్రకారంగా ప్రోగ్రామింగ్ చేయటం వేరు. అలాంటిది ఇలాంటి ప్రోగ్రామ్స్ ఎస్పెషల్లీ ఒక సెంట్రలైజ్డ్ ప్లేస్లో అకామిడేట్ చేసినప్పుడు ఇంకొంచెం న్యూ సబ్జెక్ట్స్ కూడా చెప్తే ఇంకొంచెం, ఎందుకంటే ఇది చూశారు అంటే ఫస్ట్ రామారావు గారికి తెలీదు, బార్ కౌన్సిల్ మిగతా మెంబర్స్ కూడా ఇంత రెస్పాన్స్ ఇలా ఉంటుందని బహుశా ఎక్స్పెక్ట్ చేసి ఉంటారు. ఎందుకంటే ఆంధ్రప్రదేశ్లో మొట్టమొదటిసారి కంబైన్డ్ స్టేట్లో ఏం చేశారనేది కాదు, ఆంధ్రప్రదేశ్ మనం బైఫర్కేషన్ తర్వాత వచ్చిన తర్వాత మొట్టమొదటి ప్రోగ్రాంగా ఇది జరుగుతుంది, దీనికి ఇంత రెస్పాన్స్ వచ్చింది, ఈ రెస్పాన్స్ని ఇంకా పాజిటివ్గా ముందుకు తీసుకెళ్లాలని నేను మరీ బార్ కౌన్సిల్ వారికి నిర్దేశించుకుంటూ నాకు ఇచ్చినటువంటి అవకాశానికి మీ అందరికీ కూడా నా హృదయపూర్వక నమస్కారం తెలుసుకుంటూ సెలవు తీసుకుంటున్నాను.
Thank you, sir. We will consider your lordship's suggestions in shaping the future programs, and all the delegates also can imagine, because each journey taking into the lordship journey, you can also get a chance one day to be elevated to the High Court. Though you are practicing today in official, tomorrow you may migrate to the High Court. One good news is our inauguration, our residential program was inaugurated by the Honorable Chief Justice as Chief Justice of Andhra Pradesh. Now he is elevated as the Supreme Court Judge. So campus gave them that chance, lucky chance. So all of you also may not be justice and may not be chief justice, but you will get a better future. Thank you.
Thank you very much. This has been a very patient audience, and indeed, as I said, that graceful words need gracious ears. And this has been one of the wonderful audience, and we should start this session with giving applause to the audience itself. And after that, we quickly move to felicitation ceremony, and which is a formal and symbolic recognition of the presence that the GIS dignitaries bestowed to the occasion and of course to the place. So beginning first, I request Shri Ghantarama Rao, Chairman Bar Council of Andhra Pradesh, and Honorable Vice Chancellor Dr. G. Parthasarathy Verma, Garu KLF University, to felicitate Honorable Justice Dr. K. Manmanda Rao, Garu Chief Guest of the occasion and Judge High Court of Andhra Pradesh. Next, I request our Patron-in-Chief, Dr. G. Parthasarathy Verma, Vice Chancellor KLF University, to spare some moments to felicitate the members of the bar, starting with Sri Ramareddy Garu, Member, Bar Council of India. Next is Sri Chidambaram Kalinginiri Garu. Next, Sri Chandrasekhar Reddy V. Garu. Next is Sri Srinivasa Rao Vaja Garu. Next to Sri Subbarao Mupala Garu. And next is Sri Venkatarami Reddy Garu. Before we facilitate the last member of the series, it would be highly unjustified to give some words of gratitude to the linchpin of this program. I invite Dr. Kamasai, SVM, to speak.
Good evening, all. I am Dr. Kamasai, Associate Professor in Law. Feel it a great pleasure and privilege to present a brief sketch of profile Ghanta Ramarao Garu, the key person behind this 3 days residential orientation program for advocates of Andhra Pradesh. Ghanta Ramarao Garu, a humble man by appearance, came up to this level by sheer dint of hard work, patience, and perseverance. He is one with combination of so many features. A professional, organizer, and best human, lovable personality, darling of the bench as well as the bar. By sheer dint of his hard work and legal acumen, within no time, Ghanta Ramarao Garu has become very, very popular among the bar members as well as the bench. He is one who always stood for the cause of justice, for the upliftment and amelioration of the conditions of the young as well as all the members of the noble profession, namely the advocacy. As a legal magazine, Rights al Acquitar, the thing itself speaks, same up is more applicable to Ghanta Ramarao Garu. We are the live examples who have actually witnessed the way how he has conducted successfully the 3 days residential orientation program for the betterment of the young advocates. Humble by his appearance as well as in his words and action. Just some time back we heard repeatedly acknowledging that I did nothing, I could do all this with the greatest and unstinted cooperation of my brother committee members and all the members of the bar. Really, it is fortunate that today we have in this campus this program being conducted under the aegis of Ghanta Ramarao Garu. I take this opportunity to thank all, one and all, for giving me this opportunity for speaking about such a scintillating personality. Thank you, one and all. Jai Hind.
Now, I request the Bar Council to felicitate KLEF organizers. First, we have Professor Dr. N. Venkatram, Pro VC KLEF University. In his absence, I request Dr. V. Rajesh, Dean P&D, will receive the memento. Next, we have Dr. K. Subbarao, Registrar, KL University. In his absence, I request Dr. Hanumanta Rao, Dean, Student Affairs, will receive the memento. Now, I request Dr. M. Kishore Babu, Dean MHS. In his absence, Ms. Mautashi Thakur will receive the memento. Now I request Dr. V. Rajesh, Dean, Planning and Development, to adorn the chair to receive the memento. Now I request Dr. Srinath, Dean, Skilling. In his absence, Mr. Leela Krishna will receive the memento. I request Dr. Hanumanta Rao, Dean, Student Affairs, to come forward to receive his memento. Now, Dr. I. Pawan Kumar, Principal, College of Law, in his absence, I request Dr. Kam Sai will take the memento. Next, we have Dr. Shivakumar Garu, Associate Dean and Professor from ECE Department, to take the memento. Now I request Ms. G. Vijayasudha, HOD Law Department, to come forward to take her memento. I request Ms. Mautashi Thakur, Deputy HOD Law Department, to come onto the dais and receive her memento. Now I request Mr. Hari Garu, your yoga instructor, to come onto the dais to take the memento. I request M. Pujita Garu, yoga instructor, to come onto the dais to receive her memento. I request the law faculty to come onto the dais to take the memento. I request all the law faculty to come on to the dais to receive the memento. Mr. Muhammad Hamad Siddiqui, Ms. Chandani Chowdhury, Mrs. Nupur Agarwal, Dr. P. Sailaja, Dr. Kamsai SPM, Dr. Vinodini, Ms. Rishika Seal, Ms. Kaya Sarkar, Mr. Mudassir Rasul Vani, Mr. Leela Krishna, Mrs. Bhargavi, Mr. A.V. Subramaniam. I request all the law faculty to come on to the dais to receive the memento. Last but not the least, I'd like to invite all the students, my dearest friends, onto the dais to receive their memento. I request all the students of KLEF College of Law to come onto the dais to receive their memento. Okay. Hanuman. Now, I request C. Hanuman Rao and his friends to felicitate the chairman of Bar Council and the vice chancellor of KLEF.
ముఖ్యంగా అడ్వకేట్ సంబంధించి కేఎల్ యూనివర్సిటీ మేనేజ్మెంట్ వారు, బార్ కౌన్సిల్ ఆఫ్ ఏపీ అందరూ కూడా వారంతకు వారు సన్మానించుకుంటున్నారు తప్ప మన కోసం పెట్టిన ఈ ప్రోగ్రాంకు మనం ఎందుకు సత్కరించకూడదన్న ఆలోచనతో ఇమీడియట్ గా మార్నింగే పోయి ఒక 2 శాల్వాలు బొకేలు తెచ్చాం. మా కృతజ్ఞత మనం తెలియపరచాలి కాబట్టి ఇలాంటి ప్రోగ్రామ్స్ వాళ్ళపైన మరింత బాధ్యత పెంచాలి కాబట్టి మనందరి తరఫున వాళ్ళకు ఒక సత్కారం చేస్తే బాగుంటుందన్న ఆలోచనతో వేదికలో రిక్వెస్ట్ చేసి ఇస్తున్నాం. మనందరూ కూడా ఇది వినియోగించుకొని 500 మందిలో ఒక 5 మందికైనా లబ్ధి చేకూరితే ఆశయం నెరవేరుతుందని మరి ఈ కార్యక్రమాన్ని నిర్వహించినటువంటి ఏపీ బార్ కౌన్సిల్ చైర్మన్ అయినటువంటి గంటా రామారావు గారికి, అలాగే యూనివర్సిటీ మేనేజ్మెంట్ అందరికీ కూడా మా అడ్వకేట్స్ అందరి తరఫున ప్రత్యేకమైనటువంటి ధన్యవాదాలు తెలియపరచుకుంటున్నాం. థ్యాంక్ యూ వెరీ మచ్.
All these students are of first year only. first year, second semester students.
Okay, sir.
A big round of applause for the first year students. They have done a good job.
మనకు వస్తుంది ఆశ వచ్చింది దిగలేదా
Madam, by chance.
వైష్ణవి అలాగే అలాగే
Do you know your name? Your name, please.
Everybody will be interested to take from the hands of His Lordship. We have picked them. They have picked up each bundle one like that. They will be given, but no photograph with anybody. Anybody wanted to have photograph with His Lordship Manmadrao Garu? You will wait for some time. All of you, whoever is wanted, you have a selfie or photograph. But no photograph to the participants who are taking, because other people will feel differently. So afterwards, you can have snap with them.
I request yoga teacher Pujita Garu.
అమ్మా మీరు అడ్వకేట్స్ వస్తారు సైడ్ ఉన్న అమ్మకి అడ్వకేట్ పైకి వస్తారు కొంచెం సైడ్
చెప్పేసా
మీతో ఉండి పైకి.
I request P. Chandrika to come and collect your certificate from His Lordship Justice Manmadrao Garu. P. Chandrika. Next, Challaboyina Amulya, Lalla Akhila, Kavita Lakshmi CH, K. Sumati, P. Chandrika, Amulya, please come. CH Amulya. Chandrika Rale. P Chandrika. Itundu. Next, K Sumati. P Chandrika. Lel Akhila. Kavita Lakshmi CH. Adirama Krishnudu N. Adirama Krishnudu N. నీ పేరేంటమ్మా? లేళ్ళ అఖిల. అలా చంద్రశేఖర్ యాదవ్. చంద్రశేఖర్ ప్రణీత. అదిరామకృష్ణుడు ఎన్. ఆళ్ళ చంద్రశేఖర్ యాదవ్ అయిపోయాడు కదా. అల్లు హార్దిక్ రమణ. ఏదో సార్ వాళ్ళు ప్రణీత. మీ పేరు ఏదో ఇచ్చే తర్వాత తీసుకో. మారేది తీసేసి. అల్లు హార్దిక్ రమణ. ఎం చంద్రశేఖర్ బాబు. రమాదేవి. ఆమని ఉపేంద్ర. నో ప్లీజ్. భాషా బండే. ఆమని ఉపేంద్ర.